ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಸರ್ವರಿಗೂ ಶರಣಾರ್ಥಿಗಳು. ಕೇಲಿ ಮಹಾವಿದ್ಯಾಸಂಸ್ಥೆಯ ಸಪ್ತಋಷಿಗಳ ಪಾದಾವೃಂದಗಳಿಗೆ ನಮಸ್ಕರಿಸಿ ಈ ದಿನದ ಅಂತರ್ಜಾಲ ಆಧಾರಿತ ಕಾರ್ಯಾಗಾರವನ್ನು ಪ್ರಾರಂಭಿಸುತ್ತಿದ್ದೇವೆ. I request all the delegates for better audio experience, please use headphone and mute yourself on your entry. If in case the delegates get disconnected due to any reason, he or she can rejoin with the help of same link provided. Dear delegates, greetings and good wishes to you all on behalf of Keli SNC Parivar. We always wish for your good health and beautiful smile. Let's break the chain and stop the COVID-19 spread during this challenging time. We need to tell our loved ones that we care them a lot. We need to protect ourselves and all those around us by breaking the chain and preventing the spread of COVID-19 virus during this pandemic situation. Dear delegates, get vaccinated at first opportunity. A simple precautions will keep us all safe and secure. Now it's time to wake up and mask up. Maintain the proper social distance and break the chain. All the participants are requested to fill the feedback form which will be shared on second day of the workshop. Queries can be put only through the chat box with participant name and affiliation. All the queries will be answered at the end of each session. The host will ask queries on behalf of with your name and affiliation. At the end of workshop, we have planned for the group photo session. We request all the participants to stay tuned with us till the end and join us for photo session by switching on video. A warm good morning and cordial welcome to one and all present here. This is Dr. Pratibha KS, Head Department of Biotechnology. Distinguished inaugural speaker, invited guest speaker, principal, IQAC coordinator, heads of various departments, esteemed colleagues and delegates. Before proceeding towards today's virtual workshop on intellectual property rights and biotechnology in association with Karnataka State Council for Science and Technology, it's my great privilege and honor to introduce briefly about our institution, Keli Society and S. Nijlingappa College to today's speaker. Keli Society is one of the prestigious and largest educational society not only in India but also at a global level under the dynamic leadership of our Honorable Chairman Dr. Prabhakar B. Koreji Sir. The society proudly manages with elevated number of institutions up to 270 in various fields of education, including research in India and abroad with quality concept. Dear luminaries, our Keli Society's S. Nijlingappa College is affiliated to Bengaluru City University and accredited by NAC at A+ grade college with UGC State Component 1. Yes, Nijlingappa College is offering science, arts, commerce and various management courses for the benefit of students' fraternity. Yes, Nijlingappa College has been forefront in organizing many virtual programs for the benefit of academicians, research scholars, faculty and students. The main sole purpose of two-day virtual workshop on IPR and biotechnology is to focus on different aspects of intellectual property rights and also to ignite young energetic research mind towards recent trends in patenting related to biotechnology and also on overview of IPR, PGR, GATT, copyrights and protection and also related to biotechnology. Very shortly, we are entering to do MOU in association with KSCST to encourage our research mind. In this regard, today and tomorrow, Department of Biotechnology in association with Karnataka State Council for Science and Technology organized two-day virtual workshop on intellectual property rights and biotechnology. Today and tomorrow, we have invited eminent guest speaker who have highly enriched research knowledge towards IPR and biotechnology. We hope every young and energetic mind will utilize this rare opportunity for their benefit. Dear luminaries, now I would like to request Srimati Pallavi Prasad MS, Faculty, Department of Biotechnology, to proceed with today's inaugural ceremony of IPR and biotechnology, followed by technical session 1 and 2. Over to Srimati Pallavi Prasad. May I have Pallavi Prasad?
Yes, ma'am. Very good morning to one and all present here. On behalf of KLI's Yes Nijalingappa College, I, Pallavi Prasad, Assistant Professor, Department of Biotechnology, wish to extend a warm welcome to all the delegates, distinguished guest speakers, dear colleagues, and participants. I would like to thank you all for allocating time in your busy schedule to attend this IQAC initiated 2 days virtual workshop on intellectual property rights and biotechnology. To welcome is to show honor. To welcome is to establish integrity. I request Dr. Pratibha KS, Head, Department of Biotechnology, to formally welcome and introduce the chief guest of today's event, Mr. H. Hemant Kumar. Over to you, ma'am.
Thank you, Thank you, Srimati Pallavi. Ladies and gentlemen, it's a great privilege to welcome you all to today's workshop on IPR and biotechnology, organized by Department of Biotechnology in association with Karnataka State Council for Science and Technology, initiated by IQAC KLE Society's S. Nijalingappa College. Now, I would like to welcome today's chief guest and keynote speaker, Mr. H. Hemant Kumar Sir, Executive Secretary, KCST, on behalf of KLE Society's S. Nijalingappa College, management, principal, heads of various departments, esteemed colleagues, and also on my personal behalf, we welcome you, sir. Thank you for joining us, sir. Thank you. Now, I would like to welcome Honorable Principal Dr. Arun Kumar B. Sonapanawar, who is the driving force behind all our S. Nijalingappa College various programs. On behalf of Department of Biotechnology team and KLE SNC Parivar, we welcome you, sir.
Okay. Thank you, madam. Thank you very much.
We also welcome IQAC coordinator, heads of various departments, esteemed colleagues, delegates, and students to this virtual workshop on IPR and biotechnology. It's my great privilege and honor to introduce today's chief guest, inaugural speaker, keynote address of 2-day virtual workshop on intellectual property rights and biotechnology. Mr. H. Hemant Kumar, Executive Secretary, Karnataka State Council for Science and Technology. Sir joined the council in the year 1985 as a project engineer and has a postgraduate degree in civil engineering from Bengaluru University. He is currently investigating the Karnataka Natural Data Management Systems, that is NRDMS program, State Spatial Data Infrastructure Project, and various programs besides few other projects. To his accomplishments, Sir has published more than 25 journal and also conference papers and has delivered several keynote and technical talks at national and international platforms. Sir, he is a member of several expert, also technical committees, to name Committee of Department of Science and Technology, Government of India, National Biodiversity Authority, Department of Biotechnology, Kerala, Jammu and Kashmir, Odisha, Haryana, Government of Spatial Data Infrastructure, BBMP BDA, Ministry of Human Resource Development, MHRD, University of Agricultural Science, Bengaluru, Advanced Center for Integrated Water Resources Management, that is ACIWRM, ATRI, Karnataka Watershed Development Department, National Data Registry, BIS, many more. He has also head the Technology Innovation Support Center, that is TISC, along with the Patent Information Cell of KACST, and guides in conducting the IPR programs and development of IP ecosystem at the Council. His area of specialization includes geospatial technologies, spatial data infrastructure, alternate building technologies, watersheds, minor irrigation tanks, e-governments, many more. With this brief introduction, I present before you Mr. H. Hemant Kumar Sarji, Executive Secretary, Karnataka State Council for Science and Technology, to inaugurate today's session. Over to you, sir.
So good morning, all. It's a virtual inauguration, and I'd like to speak for 2 minutes regarding my council and what we do in the council in terms of promoting IPR. My council actually started way back in 1975. Basically, it's an initiative of Indian Institute of Science and the state government. And we were the first councils to be established in the country, apart from Punjab and Kerala. And we have a very good uh, support from both government of India and the state government. The objective of the council is to take the S&T interventions or innovations or S&T benefits to the state government, and whatever technologies that gets done in the R&D institutions, not necessarily from Indian Institute of Science, it could be any academic institutions across the state or the country, which benefits the people and also the state. For your understanding, you know that
Sir, we are unable to hear your voice, sir. Hemant, sir, we are unable to hear your voice.
to build an ecosystem in each and every institution in the state, so that some of the ideas or inventive ideas or innovations or the novelty that we have gets used by the people. Otherwise, having so many academic institutions, uh, and I personally believe that academic institutions are not just for teaching, it's also meant to do research and some sort of a development, and the benefit should reach the society. Otherwise, people do certainly think these many R&D institutions uh, should make someone's life better. That's the whole issue. So the council looks into that, and so far we have done exceedingly well in several areas, especially in terms of water, energy, technology, housing, and so on and so forth. Uh, my council is, headed by Chief Minister. That's the general body is headed by the Chief Minister. Apart from that, we have 3 presidents and 41 members. And we have an executive committee which guides and provides us advices on issues related to projects and program, and also provides vision and mandate for the council. So here I'd like to specifically mention that our executive committee is headed by Director in Digital Science. Normally, these are the posts which is occupied by a bureaucrat, but in our case, in our council, this is uh, from the beginning. It's Director in Digital Science heads our council, which makes us apart from other councils in terms of disseminating S&T inventions, innovations, technologies, and products and services. I think this is a wonderful concept, and we are blessed with the support of Indian Institute of Science and other R&D institutions, and the working atmosphere here in that council is wonderful, really good. In terms of somebody wants to make a difference, definitely can do. This is because of the academic touch and also the support from both the state and central government. And I would like to mention some of the projects that we do and some details about it. GIS and remote sensing is one area which we are doing from almost 3 decades now. And you may be aware that Google Maps have been exceedingly used by almost all of us, I think, in terms of finding locations or place of interest. But for developmental planning, we need beyond this place of interest or location. We need to know where exactly our resources are placed and what is the type of soil or land use, land cover, what exists on the land, and what type of crops and these, where are the forests, where are the nalas, where are the water resources, things like that. And 30 plus development departments in the state, around 18 to 20 departments definitely depends on maps for decision making. And our state is the first state to use technology for decision making. And even all the action plans that what you see from different departments, that is agriculture, horticulture, so on and so forth, they use our maps on a day-to-day basis, and it's embedded into the governance process. That's very much important. See, there are two kinds of usage. One, I use it when I like it, but when it's embedded into a process, that means technology is here to stay. And ours is the first state to embed geospatial governance in the state. This is a very, very good beginning for us. And we have many programs like water. I think you're all very well aware that our state, apart from Chennai, is the first state to bring a rainwater harvesting policy in 2009. We were very much part of it, and we drafted the RWH policy. And we've been working for almost 1.5 to 2 decades here. And we conduct a lot of programs to help and capacity build engineers, architects, and plumbers. So far, we have trained more than 2,000 plus plumbers and engineers. In fact, BWSSB mandates that anybody who wants to get a plumbing license in Bangalore has to go in for a mandatory participation in our RWH training program. So this is mandated. And mandated by law also, anybody who builds a house in Bangalore has to have a RWH installed. So far, 1.6 lakhs plus RWH have been installed in so many dwellings. And recently, there's also enforcement we have started. This is basically in association with Bangalore Water Supply and Sewage Board. And we also work on drinking water, water body restoration, and watershed development. We continuously and constantly support the state government in monitoring, evaluation, letting, and documentation of all these programs, especially water body restoration. Our reports have been used by the state government in Jalashakti Abhiyan and Narega programs. And next one is education. I think we've been supporting engineering students, projects, secondary engineering since 1977. This is the 44th year. So far, we have supported more than 13,500 projects, and many of them commercialized. And from past 3 years, we're also looking into getting patented for some of the projects which have been awarded. So this is one thing. And apart from that, we also support the faculty research projects. Suppose somebody, students and faculty does something, and it requires fine tuning and tweaking, and requires some amount of financial support to make it commercially viable. So to that extent, we also do that supporting. And from this year, we are doing that. And housing is also one area which we been engaged from 4 decades now. We have many alternatives in walling and roofing elements. We have more than 20 plus varieties of walling and roofing elements which can be used. And in Bangalore alone, more than 20,000 dwellings have been using our technology, which essentially means that close to 20,000 crores of investment gone in our using our technology. And mind you, all these dwellings, all these dwellings are individually owned. None of it is government owned. That means to say that 20,000 happy users, happy citizens, because of the work and the effort just gone in industrial science and my council. We also work on energy. That is current technology is bioenergy. That is blending of diesel and petrol. As you're all aware that these fossil fuels are going to end someday. So we have started using the non-edible oil seeds and ethanol for blending petrol and edible oil seeds for blending diesel. And we have a national policy on biotechnology 2018, which makes certain things mandatory. And we are helping the state through Karnataka Bioenergy Development. So that's one area. And we also do a lot of detailed project reports and things like that to government institutions and private institutions on establishment of solar 1 megawatt. We are doing it in few places. We provide detailed project reports for that, and many such programs. And I'd like to now come to the today's topic of IPR, and we've been in this field for almost 1.5 decades. And let's begin with what is IPR? IPR, protects your intellectual property, not necessarily patents. It could be many things. It could be copyrights, trademarks, designs, geographical indications, plant varieties, all of it which comes under IPR. But let's begin with patents. And what's a patent? To put it in a right way, patent is granted to any individual for an invention, which could be a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, the inventor has to totally disclose to the public during the filing of the patent application. What kind of protection does a patent offer? This is often asked by people. See, basically it protects you and gives you the exclusive right to prevent or stop others from commercially exploiting the patented inventions. If I have an idea and if it's not patented, others can use it because no one has claimed it. So patenting means I have claimed the innovation and patented it, filed, published, and granted patent. That means to say others can't exploit it unless I give them exclusive right to or license it to someone to use the patent or the idea. So in other words, patent protection means that an invention cannot be commercially made, used, distributed, imported, or sold by others without exclusive patent owner's consent. This is very, very much important. And generally people do ask, is it valid? Yes, it's valid in the country where you apply only. So it gives you the exclusive right in that country. However, now we have the PCT Act, which also gives you the exclusivity across many countries who have signed the PCT, that is patent treaty. How long does a patent last? Generally, it lasts for 20 years from the date of filing. Now, coming back to the PCT, that is Patent Cooperation Treaty, that's basically WIPO, the World Intellectual Property Organization. It's a body at the world level, which all of us are members, every country is a member. And this WIPO actually helps us, every country, every cells like us, to perform better. They provide you a lot of inputs. If you go to the WIPO website, I think you get lots and lots of information, and you get to know the patents filed in different areas, domains, and things like that, year-wise, subject-wise, domain-wise. I think there is lots of, I think some, those who are interested should definitely see that. And what does the Patent Cooperation Treaty means to all of us? It assists applicants in seeking patent protection internationally for their inventions and helps patent offices with their patenting granting decision and facilitates public access to a wealth of technical information related to those inventions. This is very much essential. And by filing the international patent application under the PCT, applicants can simultaneously seek protection for an invention in large number of countries. This is very, very important for us. And also the International Bureau interprets COVID-19 pandemic as falling under the PCT excuse of delays provisions and recommends modified practices to PCT offices. So what does KCST or the KCST IPR will do exactly here? Our job is to see that to create awareness on intellectual property rights, especially on patents, since we are coming from R&D institutions, and we do patent searches. I mean, what exactly is a patent search? See, suppose I have an idea. I would like to know now, does that idea has already been patented or filed or something like that? So I go for a prior art search, it's called a patent search, which enables and tells me similar kind of patents already been filed and gives me the claims that's been made. Now it's my job to not to repeat the claims already been made and make other claims which are not been done so far. This is very much essential for filing a patent application. So this we do it for all the faculty, students, startups, and industry. This is our job. So we do it well, and this is done by, we have an excellent advisors and subject experts with us, apart from the in-house expertise we have. Mr. Vivek, Mr. Nagarjun, they take care of most of the things. We have a very good support from our subject experts. They do this. And tomorrow they will be speaking to you as well. And today also, after the inaugural session, they will be speaking to you. And we guide the inventors in patenting the invention. And one of the important things that we do is setting up IP cell and each and every unit. This I would like to dwell it slightly further. I think KLE society definitely needs an IP cell. And this is very much essential, and this should happen at the earliest, not just for
Hemant sir, we are unable to hear you, sir.
dealt with to the students and faculty. And we do hope that these workshops or webinars or whatever we call it as will act as a boost for the faculty and students to at least start filing patents. Otherwise, this two-day program is not just for information, it is for action. I repeat, it is not just for information, it is for action. That is, we need to take this beyond this today. We should be making this part of the daily society's institution. And probably we extend slightly beyond that. We need to have an incubation center and also a startup if possible. The management agrees for it. And our cell also provides IPR protection for innovative projects, which are being carried out under the technical institutions, especially graduate and postgraduate engineering institutions. We also encourage interaction between academia and industries and bring them to a common platform so that commercialization of innovative projects could happen. These are basically the core objectives. And I think all of you, after setting up the cell, you should read the IPR policy of 2016. I think we have a lot many things in store for us compared to the policy that we had earlier. This new policy actually reduces the time taken for filing to granting from 5 to 7 years to 18 months to 34 months, something like that. That means to say that earlier we used to take a lot of time during the date of filing to granting. Now it's been reasonably reduced. So reduction in approval of trademark applications, the current average is 13 months to 1 month. I think it's a tremendous growth. Government is doing at its best to create a robust IP ecosystem in the state as well as in the country. I think all our institutions and including myself should support the initiatives of the government and see that the state and the government of India, the country as a whole should be a knowledge society. And we should be on par with the developing country. That's the whole issue in promoting IPR. And also conflict resolution, it's much better compared to earlier. And the policy review, I think it's happening now every 5 years with the stakeholders because it's always a dynamic situation in IPR. We need to change with the changing times. Otherwise, you cannot apply the old theories now. So there are a lot many things happening after the IPR policy that was brought in 2016. I think many more things will happen in the coming 2-3 years. And for information, I think KCST website has published many books, and it's also available on KCST website. You can also Google search for information about IPR, but you can also get many information from website. I think you just type KCST and you get to the homepage. From the homepage, you can reach the patent and you can download. It's both in the local language in Kannada as well as in English. I think this is a very good effort from our side, providing information a lot. But this is the present world. I think the Google search you get practically everything. But however, you can also refer us. And recently, what we have done is we have established Technology Innovation Support Center with the support of CTAM, that is Center for Intellectual Property Management. This is the 8th center. What it does is it's to be installed now. It provides access to online patent and non-patent resources. It provides access to industrial property related publications.
Hemant sir, we are unable to hear you, sir.
Never thought that they could file patents because they felt that patent is for somebody who is a very high IQ or somebody who is a geek or something. It's nothing like that. And now colleges are coming with 20 patents, 40. Some of them have 200 in mind. They have a target of 200 per year. I think Haley being the oldest college in the practically, in fact, I studied in Haley during 79, 80s. I think they should promote this IP culture because being the one of the oldest college like Sheshadipura and US colleges, I think they must, and hopefully this kind of things will help them in doing that. And don't worry, you don't have to be a great scientist for that. Your idea should be climbable and there should be some novelty in what you do. And it should not have been thought by someone else earlier. These are the prerequisites. And this kind of webinars and workshops will definitely help the institutions like Haley or any other college in Bangalore or any place in Karnataka as such to take patent in a big way in future. And to promote this IP culture in the institutions, we do conduct many programs today. We're conducting this program for today. Generally, IPR will be aimed at basic understanding of patents, designs, trademarks, copyrights, GIs. And if you go slightly deep into it, that is, if the faculty students want much more information, then there will be webinars or workshops for drafting patent procedures and filings, then designs, filing procedures and infringement cases, then trademarks, case studies, copyrights, plagiarism, infringement, research ethics, things like that. Geographical indications, that is importance and registration procedures. I think Karnataka is one of the highest number of GIs. I think Nanjangud, Bode, or what you can say, Chenpata, all this. And we also have slightly bigger programs, 3 days, 5 days, or 15 days. 10, 15 days is mostly for PRR search and things like that. And we do conduct faculty development programs, short-term training programs, and it could be infringement, startups. We do have a small program for IP for startups, commercialization, hands-on training on PRR search, quizzes, assignments, and certification. And I think all this and much we do on IP student projects every year, as I already told you, award about each 200 best projects, and we try to file at least few of them which are novel, try to file on behalf of them and see to it that it's commercialized. So now here the point is, we would like to see that the KLE has an IP cell and also promote this IP culture inside the college. If possible, they should have an incubation or a startup facilities within the college, because this is basically looking into making our self-sufficient, and the goals of the government of India is make in India, skill India, things like that. We need to support that. Instead of job seekers, I think the East institutions should produce students who are job givers. That is possible through I think we need more and more of job givers than job seekers. That could definitely happen through IPR. But if your college management and the principal, faculties, and all of them stick to this mantra, probably at some point of time, we'll have many more startups coming from your institutions. It will be a proud moment even for the marriage. And lastly, we have a good collaboration with many institutions, organizations, and starting from Department of Science and Technology, Government of India. Then as I told you, CPAM, that is Cell for Intellectual Property Rights Promotion and Management. Then we work with KCTU, Karnataka Council for Technological Upgradation. Then we work with VTPC, National Law School, KITS, Karnataka Innovation Technology Society, then NRDC. And recently, you may be aware that we have invited applications for the IP awards. That is for the best under this category of students, faculty, institutions, and startups. We shortlisted few of them. Probably this month we are honoring them for doing exceedingly well under different categories. And hopefully by next year, KLE College stands a good chance of getting an award by filing patent or by conducting a lot many programs like this and enthusing students and faculty the benefits of IPR and the promotion of IPR. I think at this time I would like to stop at this point. Back to the college, back to Madam. Please, my job is done. Yes.
Thank you very much, sir. The best leaders not only inspire us, but develop and empower us to lead with passion. I take this opportunity to welcome our respected principal, Dr. Arun Kumar B. Sonapanar, to develop the presidential remarks. Over to you, sir.
Thank you, Pallavi, sir. Good morning to all the dignitaries and all the participants who are actively going to participate and interact with the resource persons on this, the occasion of 2-day an interactive workshop on intellectual property right and biotechnology. So, paying my deep sense of the salutations to the Saptarshis of KLE Society, I feel very proud to have the program of a special program, I can say, that is on IPR. So, today's the chief guest and the keynote speaker, Mr. H. Hemant Kumar, Executive Secretary, Karnataka State Council for Science and Technology, and even the resource persons, they are going to participate in this program, and all the HODs and coordinators of various departments of the college, and the delegates from our college and even from other colleges, and my dear student friends. It's really a wonderful morning that we have arranged this program where our students are get a great expose to the new era, that is getting a patent for any kind of the innovations, whatever the young students or scientists or the faculty they are doing. So today's the chief guest, Mr. Hemant Kumar, he has elaborated how that the Karnataka State Council for Science and Technology has involved since from many years, more than 40 years, that council has involved to make the youngsters, especially the academicians, and to get a bridge, to make a bridge with the industries, and how to get protected our intellectual, the ideas or the properties. So it's a protective, the measurements for all the academicians or the researchers or the students who are willing to join the field of research. Sir, this is the very prestigious college of KLE Society, S. Najlingappa College, which is offering about 23 subjects. There are about 8 UG programs we are having, and 7 PG programs we are having, and including with the affiliation and recognition by the Bangalore City University. Very recently, sir, we are applied for UGC. No doubt, since in the entire history of the college, we utilized the number of funds from the different agencies like UGC or DST or the DBT. So all the funds we are used, a number of our faculty and even the students, they are engaged in the process of research, and they have produced a number of very good research papers with a very high impact factor. No doubt, we are all very good academician researchers, but the only one, the lacuna which was there since the 60 years of this history of the college, that is patenting. So I think probably you are now going to fulfill that our dream, that whatever academicians they are also thinking are willing to have a patent for their whatever the achievements or the progress they have got in their research. Recently, we have got a fund from UGC that is to develop a research capacity building of the teachers and also the human resource development. So it's a very good occasion, I can say, or a platform, I can say. So you are educating us how all we are already involved in the process of research, no doubt, but getting the patent for that, even it may be the service or maybe the protocol or maybe the product. So totally we are uneducated in this regard. So probably if you are, even I can say very openly, I invite you, sir, I request you, please give us a kind of collaboration so that together we can progress, we can march ahead, and definitely that will help us because we have about 3,500 student community in our college, and even we are very much associated with our sister institute, the College of Pharmacy, and even the other our sister institutions are also ready to join or to put hands together to work with you people and regarding this the process of the IPR. So especially in biotechnology, I can say, sir, in our KLE societies, more than 272 colleges are there. Very recently, our society has started the Cancer Research Center and Special Research Center on the biotechnology, and number of our faculty members are already working. And very recently, our Ayurveda college also got very good appreciation from the international academicians regarding some of the drugs they have invented. But still, our KL institutions, they have never got a chance to get patented. So definitely, sir, your council will help us, the KLA society. Even I request you to have a good collaboration with the entire KLA society. Definitely, we are there with you, and we'll put our all efforts to see that our researches will be get identified by in the national or international way. So this is a very great opportunity, and you have given a lot of information how your council is working, and you are really motivated. Even all our student friends are also, because students are learning only for the process of getting graduation, post graduation, or PhDs. But nobody thinks about that. How we can go for the patenting? How we can get a benefit out of that? So really, you have elaborated and you have emphasized a lot of ideas about this IPR. It was a great informative information for all of us, and even I also request my all the participant and student friends, the 2 days this the workshop what we are conducting, definitely that will help you, and please involve in that, and practically you can think about that, and take the help of the council and get the very good patents or the license for any kind of the achievements what you are doing in our academic ideas. So with this, I wish our organizing Department of Biotechnology and all other the student friends a great success for this the 2 days the workshop, and get out of this a very good positive response, and please implement these ideas in our the college system so that we can develop a ecosystem of the scientific temper research and the patenting. So for this getting an opportunity to participate in this program, that too with a very applicable technically applicable the session what Mr. Hemant Kumar he has given. So wonderful information, sir. Once again, I welcome you, and I wish you all the participants a great success for this 2 days interactive workshop. Thank you once again, one and all.
Thank you very much, sir. Gratitude is the most exquisite form of courtesy. Saying thank you is more than good manners. It is good spirituality. I now invite Dr. Savita V. Patil, Faculty, Department of Biotechnology, to propose the vote of thanks. Over to Dr. Savita.
Thank you. Good morning to one and all present here for the IQAC initiated 2 days virtual workshop on intellectual property rights and biotechnology on 4th and 5th August 2021. Today, I, Dr. Savita V. Patil, Assistant Professor, Department of Biotechnology, take the opportunity to put my gratitude into words on behalf of Department of Biotechnology, KLSNC, Bengaluru. I record my thanks to Almighty for enabling us to connect from far off distances in this tiring situation to participate in this webinar. We extend our sincere thanks to the invited chief guest and keynote speaker, Mr. H. Hemant Kumar, Executive Secretary, KSCST, for sharing his valuable thoughts on IPR, encouragement on applying for patents. Sir, we also thank you for throwing a light on KSCST's role as being a catalyst to promote innovation and patenting. We thank respected Principal Dr. Arun Kumar B. Sonappan, our KLE SNC, for his support on organizing this 2 days virtual workshop in association with KSCST Karnataka for his presidential remarks. We extend our gratitude to Dr. Mahananda B. Chittavadigi, IQAC coordinator, for her support. We thank wholeheartedly Dr. Pratibha KS, Head Department of Biotechnology, for her untiring involvement in organizing the webinar. We extend sincere thanks to various department heads, coordinators, and esteemed colleagues for making the inaugural ceremony a grand success. Also, we extend our sincere thanks to the delegates of different institutions all over the country who have registered and are attended in this webinar. Last but not the least, we thank our students for the enthusiastic involvement in this webinar. We thank each one of you for your presence. Thank you.
Thank you, ma'am.
1 second, Pallavi. Thank you, everyone. We request all the participants kindly switch on your video for 30 seconds. We'll just take a group photo. We request all the participants kindly switch on your video for just 30 seconds. We'll just take photograph. We'll take just a screenshot. Okay. Over to Pallavi. Thank you, one and all. Thank you, Hemant sir, for joining us and gracing this occasion. We are so blessed, sir, and we express our sincere thanks and gratitude on behalf of KLE Society's S. Nijalingappa management, sir. Thank you very much, sir.
Thank you, ma'am. With this, we wrap the inaugural session and move on to the technical session. I now request Dr. Savita V. Patil to welcome and introduce the speaker of the technical session 1, Dr. Sarasija Padmanabhan. Over to Savita, ma'am.
Good morning, one and all present. Good morning to one and all present here. For the IQAC initiated 2 days webinar on intellectual property rights and biotechnology on 4th and 5th August 2021, organized by Department of Biotechnology in association with Karnataka State Council for Sciences and Technology, KSCST, Bengaluru. Today, I, Dr. Savita V. Patil, Assistant Professor, Department of Biotechnology, take the opportunity to put my gratitude into words. I take the opportunity to welcome Dr. Sarasija Padmanabhan, a technical speaker for for technical session 1 for
May I have Dr. Savita, please? Dr. Savita?
Sorry. I'm glad to introduce today's resource person of Technical Session 1, Dr. Sarasija Padmanabhan, Patent Agent, Bengaluru, and Advisory Member of PIC, KSCST, a consultant, architect invent, BAS Law Firm, New Delhi. On behalf of KLE Society Management Principal, KLE's S. Nijalingappa College, Faculty of Department of Biotechnology, and on my behalf, I extend a warm welcome to Dr. Sarasija Padmanabhan. Dr. Sarsija Padmanabhan has the following educational credentials with a PhD degree in molecular biology from Shamyakin Institute of Bioorganic Chemistry and Molecular Biology of Russian Academy of Sciences, and a postdoctoral fellow from Molecular Biophysics Unit of IIC Bengaluru. She also has completed her Bachelor's of Law from Annamala University, Tamil Nadu. She is formally She brings over 18 years of incisive experience in IP space across diverse technologies, spanning pharmaceuticals, medical devices, molecular biology, organic chemistry, and material sciences, with special interest in green and smart innovations. Besides consulting for IP facilitations, firms like Architect Invent and BASC located in New Delhi and Cambridge, Sarasija ma'am involves herself passionately with the Indian government's mission of spreading IP awareness within the country. Under the aegis of Vishveshwaraya Trade Promotion Center, Bengaluru, and KSCST, she had participated in bringing awareness to numerous schools, colleges, and India's micro and small medium enterprise MSMEs. She had been a study winner in more than 3 crowdsourced study by Article 1 Partners, one of the largest patent search companies in the world. She also has won numerous in-scope awards. Recently, she participated as an individual contractor in a collaborative effort to prepare a guide of identified inventions in the public domain by WIPO and continues to participate in the efforts made by WIPO Match. Now, she is also a tutor in WIPO e-learning platform. Dear ma'am, Dr. Sarasija ma'am, this is the platform is yours. You can continue with the technical session 1.
Thank you so much. That was a really warm welcome. And I hope, you all benefit from this. I understand that the focus is biotechnology. And I would like to start with just a question. How many of you understand what the patenting scenario in biotechnology is? Can we patent a diagnostic method? Can we patent a research method in biotechnology in India? Since this, you have,
ಅವ್ರದ್ದು ವಾಯ್ಸ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
So can I have your views in the chat box, please? Or you can unmute yourself. Let's make it interactive so that, we discuss it instead of me giving a monologue on a perspective. Let us talk about it. So basically, does anybody want to tell me the answer to this? What does the law say? What does the IP law in India say about biotech? It would be nice if somebody gave me their, whatever it is, doesn't have to be 100% exact. It can be your opinion. whatever you think about it, you can tell me what it is. See, biotech is a very, very big umbrella term, right? It includes a whole lot, from medicine to horticulture, agriculture. It includes everything in its ambit. Now, what our law says, there is a section 3 in our Indian patent law, which tells us about things which cannot be patented. All right. So in that, the exclusions are, methods of agriculture, methods of horticulture. You cannot patent an animal. You cannot patent a living organism unless there is human intervention and you want to specifically show, that there is a particular hardware or a device involved. Methods of diagnosis, methods of treatment, therapeutic methods, surgery, all these things are not patentable in India. Specific exclusions from patenting. So how would you go about patenting when you are involved in biotech? Any answers? The topic is such, it cannot be a monologue. I would require interaction. So I would urge you to put your answers so that we can have a two-way, interaction, a conversation. So I have given you the starting point, section 3 of the Indian patent law, right? So in that, there are things which cannot be patented. In that, you have all these special exclusions. Okay, so why was this done and why was this made? The answer is very simple. These are very important for the common man, right? And you cannot be giving a monopoly on a therapeutic method. It needs to reach the common man, and that has to be available, right? Methods of agriculture, it has to be available. Exclusivity or a monopoly granted on these things makes the whole idea of patenting totally redundant. Patenting means, if you go etymologically, patent is the opposite of latent. Latent is that what is hidden, and patent is that what is laid open. And now what happens is, when in the process of filing, if you've heard about what the process of filing a patent is, you have to completely disclose what your invention is to the patent office. In exchange, what do you get from the patent office? You get 20 years. Now, these 20 years are very important. 20 years of exclusivity to operate, to work that application, whether granted or in the process of prosecution. 20 years from when? 20 years from the date of filing. So if the examination process, if that takes 4 years, those 4 years are cut, right? It doesn't mean that you will get 20 years from the date of grant. No, it is from the date of filing. So you can start operating and say patent pending. This is possible. Also, if your diagnosis, your method of diagnosis or therapy or whatever, it is included in a hardware, that is also patentable. Pharmaceutical compounds, these are patentable. Okay, now a method of therapy, a method of diagnosis, a way of doing surgery, a way of doing agriculture, a way of doing horticulture, these are not patentable subject matter. Animals, plants, these are not patentable subject matter. Now, can I have some answers, please? Why is, supposing you discover a new plant, why is that not patentable, please? Can I see some answers? Any answers? What do you think? Why are plants or animals which are discovered not patentable? No answers? Oh, okay, then I'll continue. But I would really appreciate if you interact. Natural resources are for all. That is a beautiful answer. That is very correct. But the actual reason is in the mechanism of patent filing, there are three filters. Those three filters being novelty, right? Inventive step and utility. Novelty meaning that it has to be something new. Now, if you are talking about a plant or an animal which is a natural resource and exists in nature, that means it's not new. You have discovered it. A discovery is not the same as an invention. Discovery means it already exists and you found it out. So a discovery is not patentable subject matter. It already exists in the prior art, right? So that is the reason why you cannot patent an animal or a plant that exists in nature and you find it. However, if you have made a plant or an organism, let us say by some manipulation, a genetic manipulation, right? And it brings about a change in the sequence in the DNA or something, and there is a different kind of an advantage in the crop. Now, would that be patentable subject matter? Would the filter of novelty, inventive step, and industrial applicability, will these filters, be properly passed by this invention? Any answers, please, in the chat box? Yes, that is correct. However, the national laws of the various countries, they always reign supreme, and each country has its own national law. The laws are not actually, they are trying to harmonize them, but they are not, they are different. Each country has its own circumstance, each country has its own way of dealing with intellectual property. They differ. All right. And patents are territorial in nature. Can you explain what does that mean? What does it mean when I say a patent is territorial in nature? Brilliant answer. So that is what it means. Wherever it is filed, that is where you will get the protection. Let us say you file for a patent in India. Will you get protection for it in Brazil? Will somebody in Brazil be able to use it? That is what I mean to ask. You have filed for patent protection in India. Would somebody? No, absolutely not, because the government in India will give you the protection, right? Brazil can make, use, or sell, but can they file for a patent in Brazil? The same invention. Can they file for a patent for the same invention? Any answers, please? No, they cannot. No, 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 absolutely not. The criteria of novelty is absolute, right? So the examiners have access to the best databases and best resources to find out whether your invention is new, whether it has been filed for in any other country. So the novelty filter, that will kill your application. So these are the three filters which you have to be very, very aware about, novelty, inventive step, and industrial applicability. Novelty you might pass. Now, what about inventive step? What does that mean? Any answers? Process. Okay. Any other answers? Okay, so inventive step is like that. Let us say an examiner looks at your invention and passes it through the novelty filter. Okay. Then he examines the literature that is available and sees there are two articles, let us say IEEE and chemical, let us say which one? Trends in biotechnology. Okay. And if you combine these two, it becomes very obvious. You can come up with this invention. But they have not been combined so far. But if you look at these two documents, it is very obvious that if you combine, you can combine it and you can get this result. So would there be an inventive step in such a case? would there be an inventive step in such a case? Not completely, absolutely, because anybody who is skilled in the art and is presented with these two documents would see that there is a possibility of combination, and that's what the examiner will do. He will put these two documents in front of you and ask you this question in the course of the patent prosecution, that these two documents exist in the prior art, and I believe that they can be combined and it kills the inventive step of your invention. So this is some of the little things which one comes across, and I'm just sharing it with you. The topic, today's topic, is not the basics of patenting, but you need to know a little bit before I can delve into the global scenario of biotech patents. So that's the reason I'm just giving you a little bit of prior background. Okay, so now let us look at what is available in patent databases. Patents are classified they are given a classification. Library books are classified. There are classes. Okay, so now I want you to see this um, um, website, which I am going to show you now. I will share with you here. Okay, so this is the one which I want you to look at. Are you able to see my my screen? Okay. Now you see, we are going to look at what is the global scenario of a biotech patent. So what do you do? Okay, I have selected medical technology over here. All right. So what countries do we want to look at? Okay. So if you want to look at India, then you just have to type India here. So let me just close all this. And I'll just put India here. Okay, and I am going to look for medical technology from all these. Okay, so now let us medical technology. I just need to go and do a chart type. I'll do this chart type line. So here is all the medical technologies you can see. Oh, all it says, it comes to all again. It's not kept India. Okay, so here is, again it went, but this is for India, definitely. So you see, can I put this here? How it's on the rise. I just want to. Yeah. So this is just one medical technology. You can also have analysis, biotechnology, right? So we put biotechnology and you do line medical technology, update chart. So we've got two now. In India, we are looking at medical technology and biotechnology. So we are looking at European patent applications which have been filed from India. Okay, so you see how it is going. So you've got biotech. 2017 onwards, there seems to be a little bit of a plateau, and we're looking only at applications. You want to look at grants, it would be different. So basically, for you to see how one arrives at all this data, these things are available. This I'm showing you at the European Patent Office. All right. So now here we are looking at grants. You can see there has been a dip in 2019 when it came to biotech. Can you tell me what is the reason for the dip? Anybody can tell me what would be the reason for the dip in biotech? Excellent. COVID in 2019. And how has there been an increase in the medical technology? You see a rise. What is the reason in the, you can see it's a mirror kind of a thing. Why is that? The reason is the same.
ಗೊತ್ತಾಯ್ತು ಆದ್ರೆ ಅದಕ್ಕೆ ಇನ್ನೂ ಮೆಡಿಕಲ್
Absolutely the same reason, right? You cannot have research in biotechnology, but you need to have some kind of an applied thing because we had to apply it to the time. So medical technology was on the rise. So these are some of the things I wanted to share with you. Now I want to show you my slide. Okay, so now how do I go next? Enter. Okay, so here I'm looking at the global scenario now. There is a class called C12N508. This is a classification. This is basically for biology and tissues and cells. I wanted to take this because this classification I chose because we are talking about biotechnology. Now you see, this one, it poses very significant bioethical questions. Now, the patterns of ownerships and ways such patents are used are likely to be subject to special scrutiny from a bioethics point of view, right? So now you see in most countries, there was some kind of a peak in 2012 and a sudden dip after that. I haven't got the data. It can be easily sourced from any of the databases, but the screen is only so much and I wanted to show you the entire thing. This is an international patent activity chart. So why do you think this dip happened? Anybody? Any answers as to why this dip happened? Changes in laws, exactly that. It affects research, you see. So let me go back. Here in 2019, you can see there is again a little bit of a hump, right? In Europe, a little bit of an increase. And then again, it goes down. Now, I'll tell you, I'll read it out to you so that you have all the details. You see, biotech patenting in 2019, after a small increase in 2018, saw about a 15% uptick in biotech. Stanford, MIT, they were the most active standalone universities for biotech patent. Harvard leading the way with the most cited patents. However, the University of Tokyo also scored well as a result of patents related to regulatory T-cell research. Yale re-entered the top 20 for the first time since 2014, thanks to older patent finally clearing the US Patent Trademark Office. The Mayo Clinic made its first appearance amongst the top 5 research institutions on the strength of new patents focusing on nanobody antibody complexes. Seoul National University joined the list. United States has led the way in overall patenting, etc. So these are all the things. However, let us go back to this. Why did this dip happen and what was the change in law? That is what we want to address right now. Can I see the Okay, so I'll tell. So what happened was, this was the time when, the patenting of genes and DNA and all these became an ethical question. In 2012, this was in very much in the press and media till 2013, 2014. And most countries, they said, like cloning, you cannot have patents for that. Genes, altered genes, you cannot have. And all this kind of, a lot of questioning and there is a lot of literature on that. That just brought the entire thing down. You see how high it had reached and how it came crashing down. Now with COVID, there was a little bit of a pickup. And what was the issued research biotech patents by country in 2019? You can see there is a comparison between the European Patent Office and the USPTO. Of course, the United States is the leader. EPO is much less, but you can see the comparison. There is a huge disparity between the United States, patenting in the United States by various countries. So a Japanese company filing in the United States or in Europe. So Europe was not giving biotech patents. Basically, there is a huge stringency in the European patent laws regarding bioethics and whether you can, genes and clones and things like that can happen or not. Okay, so this is basically what this is showing. Countries do research like Japan, France, Korea, China, United Kingdom, Germany, all these have their research, but where it is filed, USPTO filings are the maximum. And then who are the 10 most active non-US universities by number of issued biotech patents? You can see there is a comparison. University of Tokyo ranking very high. Okay. And here there is the competitive impact by country of inventors. Denmark and Switzerland, they rank first for both biotech and all patents. All right. So this is how the global scenario of biotech patents is. And now this is the innovation index. All right. So GII ranks 1 to 5. You can see United States, Canada, and all that. India, today it is ranking 48. Okay. China is at 17. The biggest blob you can see over there is, you can see in 2020, there is US, Canada, Germany, that is the biggest one. And the technology relevance, that is the chart below that. The bubble size represents the patent asset index of the respective portfolios. Patent asset index means one technology has many patents to cover it. It doesn't, one technology is not limited to one patent. To make a technology, you have to have a portfolio, and that entire portfolio makes a patent asset index.
Ma'am, we can't hear you, ma'am.
Further, strengthened by patentable subject matter, enablement, and morality. Okay, so now this is the other question that the Indian Patent Office very, very often raises about biotech patents. All right, now just to refresh and to know that you are with me, can you tell me where in our Indian law do we deal with patentable subject matter? Any answers, please? Where in our laws do we deal with patentable subject matter? Nobody's answering. We need to know, where do we deal with patentable subject matter? Any answers? Under what sections do we deal with patentable subject matter? No, okay, it's section 3 of our Indian Patents Act. Okay, so there is specific exclusions to patentability, and there they say which are the points which cannot be patentable. What do we mean by industrial applicability? how well it suits. Okay. Okay. So basically, whether it meets a need in the country, whether there is a need for what you are giving to the patent office. And what is the criterion of novelty? What is the criterion of novelty? Novelty is absolute. The requirement is absolute new idea upgradation. Yes, that is absolutely correct. The requirement is absolute. It has to be new, and not new just in your country. It is new anywhere in the world. So let us say you are making, let us say you're making a tire or you're making a wheel. Okay, and you are talking about a wheel, then would the prior art, right, which is relevant to the wheel, like let us say there is a cave painting of a wheel, would that constitute prior art concerning the wheel you are submitting to the patent office? It would. It would, depending on how far you have gone from that initial wheel. Okay, so you have to keep in mind that any kind of recorded evidence that anything related to that what you're presenting to the patent office existed, it has to be, you have to acknowledge that. It can even be a comic strip. It can even be a newspaper article. These are all prior art, and it can kill your novelty. Inventive step. We dealt with inventive step. Let us just quickly refresh. What is inventive step? Inventive step towards novelty. Not quite. You clear the novelty filter first, and then you come to the inventive step filter. You might have cleared the novelty, but the examiner can pose a question on the inventive step to you. Why? Because there might be two different evidences which when combined, yes, which when combined propose a new step. Now, whether that would be obvious to somebody who is in the same domain as you or not, is that what would be questioned. What is enablement? What do you think is enablement? Not quite accessibility. When you write your patent document, you have to write it in such a way that anybody who belongs to your field, when tries to reproduce it, gets the result that you claim. So they are going to test it. It has to be testable. Basically, whatever you're saying, if it is done the way you say it has to be done, it should yield the result. Yes, it can be applied. Basically, that is what it means. So you are going to write out your invention in such a way that anybody else who is from the same field can reproduce it and get the results that you claim. Okay, so that is one of the most important requirements of patent process. Yes, it means reproducibility. That is what enablement means. Exactly right. The last thing is, it's a little ambiguous, which is morality. Now, morality being like, for example, using live human tissue for making a stem cell or something like that, that can create a controversy.
We can't hear you, ma'am. Sarasija, ma'am, we can't hear you.
Things which are related to morality, they can, make or break uh, a patent go through with special reference to biotech. All right. Why am I not going next? Okay. Okay, so now let us look at in India, what are the pharmaceuticals is another huge segment of biotechnology, and we do well. India does well with this. You can see where we have, this is just data between 2016 to 2018. I've not included 2019 because there many things have been happening since 2019. As we already saw, due to the COVID pandemic, things are a little difficult, but we will have all the data pretty soon. Okay, so now you look as of 2018, that is 2016 to 2018, CSIR was a top filer for pharma patents, followed by Dr. Reddy's Laboratories, ITC, MSN Labs, Lupin, Wockhardt, Cadila, Sun Pharma, Mylan, DRDO. So these, this is very heartening to see how much work happens in the pharma industries. And what kind of technologies in pharmaceuticals? Drug combinations. I've given the patent classes, so don't worry about that now here. This is we just look at what are the top technologies in pharmaceuticals, because the thrust is on India and biotech. Drug combinations, anti-inflammatory drugs, plant extracts. Plant extracts, I think, would be of interest to you, because in the earlier talk given by your institution, it was mentioned that plant extracts and Ayurveda figure very prominently in your curricula. So here you see plant extracts in India as well has a very prominent position. Multi-drug resistant cancer treatment. You see here it is treatment, but it is pharma. That means it's probably a drug, not a method of treatment. So multi-drug resistant. So here it is herbal composition. So you have plant extracts, herbal compositions, two of those things which probably would be of interest to you. This is the entire pharma thing. And also
Sarasija, ma'am, again, we can't hear you, ma'am.
basically because it has a whole number of institutions under its umbrella, right? And a whole lot of biotech, medical, life science based patents are being filed. And ITC, ICAR, agriculture research, Colgate Palmolive, DRDO, Department of Biotechnology, Procter and Gamble, you see, big filer, Dr. Reddy's Laboratory. This is food, water, and biotechnology. Amity University is coming up. IIT Bombay is very prominent in food, water, and biotechnology. So this is something to keep in mind. And these are the assignees. And what are the top technologies in food, water? Testing and detection of microbes. So this is not health related, but testing, detection of microbes, you see. Health, low calorie foods, functional foods, nutraceuticals, all of that comes under the second heading. Purification of water, lots of technologies. Microbiology, lab procedures, cosmetic preparations, you see. These are all biotech related domains, and we have the technologies which are related. And this time period is between 2016 and 2018. And Bharat Biotech, I have put the filing trends here just so that, just for an interest, let's just to see whether we can sort of relate to what their filing trend was, since the co-vaccine has come from there, you see, and it has really peaked in 2018, 2019. You see the topmost thing over there. Okay, I think, and what are the technologies? It has viral antigens, reoviridae, salmonella, vaccines, growth factors, regulators, Bharat Biotech, just for interest. And now we come to something where we have to apply our minds to. Okay, this is the business model canvas and how you can benefit with, from patents that are happening all over the world. So here we have Mr. Mutua, who has a finished market-ready piezoelectric shoe phone charger. Okay, it is a pressure-based mobile phone charger, and the device is installed inside a shoe's inner sole. What happens when you walk? The motion exerts pressure on the piezoelectric crystal, and you are able to charge it. So there is a patent filed in the United States, and it was not filed in Kenya. So can Mr. Mutua use this technology in Kenya? That is my question to you. Patents are territorial in nature. Very good. So absolutely correct. The answer is yes. And that's what he did. So why am I telling you this? See, we are a growing nation. We are a developing nation. Resources are always a question, there is a crunch about, you need finance for filing, you need finance for conducting research, you need finance for marketing, and you need to prioritize how you want to use intellectual property. A lot of technology is available out there, and not everything needs to be filed in India. Now, if somebody has not filed in India and that technology exists, can you make use or sell it? Can I have an answer, please? Can I have an answer, please? If a technology exists but has not been filed in India, can you make use or sell it in India? Absolutely, yes. Very good. You can, because it has not been protected in India and it is in the public domain for you, right? So you can. So we are a growing country and we need to know the rules of the game. If we play the game right, we will be on top of it. So that's why I'm telling you this. Patenting is one thing and using patents is another thing. If we combine the two sensibly, that is where you can get your progress, right? So here, this is what Mr. Mutua does. He picks up that patent information in Kenya and makes his shoe phone charger, right? And how does he do it? He finds key partners, activities, resources, cost structures, all these things he needs to fill. And he fills all these things up because the technology is already existing and he has a going startup business, all right, from a patent that exists, not filed by him, filed somewhere, but of use to him in his country, all right. Now we take an example for COVID-19. Okay, there exists a United States patent, okay, and it is a mask which has a filter layer, and it is in these COVID times it is useful. We have to look at it from Indian point of view. Now look at it, it is being filed in the United States, all right. Now can we use the business model canvas with India in mind? Any answers? It has been filed only in the US. Okay, can we use it in India? Yes, yes, very good. It can be. Right, another example. So this is an application which is an antiviral formulation, nanomaterials and nanoparticles, okay? And we are looking at the application in the context of the business model. You look at its legal status, it has been filed in 2006 in Great Britain. And then Europe, US, Korea, China, it has a PCT application, WO, Japan, China, and JPUS. So WO is a PCT application which can designate a number of countries. Now you have to keep this in mind and look at this patent, right? And can the business model canvas be used with India in mind? Answers, please. There is a PCT application there. Keep that in mind and give me your answer. India is not excluded from the WO. India is included in the WO, absolutely included. What happens then? Then you have to check for what is its status in India. So if you look at the Indian Patent Office, you see that it has been filed under this application number. The title is virucidal materials, and you look at what has happened. This is the entire thing. You go to the Indian patent database called InPass. It's available, not very user friendly, but you can get information. So you see the last thing that has happened is in 2008 examiner's report, which has been uploaded to 2016. So the last activity on this database is 2016. So you go into that further, and what do you see? You see that he's saying, the examiner is saying that there is an application from Japan which discloses particles comprising zinc, titanium, reducing virus transmission, etc., and that it does not meet the novelty. You are requested to comply with the objections by filing your reply by 2014. Okay, and there has been some activity. We saw that in the previous one. When I went back and checked, nothing has happened, right? So it looks like they have not proceeded with the filing in India. All right. So then if they have not proceeded with the filing in India and they have abandoned the filing in India, can you make use of the technology? Yes, you can. All you need to do is confirm, right? You can. All you need to do is you need to confirm with the Indian Patent Office that it really is abandoned and that they are not seeking protection in India. And you complete your business model canvas, get all your key partners, activities, resources, right? And make sure that it is cost effective, easy to use, safe to use. Who would be the customer segments? Doctors, nurses, patients, etc. Design your cost structure and understand what your revenue streams will be, and you would be ready to go. So basically, this is all I have to share with you, and I would end my talk here. Any questions now?
Thank you, ma'am. Now the platform is open for Q&A session. The participants can put a question in the chat box, and the speaker can answer the questions.
I think there aren't any questions.
Students, you can ask your questions. You can directly ask instead of typing in chat box. Ma'am, we have one question from a student.
Yeah.
Yeah. How about ethical issues in relation to plants?
Yeah, so this is the thing. If it already exists, right? If it already exists, it cannot be patent. Also territory, where it does belong. We've had a lot of ethical questions regarding plants, for example, the basmati, right? And then the neem, all these things which were connected to indigenous knowledge and things like that. They were all resolved based on the fact that these were all existing prior to the patenting process. So which are the ethical biopiracy type of questions? This was raised, right? Like we had neem, and then what else did we have? Haldi. The turmeric case is a very famous one. So these things are also related to biotech. And now we have a
Okay, thank you, ma'am. Ma'am, we have a question from the. Excuse me, ma'am.
requirement. There is a requirement in the patenting process which says that you have to deposit that plant material or biological material which you have used. So these are the couple of things how we deal with biopiracy and ethical issues related to material from a particular territory.
Thank you, ma'am. There's one more query from the faculty. With respect to plant extracts, as you mentioned, we have many patents. Will a process of extraction or the whole mechanism of biosynthesis mechanism will be involved in the patenting?
So the biosynthesis, if it is something which already exists, is not patentable subject matter because it already exists in the plant. But if the extraction, the process of extraction is new, right, and not already known, then that is patentable subject matter. For example, iron ore, right? Iron already exists in nature. The ore already exists in nature. However, and if you extract iron from the iron ore, you will get which is new, then that is patentable subject matter.
Okay. I have one more, my personal question. Is the same process implemented for patenting with respect to COVID-19 kits and all? Because it is very short time. Is there any other process, ma'am?
The patent prosecution is the same process. You will file a patent application. There will be a formal scrutiny of your patent application. Then there will be a prior art search. Then there will be a substantive.
Okay. Yeah. Any more questions from the participants?
Okay. How do I make it big?
Ma'am, one more question we have. Yeah. How about, is there any patent being filed for disposing the masks and other things which are related to COVID-19 now?
I'm sure there are, but it's a question of patent search. You have to do a patent search and look at what is being filed now, and because it's an absolute need. It's a beautiful question,
Yes.
and disposal is a huge issue. So you just have to go to the patent databases and look. There's a lot more that I can tell you. If you have the time, we can go to the patent scope database, and I can show you how to do it, but we are short of time. What I would suggest is go to the patent scope database. In that, there are sections, like transport, for example, ambulances and things like that, disinfection, then kits, diagnostic kits, treatments. Whole classes have been allocated. So if you go and do a proper prior art search, you should be fine.
That's good, ma'am. We will do it. Thank you for the information.
No problem at all. Always here and ready to help.
Yeah, thank you, ma'am, for the insight into the patents and how to go ahead with it, and the worldwide scenario, how the things are happening with relation to pharmaceuticals and biotechnology. Thank you very much, ma'am.
I just hope you find it useful, and the links that I have shown, please go there and take a look at it yourself. Whatever is of interest, probe it, And I'm sure if you do your own research, it will be more satisfactory than my trying to tell you. And today it is X, tomorrow it will change. This is a very dynamic field. It doesn't stay static, it will keep changing. So you have to go and you have to look at it. But
Yes, yes, ma'am. Thank you so much, ma'am. Over to Pallavi, ma'am.
Thank you, ma'am. I now request Srimati Trupti A. Vadakeri, Faculty, Department of Biotechnology, to welcome and introduce our next technical speaker of the day, Dr. Brinda Verma. Over to Srimati Trupti.
Warm greetings to everyone. I feel it is my great honor to introduce our next speaker, Ms. Brinda K. Verma, IP Advocate, Patent Agent, Bengaluru, and Managing Partner, Ekam Legal Abroad Law Firm. On behalf of KLE Society Management, Principal KLEs is Nijalingappa College, Head Department of Biotechnology, Heads of various departments, Faculty, Department of Biotechnology, I extend warm welcome to Ms. Brinda K. Verma. She is a dynamic lady with eminent role in the society. Ms. Brinda K. Verma holds a MSc degree in biochemistry and biotechnology from Bangalore University. She has a LLB degree from Bangalore University and a postgraduate degree in business administration from Symbiosis Pune. She is a registered patent agent and qualified to practice before Indian Patent Office. Ms. Brinda K. Verma is an advocate and patent attorney with over a decade of experience in dealing with IPRs, including patents and trademarks. She is associated with research wings of several institutes to frame their IPR strategies. In the managing a partner of Ekam Legal Abroad, a law firm based out of Bangalore, which handles and assists business including startups in various legal matters from inception of a company to protecting their IP. Her primary focus areas are patent drafting and prosecution, IP litigation, training researchers of various educational institutes, and startups on various aspects of patent, trademark, and copyright related areas. She was associated with Intellectual Property Cell of IISc for over 5 years as an IP executive. She handled technology transfer deals for IISc inventions, drafting and negotiating research and license agreements, preparing, filing, and prosecuting patent design and copyright applications, and has managed outside counsels. She was instrumental in transforming the IP cell of IISc from a service facilitator to a service provider. She was involved in handling several research-based collaborations with industries. She worked towards pursuing a systematic, mutually beneficial engagement with research-based national and international companies in order to encourage them to partner with IIS. Thank you, everyone. Now, I request respected Brinda ma'am to enlighten us with your presentation. Over to you, Brinda ma'am. Ma'am, we cannot hear you, ma'am. Please unmute yourself.
Can you all hear me now? Am I audible?
Yes, ma'am.
Thank you very much, Dr. Trupti, and thank you, Kaylee and KCST for giving me this opportunity. I think before I start, I would just want to know how much time do I have to complete my session? Is it 1 hour or a little more than 1 hour?
1 hour, ma'am, but you can take as much you want.
As much, you should never give the description to the speakers.
It's 1 hour, ma'am.
Thank you. And after that wonderful session from Dr. Sarsija, I think I will, continue on the perspective of Indian context, basically of what does the Indian patent law talk about the biotechnology invention. So this would be the objective here for the next 1 hour. So I would be covering the following aspects. A little introduction about the patents, and of course you've already learned about it, but yeah, I think it's always important to start with that. A brief history of how the biotechnology patents have been developing in India. Patentability criteria from the international perspective, you've already learned that. So I will focus from the Indian side. Patentable subject matter and provisions relevant to the biotech industry. I also know that there might be an overlap, between what has been covered previously and this, but we'll try my best to ensure that the overlap is minimized. And a few case laws as and when required. So I don't have to get into the details of what is a patent. All of you are already aware what is a patent and what actually, what kind of a right you get under the patents. And so we usually call intellectual property rights as a negative right. When I say negative right, you have a right to stop others from making, using, offering for sale, or selling your invention for a period of 20 years. Okay, so that is what we mean when you say you have certain rights under the patent law. So with this, a little intro about patents. Let's try to understand inventions in biotech field. So it includes any kind of product or process, of course, as you know. Some of the examples which I picked up from the patents granted in India is gene engineering technologies, methods of producing organisms. You please try to understand it's a method of producing organisms and not the organisms per se, because there is some kind of restrictions there. So methods of isolation of microorganism from culture medium, methods of mutation, cultures, mutants, transformants, plasmids, cell lines for making monoclonal antibodies, transgenic plants, animals, isolation of human genes for using them to produce medicaments. So these are some of the inventions which gets covered in this particular domain. With that introduction, let me get into the brief history of how patenting in biotechnology has developed or is developing in India. So till 2002, the practice in the Indian Patent Office were that patents were not granted for inventions relating to living entities of natural or artificial origin, biological materials or other materials having replicating properties, substances derived from such materials, and any processes for the production of living substances, entities, including nucleic acids. So till 2002, this was not the scenario in the country, despite it meeting the patentability requirements. Okay, but patents could be granted for processes of producing non-living substances by chemical processes, bioconversion, and microbiological processes using microorganisms or biological materials. So that was definitely allowed even prior to 2002. However, what happened that all these things were started included in the Indian patent, pertaining to the grant of technology inventions. So one such interesting decision by the High Court, Honorable High Court of Calcutta, was that this is a case between Timanico versus Controller of Patents and Designs, where it focused on inventions where the final product of the claimed process contained living microorganisms. Okay, so this was the entire thing. So let's try to understand what this case basically dealt with. So the court, this particular case was related to a process for the preparation of a live vaccine for protecting poultry against bursitis infection. Okay, the control of patents had refused, that is, the patent office had refused the application for grant of patent on the ground that the vaccine involved processing of certain microbial substances and contained gene sequence. So the controller had decided that the claim was not patentable because the process was only a natural process, devoid of any manufacturing activity, and the end product contained living material. You can see what kind of conditions or the reasoning the patent office had given. So when it says it's related to a process for the preparation of a live vaccine, okay, so the controller said that it was not patentable because the claim process was only a natural process devoid of any manufacturing activity, and the end product contained a living material. So living material was not patentable. Now, one has to understand what the word manufacturer actually means, because the controller here clearly stated that it is devoid of any manufacturing activity. right? That is as per the definition given to us in the patent law of what invention is. I'll get into that a little later. So the court basically held that the word manufacture was not defined in the statute. Therefore, the dictionary meaning attributed to the word in the particular trade or business can be accepted if the end product is a commercial entity. Okay, so that is what the High Court went ahead to and tried to define the word manufacture. So the court held that there is no statutory bar in the patent statute to accept the manner of manufacture as patentable even if the end product contain a living organism. So the Indian Patent Office says because it's a living organism, you cannot consider that to be a manufacturing process. But however, the court said that even if this is a living organism, okay, you should consider that to be a manufacture. You know, it should come under the definition of manufacture. So the court came up with an interesting test, which was considered to be the vendability test to identify, what the invention is all about. So the said test would be satisfied if the invention resulted in the production of some vendable item, or it improved or restored the former conditions of a vendable item, or its effect was a preservation and of some vendable product. So the court further stated that the vendable product meant something which could be passed on from one man to another upon transaction of purchase and sale. In other words, be a commercial entity. That is what vendable product. The reason I had to read this out for you is because it is important for me to communicate to you what exactly the court had said, not something which I am trying to interpret. Okay, so considering that, the court concluded that a new and a useful art or process is an invention, and where the end product is a new article, the process leading to its manufacture is an invention. So can you just try to understand the difference here? So it said that a new and useful art or process is an invention, and where the end product is a new article, irrespective of whether it contains a living organism or not, the process leading to its manufacture is an invention because the end product is new, the end product is different. Now, based on this decision, in the year 2002, okay, the Patent Act was amended, and to basically incorporate biochemical, biotechnology, and microbiological process, okay, within the scope of so-called chemical process and within the scope of so-called manufacture. So here, because there's a lot of confusion, the definition of invention was changed in that particular year. And it said any new product or process involving an inventive step and capable of industrial application. So the manner of manufacture was deleted in the enactment, okay, for this particular thing. So why was it deleted? Because of this decision. The manner of manufacture was not very relevant when it came to since there was no definition provided by the Patent Act, so the interpretation is always a problem. Now let's move on to the patentable criteria, which has already been dealt with. So you know the primary criteria for patenting. So it is novelty, your invention. So what is an invention, which I've already said. So your invention should be novel, should be non-obvious, and should have an industrial application. So from the Indian perspective, I'll give you examples of how a patent office actually considers these three criteria, okay, and evaluates your invention. This is which I've already so what does an invention mean? It says a new product or a process involving an inventive step and capable of industrial application. So invention is related to both a process or a product, or it can be both. So this is something which is what I'm going to deal here in the next few slides. So let's go into the examples of novelty. I will not get into the details of what novelty is, what inventive step is, because the previous speaker has already covered these criteria. But I'm just going to focus from the Indian perspective of how they deal with what an invention is novel. So I'm just going to take an example of a claim, which we call it, I mean, we have different kind of claims or different kind of inventions. And based on the inventions, we have different kind of claims which you put. One of such claims is product by process claims. You know, the case which I previously explained. So that also falls under a product by process claims, wherein a claim to the claim reads as follows: a claim to a product obtained or produced by a process is anticipated by any prior disclosure of that particular product per se, regardless of its method of production. Okay, so some of the examples are a polypeptide compound, which is a product of the method according to claim 10. Okay. So a polypeptide compound, which is a product of the method according to claim 10. So what is it saying? Now, I have actually produced a product using the process which has been listed there. Okay, so that is what it means by a product by process. My product is achieved because of the process which I have mentioned in my previous claims. Okay, so I claim my product based on that. However, my product would not be my first claim. I would not say, the invention pertains to a polypeptide or a compound X. No, it doesn't say that, but it says in a polypeptide, which is a product of the method according to claim 10, right? A transgenic microorganism obtained by the method characterized in that. So these are some of the claims wherein it clearly states that you have obtained a product based on certain process which you have been followed, and that process is unique. So basis that you have achieved a product. Now, are such inventions basically accepted? Are such patents are granted for such invention? The question is, there is no doubt that a patent can be granted for the process which you achieve. Okay, the process which is new, if it meets the criteria. So the patent office will try to divide your claims. Okay, so obviously when somebody has gone ahead and drafted claims, they would have added two independent claims. One claim, the first claim is pertaining to the process, and your next independent claim is regarding the compound or a polypeptide or whatever you have obtained using this process. Okay, now, so if the product meets the requirement of patentability over the prior art, then of course a patent would be granted for your product as well. However, if your product is not new, does not meet the requirement of patentability over the prior art, then of course a patent will not be granted. Your patent probably will be restricted only to the process. Okay, so that is where the whole issue lies in. For instance, I'll give you an example here. Say we have obtained, I'm just giving a random example, paracetamol, okay, using a certain process. Now your process is unique. So you've come up with interesting steps, and then you have, obtained or produced paracetamol. Now what happens? You're going to claim paracetamol and you're going to claim the process as well. Process probably meets the criteria of novelty, inventive step, and industrial applicability. But then when it comes to paracetamol, which also I've claimed at the end, now how different is this paracetamol from the existing paracetamol? Now, if I get a patent for paracetamol, okay, paracetamol is already in public domain, which means I'm trying to monopolize my product of this paracetamol, okay, through this process. But it also means that if somebody else comes up with this paracetamol using a different process, they can also get it right. It's not restricted only to you. So what the patent office does is they also analyze this product to see whether this product, what you've achieved, probably using a different process, is also in the market or not. Now, considering that paracetamol is already in the market, so the technical effect remains the same. So that the patent office will reject the grant of, that particular claim related to paracetamol. However, if you can prove the technical effect is much different, so your paracetamol efficacy is much different, the features are much different from the existing paracetamol, then of course the patent office will consider and grant you a patent for that claim as well. So that is how it is analyzed when it comes to product by process. And in biotechnology inventions, you have a lot of such things, such kind of inventions where it is relied on product by process claims. The next example I would like to give is a sequence claim. So let's read this out. So it says a claim to a polynucleotide sequence that was available, example, as a part of library before the priority date. Okay, so it can lack novelty even if activity or function of the said sequence of the polynucleotide has not been previously determined. So what does it mean? So if there is a polynucleotide sequence available in the library before I filed for a patent, okay, and because it's available in the library, obviously it lacks novelty. Okay, now what have you come up with? If your invention is not focusing on the polynucleotide sequence, but focusing on a new function or a new activity of the polynucleotide sequence, even then it is rejected. It is rejected under doctrine of inherency. Basically, what it says is, now the new function or the activity which you have identified of a polynucleotide which is available in the library is something which was inherent, right? So it is not, it's a kind of a discovery. It's not an invention. So since it was inherent, a patent will not be granted. However, if it is not, if your polynucleotide sequence itself is new, then of course it's a different story altogether. And another example here is if any sequence of the polynucleotide or a polypeptide from a prior art does not exactly match with the claim sequence, okay, of what you have come up with. So if your sequence has some variation to the one which is already available in the domain, and when you try to compare, if the variation is very, very clear, then under those circumstances, it will not be considered, your invention will be considered to be novel and it will not be considered as anticipated by the prior art sequence. So those kind of sequences, of course, you can get a patent. Now that is with regard to the example of novelty. Now let me get into the details of an inventive step. So first and foremost, when a patent office considers for evaluating your invention, they'll go stepwise. The first thing they'll do is do a novelty check. Okay, and in the novelty check, they will determine whether your invention is disclosed in one single document. All the features of your invention, whether it is disclosed in one single document. Then after that, if they identify that it's not disclosed in one single document, okay, then they will go ahead to the next step with regard to the obviousness, that is inventive step. And then try to understand whether your invention is eligible as per the non-obviousness criteria. So as per the Patents, Indian Patents Act is what I'm trying to focus. An invention will have inventive step if the invention involves A, technically advanced as compared to existing knowledge, or B, having economic significance, or both, and that makes the invention not obvious to a person skilled in the art. Okay, so this is some of the criteria also to determine the inventive step. So let's take some examples here. The first one. An isolated DNA sequence encoding a mature human IL-3 protein having a proline residue at position 8 of the mature polypeptide, said protein possessing bone marrow proliferation inducing activity in a human bone marrow proliferation assay. So the difference with, as I told you, whether a novelty, inventive step, it is always evaluated using the existing prior art. So of course, if there's no prior art, the question of novelty or inventive step is not arise. So you compare the document, then on position 8, there was a proline moiety, whereas in the prior art compound, in the same position, there was a serine molecule. So that was the main difference. Position 8. So let's see what the patent office actually said. what I'm going to give you is not. So it's are part of family genes which are similar in their amino acid sequences, but are minor variants or point mutations of each other. So a single variation in the amino acid sequence does not normally change the activity and function of the protein unless the single variation is in a critical region of the protein. So look at the way they are trying to evaluate. So the applicant here could not provide any evidence that the protein coded by the claimed DNA was any different from that of the prior art in its chemical properties. Thus, the inventive step cannot be acknowledged. So by only changing one position, okay, and replacing it with a serine molecule as opposed to a proline moiety, the patent office said that unless you do not prove, okay, that there is a change in the activity and function of the protein with this single variation, we cannot basically state that it has an inventive step. Okay, so these are the conditions which the patent office put. So please understand these conditions are applied even for any new inventions which you file for a patent. So this is a precedent which patent office will follow for all their inventions, and this is how they go ahead and analyze when it comes to the sequences and the function these sequences have or the sequences carry. The next example here is a recombinant DNA sequence of sequence ID number whatever 10. So encoding sequence ID number X, encoding human interferon alpha 2 polypeptide. Okay, so this is a claim. Now, prior art discloses a nucleic acid sequence of sequence ID number X1 encoding human interferon alpha 1 polypeptide. Okay, let's look at the analysis here. So my claim, my invention is I come up with a sequence ID which encodes human interferon alpha 2 polypeptide. The prior art talks about the nucleic acid sequence of sequence ID X1 encoding human interferon alpha 1 polypeptide. Now, the claimed human interferon alpha 2 is structurally close to the prior art's human interferon alpha 1. So this is what the analysis by the patent office was. However, the alleged invention can be held non-obvious. So which means they said that it is inventive in nature because of the fact that the claimed human interferon is 30 times more potent in its antiviral activity than its prior art analog. So you can understand the difference, the functionality, there is efficacy is much higher. Okay, so because although they're structurally close, but however, because that the human interferon is 30 times more potent in its antiviral activity than the prior art of interferon alpha 1 polypeptide, it was considered to be non-obvious and a patent was granted. That is how the inventive step is analyzed. So let's move on to the industrial application. Okay, I'm just giving you one example each because there's a lot of things for me to cover pertaining to the biotechnology inventions based on the patent law. And since I have only 1 hour, I thought it's important and to just give you one example so that you understand how the patent office evaluates vis-a-vis the Indian patent law. So moving on to the third criteria, which is the industrial application. Now, what does this say? So capable of industrial application means with regard to an invention that it is capable of being made or used in an industry. Okay, so that is what it means. So it should be capable of being made or used in an industry. So it also says, our enactment also says that if a patent is liable to be revoked if the invention is not useful at any point of time. Okay. So let's take an example here. The claim reads as follows: a polypeptide in substantially isolated form comprising a contiguous sequence of at least 10 amino acids encoded by the genome of hepatitis C virus and comprising an antigenic determinant where HCV is characterized by a positive stranded RNA genome, to said genome comprising an open reading frame encoding a polyprotein, and 3-set polyprotein comprising an amino acid sequence having at least 40% homology to the 859 amino acid sequence X. Okay, so that to the 859 amino acid sequence X, so it is a number of amino acid sequence which basically it says it has at least 40% homology. Now, analysis by the patent office. So the patent office said that it was sufficiently enabled and its use was properly established in the specification. Therefore, this claim 1 was allowed. Okay, there was another claim which continued. So claim 1, there was no problem. It says because all the criteria was met and and approved in the specification. So the other claim actually says a polypeptide in substantially isolated form whose sequence is shown in one of sequence IDs 1, 3 to 32, 36, 46, and 47, or whose sequence is encoded in a polynucleotide selectively hybridizable with the polynucleotide as shown in any one of the sequence IDs 1, 3 to 32, 36, 46, or 47. Okay, so this was another claim. Now, the patent office examined and it said that the claim covered an almost vast number of polypeptides for which no use was established. And the said claim, because no use was established for the listed polypeptides, okay, I mean, the patent specification should actually clearly establish the use of each polypeptide, right? What is it used for? So for which no use was established, and the said claim therefore was not allowable on the ground that it lacked industrial applicability. Moving on. So fragments or ESTs are allowable if they, in addition to other conditions, satisfy the question of usefulness and industrial application. So probably when you're trying to claim any kind of fragments or ESTs, the patent office is very clear that if you can satisfy the question of usefulness in addition to the novelty and inventive step which I mentioned, of course it will be allowed. Now, but however, if you say that this EST is used, okay, as a gene probe or a chromosome marker, then of course it will not be considered to be having an industrial application. You'll have to be very specific, and a substantial use of the EST should be disclosed. So even in the previous case, the same thing has happened. Okay, unless you're very specific and specific with regard to the use of that is not disclosed, then it will not be granted. So one such example is to diagnose a specific disease. So you just mentioned what is the specific disease when I talk about a probe to diagnose a specific disease. So if it's a chromosome marker, we'll have to determine for what is it used for. Okay, clearly mention what is it used for. So when that is very, very clearly established in the specification and in the claims, then of course it will be considered that it has an industrial application. But if you give a general thing stating, okay, this can be used as a chromosome marker, no, the patent office would reject, stating that it is very generic in nature. Moving on to the patentable subject matter. So in addition to the important criteria of novelty, patentability, and industrial applicability, your invention, whether it's biotechnology or non-biotechnology invention, should not fall under the patentable subject matter. So here I'm trying to cover the sections which are relevant to the biotechnology industry alone. Okay, I'm not covering all other relevant sections because that is not the subject matter of today's discussion. So what does section 3B of our Indian Patent Act actually says? It says inventions contrary to morality or which causes serious prejudice to human, animal, or plant life or health or environment. So if inventions fall under this category, irrespective of whether it meets a criteria of novelty, inventive step, and industrial applicability, a patent will not be granted. For instance, a process for cloning human beings or animals. Okay, a process for modifying the genetic identity of animals which are likely to cause them suffering without any substantial medical or other benefit to man or animal. A process for preparing seeds or other genetic materials comprising elements which might cause adverse environmental impacts. Okay, so these are some of the examples under this category where inventions, a patent will not be granted because it will be considered to be against or a prejudice to environment or health, whether it is human health or non-human health or any living organism. The next section is section 3C. Okay, so a case study there. So here it talks about discovery of any living or non-living substance occurring in nature. How does one really identify microorganisms, nucleic acid sequences, proteins, enzymes, compounds, etc., which are directly isolated from nature and not patentable subject matter? Please remember that this is one of the exclusions which is not restricted only to India, but there are several countries who follow this. Okay, and I'm sure the previous speaker has spoken to you about a few interesting case studies which was decided by the US Supreme Court, which clearly spoke about how do you really differentiate between a discovery and invention of a living or a non-living substance. So products such as microorganisms, nucleic acid sequences, proteins, enzymes, compounds which are isolated cannot be considered to be a patentable subject matter. So one of the cases again dealt by the Indian Patent Office. So as an bacillus species, it's given an ID 123 comprising rDNA, sequence represented as sequence ID number 1. So the response from the Indian Patent Office was the subject matter of claim falls within the scope of section 3C of the Act as it attempts to claim an isolated bacillus species 123, okay, occurring in nature, that is from soil as disclosed in the specification. Thus, what is claimed in the claim is treated as a discovery of living thing occurring in nature and hence not patentable. Okay, so it was just a isolation of the gene sequence, and considering that, they said it is not patentable. Now, section 3D, very, very important. So mere discovery of any new property or new use for a known substance or of the mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. So if there's any invention which falls under this category, which will be considered as only a discovery of any new property, okay, without it showing any new reactant or any new substance in it, then of course it will not be patentable as per section 3D. It also further explains with regard to salts, esters, ethers, etc., etc. So, which is more towards the chemistry aspect, but complexes, combinations, and other derivatives of known substance is also considered for biotech industry. Okay, so anything falling under this explanation shall be considered to be the same substance unless they differ significantly in properties with regard to the efficacy. So the highlight here is about the efficacy. If you can do that, prove that, then of course you can overcome this particular section 3D. Now let's try to see a case here. Pre-protein A being one of the factors which primarily controls glucose metabolism in mammals having C-peptide, wherein said C-peptide comprises 2 amino acids selected from XY, YZ, and ZX. Okay, so this is what the claim is. Now, analysis. Prior discloses modified protein A having C-peptide. Okay, so wherein said C-peptide consists of amino acid XX. So here we have, my claim is a pre-protein A being one of the factors which control glucose metabolism in mammals having C-peptide, wherein the C-peptide comprises 2 amino acids selected from XY, YZ, and ZX. Okay, any one of these 2. Now, analysis, my prior art says that a modified protein A having C-peptide, wherein said C-peptide consists of amino acids XX. Now, the applicant failed to demonstrate any therapeutic efficacy as a result of claimed modification of the prior art. Okay, because there is no increase in the efficacy for the modification made. For the insertion of the two amino acids selected from the list of X5, YZ, and ZX, the patent office rejected this particular patent, stating that it falls under section 3B of the Act. So again, it is the end result, which is what is focusing on. Now, section 3E. This basically talks about substance obtained by mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance. So an invention which is a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance. So just gave a random example here of a combi flame, which is a admixture of paracetamol plus bruphene. So antipyretic and analogous. So such combinations, you would not get a patent. However, if the combination gives you synergistic properties, okay, and then it'll definitely be considered to be patentable. Okay, so the focus is here on the synergistic properties. An example here. A composition of innovative combination of dormant spore of naturally occurring Pseudomyces lilacinus and Arthrobotrys species fungus with enzymes, fats, and growth promoting molecules to control plant parasitic nematodes. Okay, now the patent office stated here that the claims fall within the scope of section 3E. Why? Because it is focusing on two naturally occurring fungal species. Okay. Upon examination, it is found that the claim is directed to a composition of two known fungal species. So said two species used in the alleged invention were known for nematode biocontrol activity. However, the specification was silent on advantages of a combinative effect of these two fungal species. So the synergistic effect was not proved. And because it was not proved over the sum of their individual effects, okay, the patent office rejected this claim under section 3E. Next is the section 3H. Now, 3H is related to inventions which are a method of agriculture and horticulture. So I've just given some examples here. A method of growing leguminous plants as intercropping for improving fertility of soil by augmenting plants as intercropping for improving fertility of soil by augmenting nitrogen content of the soil. So the patent office evaluated and said that the claim is agriculture method and hence falls under the scope of section 3H. So I think there is nothing new with regard to this method, because leguminous plants are usually grown as intercropping, right? We all know what is the importance of this leguminous plant when you use it as intercropping. And considering that, even if you come up with a process, the ultimate effect is you're using these leguminous plants to improve the fertility of the soil. So since it's a method of agriculture and horticulture, they said it's not patentable. Another example for 3H is a method of reducing mycotoxin contamination of a plant or harvested plant material that involved treatment of seeds with the chemicals before sowing or during sowing or the field for the plant cultivation process. Okay, now invention, because it only involves treatment of seeds with the chemicals before sowing or during sowing. They said that this is related to the cultivation process, falling under section 3H and hence considered not patentable. Section 3I. So this relates to method of treatment and diagnosis. Again, this is something from the TRIPS. So followed by all the TRIPS signatories. So any invention which is a process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings or a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. So inventions falling under this category is not patentable. However, if there is any surgical, therapeutic, or diagnostic apparatus or instruments, okay, if it's related to an instrument or apparatus, of course, it's patentable. But if it's not related to an instrument or apparatus, and it's related to a process, then it is not patentable. There's always a lot of concerns when it comes to the latest technology, sometimes where you come up with an instrument which requires unique methods to handle the treatment. So under that, there is always a concern whether that particular apparatus, which is patentable as per the Indian patent law, along with that method to use that apparatus, should also be considered patentable or not. There's a lot of debate because sometimes it is acceptable, sometimes it is not accepted by the patent office for stating that the second part falls under the 3I, but the first part is of course allowed. Okay, that is still which has to be considered by the Indian Patent Office to see how we can overcome such kind of combinations. So removal of cancer tumor, removal of dental plaque and caries, surgical processes, blood transfusion methods, all these are not patentable as per Section 3I. So one example here, a method of monitoring drug response in a patient suffering from cancer treated with a combination of gemcitabine and P1446A, comprising detection of a gene signature with at least 2 drug response markers, wherein the said drug response markers are selected from the group consisting of P21, REV3L, etc., etc. So these are the various markers. So when we say from the group, which means you can use any one of these markers, right, to detect the gene signature. Now, and the patent office came back and said, the subject matter of claim is directed to method of diagnosis of human beings or animals, which are statutorily barred from the patentability under Section 3I of the Act, right? So since it is involved in the diagnosis of patients suffering from cancer, it was not considered to be patentable. So one of the smart ways to address this, you just remove this, a method of monitoring drug response. Okay. So, but however, if there is a way out to redraft the whole claims and come up with a claims which focuses on the compounds here, then probably we hold a better chance of getting a patent granted. The other exclusion is Section 3J. That's plants and animals in whole or any part thereof other than microorganisms, but including seeds, varieties, and species, and essentially biological process. Okay, so this again, any microorganisms, you can see the differences here. Other than microorganisms, okay, is something which will be falling under Section 3J. So one of the example here is a method of producing at least one of substantially pure hybrid seeds, plants and crops, comprising the steps of I, producing a male parent, which is a male fertile, 2, breeding the male parent with a female fertile, which is substantially male sterile, and 3, harvesting seeds from the female parent, which contain pure hybrid seeds. I think this method is anyway common. Any agriculturist who knows something about agriculture will have to do this for breeding. So here, the claimed method involves a step of crossbreeding for producing pure hybrid seeds, plants, and crops. Thus, it is an essentially biological process and not allowable under Section 3J, right? So that is how it was decided and said a patent cannot be granted. I think each example will give you an analysis of how random patents are not allowed by the Indian Patent Office. And in fact, we would say some of these exclusions are the best over such inventions. If at all this Section 3J was not available, probably a patent would have been granted for a crossbreeding mechanism, which is quite well known amongst the agriculturists. The other one is Section 3K, which is computer programs per se and algorithm mathematical methods. Okay, so here A computer-assisted method of generating a compound that inhibits the glutamine formation active site activity of a glutamine synthetase polypeptide, wherein said test compound is capable of inhibiting the interaction between an adenylated catalytic triad site of the glutamine formation active site and a glutamine phosphate intermediate, or of inhibiting the interaction between a deadenylated catalytic triad site of the glutamine formation active site and a glutamine phosphate intermediate. Okay. So this is basically related to a computer assisted method of generating these compounds that inhibit various glutamine formation. Now, what are the steps of providing a three-dimensional structure of a glutamine formation active site of a glutamine synthetase polypeptide? So it is all a three-dimensional structure and designing based on the three-dimensional structure. Since it was a mathematical model, okay, the patent office has rejected this invention. It said it's considered as a mathematical method or a computer program per se. Okay, so it is a method to design the inhibitory compound based on 3D structures, but does not lead to a real product whatsoever. So since it is not concerned to a real product, it falls under section 3K and it cannot be patented. That is what this particular enactment says. Section 3P. This is the last exclusion available for biotechnology inventions under the patentability subject matter. So section 3P talks about inventions which are in effect traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components, is not considered to be patentable. Okay. One example is serum of pigeon possessing the anti-paralysis activity. So this was a claim. Now, I'm not sure how many of you are aware that I think it is it was a well-known traditional method of using the pigeon serum to cure anti-paralysis activity. So the patent office came up stating that the use of pigeon serum for the treatment of paralysis is a traditional knowledge in India or is an aggregation or duplication of known properties of traditionally known component. So they came up with interesting prior art where it stated that animals and the products utilized as medicines by the inhabitants surrounding the Ranthambore National Park. Okay, and this particular application clearly disclosed that the use of pigeon blood for treating paralysis. So they came up with a prior art and stated that since it is a traditional knowledge, it is known in the public. Because of that, a patent cannot be granted for such inventions. So that is with regard to the patentability criteria. Now, I think it's also important for us to understand the other clauses which are relevant to biotech industries. Of course, this is something which is relevant to all industries, but biotech industry also, it is important for you to know. Also considering the pandemic situation. So India also has several balances and checks when it comes to drugs or anything related to such a pandemic situation which we are facing. So one such option is the compulsory licensing provisions. Not many countries have, but yes, there are several countries who have included such an option in their patent systems. So what happens now under this? At any point of time, if the patent office thinks that this particular invention which has been patented by one particular country, one particular company is not meeting the requirement of public, or the cost is very, very high, okay, or is not working in a particular area, then under those circumstances, the patent office will go ahead and, without the permission of the original patent holder, grant licenses to other companies who would be capable of going ahead and producing these particular drugs, okay, to meet the requirement of public. So that is what it means, okay. This is just an overall description, not getting into the details, but then this is a great check which we have under the Indian patent law. But of course, there are certain terms and conditions which needs to be met for a compulsory license to be granted. So if any one of you have a doubt stating that, okay, why is that the current vaccines which we have for COVID, not being able to is not being manufactured by several other companies. One of the reasons is compulsory license is only for once a patent is granted. Okay, and after the expiration of 3 years from the date of grant of patent. Okay, there are a lot of issues involved in it, but I'm just trying to give you that. So of course, still, probably they would have just gone ahead and filed for a patent. So patent should be granted, and then upon expiry of 3 years is when this can be implemented or enforced. So this is one of the condition here. So I think, unless one does not fulfill these criteria, licenses cannot be granted. Now, other provisions, sufficiency of disclosure and the best method of performing the invention. It's very, very important for, biotech invention. Now, if you do not disclose sufficiently or the best mode of performing your invention, a patent would be rejected. So it is like, even if it meets the criteria I just specified or falls beyond the subject matter, okay, does not fall under the exclusions, and if you have not disclosed it sufficiently and not disclosed the best method of performing the invention, patent will be rejected. Now, deposition of biological material, I think was already discussed, but I'll tell you, it is a compulsory thing even under the Indian patent law. So you will have to go ahead and deposit the new biological material which you have come up with. Okay, you'll have to describe that clearly in your patent application and go ahead and file for application and deposit with any of the international depository authorities. We are all bound by the Budapest Treaty, and India is a signatory to this. Okay, and the process is very easy. It is not difficult at all. And the scientists from these collection centers are very, very helpful. And if you deposit it in one center, the same deposition number can be given to all other countries, to the other patent offices, wherever you intend to go and file for a patent. It is not a requirement that you'll have to go and deposit it each country's deposition center. Okay, but it is a mandatory that you have to deposit any kind of biological material which you have come up with, which you're trying to claim a patent for. With clearly characterizing the material which you are trying to put your hands on. Okay. In India, we have the MTCC, which is a microbial type culture collection, and Gene Bank Chandigarh, and we also have the microbial culture collection in Pune. So these are the two places where you can go ahead and deposit the biological material in India. All the details are available in their website. And if you do not deposit, of course, the patent will not be granted till you deposit and get your accession number from these centers. Another interesting aspect which everybody should consider, because the patents are being rejected because of not following this process, is biodiversity related issues. So we have something called a Biological Diversity Act. Okay, under this act, any intellectual property, including patents, okay, which is based on the research, understand, research or information on biological resources obtained from India shall not be granted without the approval of NBA. Okay, so that is what, which is very, very important. So you will have to go and file for an application before the NBA authorities. And then before your patent office examines your application, ideally, you should get a no objection certificate from the NBA authorities stating that this biological sources can be, a patent can be granted. The objective here is to basically facilitate the access to the benefit sharing. I would not say all the biotechnology related inventions might fall under this, but there are a lot which falls under this category. Even the research also includes that. I will give you one interesting case, pertaining to turmeric. So there was this scientist who was working on curcumin, and we all know that turmeric is available across. Okay, and this scientist has actually picked up this. He's not picked up the turmeric from naturally available places. But what he's done is, and not extracted curcumin from a plant, but he's basically bought this curcumin from a chemical store, a chemical store which is like well known in the world. Okay, so then he's gone and picked up this 100% pure curcumin for his research. Now, the research results are definitely different, but he's used this curcumin from there. Now, the NBA insisted that we should have sought permission from them and a no objection, because we are actually doing a research using a biological resources available in India, okay, for this particular invention. Now, because of that, there was a lot of issues which have to be faced by this inventor, and some of the inventors who were actually working this area, it was rejected, so they didn't grant they didn't issue any new objection. But yeah, some of them took the benefits because there's there was a notification 2 years, 3 years ago that all such things should be considered and quickly disposed of. So benefits were taken under that notification. But however, what was learned is whether you use it for research, okay, whether you extract it or not extract it, but obtain the purified form of this product from any kind of a store, you will have to report to the NBA. And of course, the process is again not very complicated. You can just report to the NBA. You are supposed to sign certain documents stating that if you reap benefit at some point of time, if you're trying to extract curcumin from turmeric plants, instead of then buying it, maybe you can always think it this way, that probably when it is mass production, buying the purified form, the 100% form from a chemical store may be expensive, and you would consider going ahead and sourcing it from some store, sourcing it from a farmer. So under those circumstances, they're like, we will have to share some kind of benefits with them. So that's the objective here. And it also, another objective is to prevent misappropriation of biological resources and traditional knowledge, which is also happening with a lot of industries, both pharma and biotech. And this has actually put in a lot of checks and balances and has ensured that the biopiracy also does not happen. With this, I would end my session, because the other case laws here would have already been covered from the international perspective by the previous speakers. So whether it is Mayo versus Prometheus, which talks about how various drug-related inventions, and the myriad genetics, which actually spoke about the extraction of a gene, whether it is considered to be patentable or not, whether it's considered to be a discovery or an invention. Okay, so these cases have already been discussed. I will not get into the details, but and would like to restrict only to the Indian patent law cases. So this is a quick statistics. This is from the report by the Indian Patent Office. You can see the number of inventions which are being filed in India. Unfortunately, the numbers are not very high. Engineering domains, of course, the numbers are high, but you can see that in 14-15, the biotechnology inventions was 260, 215-16 reduced to 185. 17-18, 546 in this industry, and 18-19 again, it's come down, it's 457. So these are the number of patent applications granted in that particular year, okay, from 14 to 19. And number of patent applications filed, 15, it is 1,035. Now, one cannot correlate the patents filed and granted. So I cannot say that in 15,035 were filed and only 262 were granted. No, for a patent to be granted on an average, it takes 3 to 5 years. So probably there's 1,035 patents granted in that particular year of patent applications filed maybe in 2010, 2009, or 2011. Those years where patent applications were filed would have been granted in 2015. So the number was 1,035 then. In 2018 and 19, the number of patent applications granted is 882. Okay. the numbers have to be, the objective of all our sessions is to encourage and to give you that kind of analysis of the how patent law treats your inventions, evaluates your invention. And I think at least through this awareness, we would want you to understand that, you can keep in mind when you're drafting a patent applications or even when you're trying to work on a particular project to ensure that you meet the criteria in the beginning itself and do not struggle, after filing for a patent based on the objections raised by the patent office. So the objective here is to ensure that you go ahead and seek protection for your biotechnology inventions and increase a number in the country, which is unfortunately very small in nature. And again, out of this, there are very few Indian applicants filing these patent applications. A lot of multinational companies were seeking benefit here, but there are very few Indian applicants trying to file for patents under this domain, which is an unfortunate scenario. But I think the kind of awareness created by both the central and the state governments, we hope that in the coming years, the numbers would go up and many of you also would focus on filing patents in this particular domain and help the country generate some revenue using these patents. So thank you very much for your kind attention. I think we can open the floor for probably a couple of questions. I am sorry that I was quite fast without taking a break because I had to cover a lot of things in this 1 hour time. So that's the reason I was asking how much time we have in the beginning. So I was trying to be really fast to cover all these aspects, but however, yeah, maybe we can just take another 2-3 minutes to close. I know it is lunchtime and all of you, would be hungry.
Thank you, ma'am, for the wonderful presentation. Now the session is open for question and answer. Please drop your questions in the chat box. We have one question from the faculty, ma'am. What would happen to a patented microbe or a mechanism that showed ill effects after it got patented?
It can always be invalidated if it shows ill effects. Okay, the patent law actually is not restricted only to rejecting of a patent. At some point of time, if somebody can really prove that it has ill effects, it can always invalidate.
Okay, thank you. There is one more question from the faculty. What are the norms for biological protocol patenting?
When you say norms, did they mean by procedures?
Procedures and what are the certain rules that has to be followed?
Okay, so I think the entire session was focusing on what are the terms and conditions one needs to follow. Basically trying to tell you that these are the criteria which your invention should meet. Okay, one meets this criteria and you as an inventor feels, it has this inventive step, it is non-obvious, it has this industrial applicability and does not fall under the section 3, which I was trying to explain. That is your first step for you to go and file for a patent. The second step is, the previous speaker, I'm sure I've told you because she's an expert in that, the importance of doing your prior art search. Your prior art search is definitely related to your novelty and inventive step identification. So you as an inventor, do your first analysis. And once these things are met, then follow the procedures. And the procedures for biotechnology inventions, as I told you, is not very different from all other inventions. But certain conditions, like if you have a biological material, please talk to somebody, go ahead and deposit it. If it's related to the NBA, do it. The very reason why I'm stressing on this procedural aspects is, even if your invention meets all the criteria, okay, and if you do not this, there are a lot of inventions which have been rejected. Okay, keep that in mind. Follow these procedures and then go ahead and file for a patent. Procedural defects will not be, considered at a point of time.
Thank you, ma'am. There is actually one more question. Can a microbial extract or any microbial component that is having antimicrobial property or any anti-cancer property can be patented, not the organism, but the component of the microorganism?
the component per se, again, it might not be the microorganisms, but the component which is available in that particular microorganism. Okay, if you're just trying to extract that component available in microorganism, and then you identify that it has these kind of properties, I would say it's a lot of debatable matter, because there are inventions which are allowed by some of the patent offices. There are also inventions which are not allowed. It also depends on how we smartly go ahead and draft those applications. But for now, for this session, I will tell you that let's consider that it will be patentable, but please be very, very smart in drafting your applications to ensure that it will not be considered only as a discovery. If you can try to overcome that discovery component, yes, you can definitely go and seek patent protection.
Thank you so much, ma'am, for your patient listening and providing everyone with the valuable answers. Now session will be moved on with Pallavi, ma'am.
Thank you very much.
Thank you, ma'am. That was a wonderful session. Now, this concludes our first day of the workshop. Thank you all for attending. We hope you have learned and enjoyed the day's presentations. I request you all to grace your presence tomorrow for the second day of 2 days virtual workshop on intellectual property rights and biotechnology with the link provided at 10:30 a.m. tomorrow. Thank you all.
Thank you, Brinda madam, for joining us.
Thank
Thank you so much.
Thank you. Bye.
Bye. We express our sincere thanks and gratitude on behalf of KLE management, principal, and heads of various departments. Thank you so much.
Thank you.
Dear delegates, now we are going to receive feedback link. Kindly give your valuable inputs in this particular feedback link. And tomorrow you will receive your e-certificate. Today you need to give your feedback of today's resource person, a talk and interaction. Tomorrow, when you submit second feedback, that time you'll receive your certificate. Thank you. Dear delegates, kindly fill day 1 workshop on IPR and biotechnology feedback. It's put on the chat box. Kindly give your valuable feedback. Thank you, everyone. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಸರ್ವರಿಗೂ ಶರಣಾರ್ಥಿಗಳು. ಕೇಲಿ ಮಹಾವಿದ್ಯಾಸಂಸ್ಥೆಯ ಸಪ್ತ ಋಷಿಗಳ ಪಾದಾವಂದಗಳಿಗೆ ನಮಸ್ಕರಿಸಿ ಈ ದಿನದ ಅಂತರ್ಜಾಲ ಆಧಾರಿತ ಕಾರ್ಯಾಗಾರವನ್ನು ಪ್ರಾರಂಭಿಸುತ್ತಿದ್ದೇವೆ. Now I would like to request Srimati Trupti Vadakeri, Faculty Department of Biotechnology, to proceed with today's technical session 3 and 4. Over to Trupti Vadakeri.
Warm greetings to all. It gives me immense pleasure to welcome you all on day 2 of virtual workshop organized by Department of Biotechnology. On behalf of KLE's S. Nijalingappa College, I, Trupti Vadakeri, Assistant Professor, Department of Biotechnology, would like to welcome you all to second day of IQAC initiated 2 days virtual workshop on intellectual property rights and biotechnology in association with Karnataka State Council for Technology, Bengaluru on 5th August 2021. I would like to welcome Dr. Arun Kumar B. Sonapanavar, Principal KLES Nijalingappa College. Welcome to you, sir. Warm welcome to Dr. Pratibha KS, Head Department of Biotechnology. Welcome, ma'am. I also extend my warm welcome to IQAC Coordinator, Heads of various departments, faculty, delegates, and students. Welcome to you all. The world is full of diamonds and gems, and we are having some of them here today. Today's speakers are one of the best in their respective fields, and I feel it is our great honor to be in their presence and listen to their knowledgeable talks. So without any delay, now I request Ms. Pallavi Prasad MS, Faculty Department of Biotechnology, to welcome and introduce our speaker for second day's third technical session, Dr. Nandini D. Over to you, ma'am.
Good morning, one and all. This task of introducing our resource person for the technical session 3, Dr. Nandini Ji, is a great privilege. I feel elated to welcome and introduce Dr. Nandini Ji, GI Expert Foundation for Revitalization for Local Health Traditions, Bengaluru. On behalf of KLE Society Management, Principal KLE's Nijalingappa College, Head Department of Biotechnology and heads of various departments and faculty of Biotechnology Department, I extend a warm welcome to Dr. Nandini D. Nandini D is currently associated with Foundation for Revitalization for Local Health Traditions, Bengaluru, and with Research Institute of World's Ancient Traditions, Culture and Heritage, Arunachal Pradesh, as visiting faculty. Her research work includes genetic studies and phytochemical analysis. She served as faculty, Department of Biotechnology, PES University. Dr. Nandini has received Best Woman Scientist Award, Gulbarga University, Gulbarga, and Best Young Scientist Award at Karnataka Science Congress, VTU, Belagavi. Nandini trained government officials, public NGOs on biodiversity and conservation. Served as evaluator for rural development and Panchayat Raj for sanitation and rainwater harvest programs in Karnataka. She is consultative group member for Geographical Indications Examination, Government of India, and helped rural communities to file GI application. She has facilitated e-network, updated information under GOI, DEF UNDP, medicinal plant projects to promote communication across stakeholders. Dr. Nandini authored books in Kannada and English. She has participated in public talks, radio, TV programs, published scientific and general articles to bring awareness on biodiversity and to create awareness in traditional knowledge. We welcome you, ma'am. I now request Dr. Nandini to deliver her talk on overview of IPR, PGR and GAIN. Over to Nandini, ma'am.
May I share the slide, madam?
Yes, ma'am. Yes, ma'am. Are you getting, ma'am, there? Share option?
Yes. Could you see the screen?
Yes, ma'am. Yes, coming.
Could you see the screen, madam? Presentation?
It's just opening, ma'am.
Hmm.
Not yet opened.
No?
No, ma'am. You please go for again stop share. One more time you try, ma'am. Otherwise, you can send me your PPT to the email ID. so that I
Yes,
can
ma'am.
share.
Yeah. For me, it is showing sharing.
Over to you, ma'am.
Okay, thank you very much. And sorry for the delay. Somehow I could not, be on time, log in here, and there was some delay in that. Sorry for that.
No
Okay.
issues. Thank you.
So the topic given to me by my young friend Vivekananda is GAT, PGR, and IPR. I just reversed that, IPR, PGR, GAT. I reversed that, considering which is the best chronological way to tell you the story. I'm not trying to, just trying to teach something here, but sharing some of my thoughts, my observations. So it may help you in due course of time, because you're all studying biotechnology and what you are going to do with this biotechnology. And when you think about something like patent, how best you can understand the science behind that, and also how you can turn it out into a business model. What are the possibilities, and what made this IPR regime to become very, prominent subject matter to understand. Okay, so being a science student, it is very relevant for you to understand the IPR regime, and also how you can fit into this particular context. Okay, so this is a kind of history now. You can see a lady carrying a basket full of fruits, right? And on the other side, you can see the goddess, some doll kind of thing. You can see somebody is making it, right? So these are called Kinhala toys. Kinhala, ಕನ್ನಡ ಬರುತ್ತಾ ಎಲ್ರಿಗೂ? ಕೇಳಿಸ್ಕೊಳ್ತಿರೋರ್ಗೆ?
Yes, ma'am. They love Kannada.
ಓಕೆ. ಕಿನ್ಹಾಳ ಗೊತ್ತಿರ್ಬೋದಲ್ಲ, ಅದು ಸ್ವಲ್ಪ ಧಾರವಾಡದಿಂದ ಮುಂದೆ ಹೋದ್ರೆ ಅಲ್ಲಿ ಸಿಗುತ್ತೆ, ಹಂಪಿಗೆ ತುಂಬಾ ಹತ್ರ. ಸೊ ಇಟ್ ಇಸ್ ಅ ಸ್ಮಾಲ್ ವಿಲೇಜ್, and people who are residing in this particular village, they are artisans. They are artisans, they are toy makers, and they say that they hail this particular art, and they're practicing since the rule of Vijayanagara kingdom. It was in the 14th and 15th century. Today's Hampi is earlier Vijayanagara. So they were patronized by the rulers of Vijayanagara, but after the collapse of Vijayanagara kingdom, they moved to different parts, and many of them they moved towards the Kinhala, and they started practicing their art craftsmanship for their livelihood, and it continued. And this is very popular, the fruit tray what they are making. It looks very natural. You cannot distinguish it as something which is man-made, artificial. It looks very natural, and this is very popular. And the other thing is the statues of goddesses, they are very popular in making, and all these are made out of light wood. Like today what we are getting is light wood is Wrightia tinctoria, then drumstick tree, neem tree. So all these are used for making the toys. Okay, and here in the center there is a write-up. So some people, students from Glasgow, they visited this in 2007, and then they learned the art and craft of making this particular articles from these local villagers. They stayed for more than a month, and they returned to their home country, and they have come up with a product called as Glasgow Kinhall toys, and they started selling. So anyway, it was an international market, so they could sell their products in a better way. They could get the customers in other parts of the country and world also. So what makes the problem here? Okay, anybody can learn anything and they can do their business. What is wrong with this? There is nothing wrong with this. But what happens, because these are rural people, the artisans who are living in Kinhala, they don't know what are the consequences of this sharing knowledge, and also not going for the registration and for the international marketing, because Today you must have seen, even when you go to the kitchen, on the oil packet, if you see FASSI mark will be there. If you see your electronic items, I mark will be there, isn't it? It should be certified. So certification is very, very important to address the customers, to be in a business. So some kind of certification marks are required. One, to make a boundary to our own knowledge, and also to get it certified. Here knowledge means making a craft is a knowledge, right? So it is a knowledge. It is evolved out of their knowledge, their expertise, experience over the period, but it was not there. So the people who visited them, they learned the art and craft, and they have come up with their own product and started selling. So they were getting the better market, but these people, they didn't understand at that point of time. So let us come back to this particular instant, Kinhala ties, after some time. So what all happened during the previous century? So there was World War One, World War Two, which happened earlier. Also, there was a trade which was happening. You know why Europeans visited India? Because the road was blocked, the land route was blocked. They had to find a sea route. That's how again they could enter India. All the European different countries, people, they tried to get into India, because India was the richest country, and lot of this precious stones, or even the spices, which are very popular. Here spice means not just spice, it may be medicinal plants and other commodities also, even like fur, wool, all these, which was abundant. They were not able to leave that, because the land route was blocked. Somehow they wanted to continue trade with India. That's how they tried to find the sea route, and they entered India. And after that, you know that uh, all these Asian countries, and even the South American countries, they were under the rule of this French, British, all these, and many things happened over the period of First World War, Second World War, all these. But trade has to happen. Whatever may happen in the world, trade has to happen. You know that even during this lockdown period, the trade was down, but it was happening, right? The business was happening. It has to continue for the survival of the human society. So because of this trade requirement, there were many agreements which happened between the countries. Okay. So in 1972, Stockholm, Sweden, they have come up with the United Nations Conference on Human and Environment, because all these are biodiversity rich countries. So African countries, South American country, Asian countries, they are biodiversity rich country, and they are developing countries, are newly recognized countries, because earlier it was ruled by Europeans and they left, and again they have come up with their own concept of for fixing a boundary for their nation, for their country. So there was something which was required, an agreement, a conversation was required between the countries. So 113 countries, they attended this particular summit, and that time our Prime Minister Indira Gandhi, she attended this particular program. So this conference raised a generation's awareness on an issue hitherto little talked about, the global environment. Because of the war, so much destruction happened by the time, isn't it? First World War, Second World War, and all the Vietnam War, so many things happened during that time. Then the Stockholm Conference secured a permanent place for the environment on the world's agenda and led to the establishment of United Nations Environment Program. So after that, there was a before that, there was a Paris Convention, and this convention has given importance to the protection of industrial property, geographical indications, and also elements of IPR. So in 1883 itself, it was considered, but it was not that much prominent, or though it was prominent for the European countries, it was not much talked with these developing countries. And there were agreements which are called as GATT agreement, which is General Agreement on Trade and Tariff. So this agreement, there are several rounds of this GATT agreements. And in Uruguay round of agreement, which happened in 1994, there were 123 countries which were participants. And an outcome of that is the TRIPS agreement, which happened in 1995. So during this TRIPS agreement, 162 countries they participated. They are also covered under Article 22 and 24 of India as a member of the World Trade Organization (WTO), right? Which is enacted geographical indications of goods, which is 1999, which has come into force with effect from 15 September 2003. So I wish that at least few things like uh, that agreement, TRIPS agreement, and this Paris Convention 1883, and there is one more which is again 1993 convention, which I am going to tell. You need to remember some of these. So under this, as I told you, intellectual property in general, you might have already discussed in yesterday's programs. Okay. So you know that intellectual property means something which is, origined out of human experience, right? Which is should be non-obvious. And you can produce in large scale. That is, it should be, you can scale it up. Industrial production should be possible. You can make it into large scale production, and which is a requirement for the society. So considering all these, the rights can be given to the inventor or the people who are involved in production of this. So that is the basics. Then when you consider geographical indication, so something which is originated from a particular place, so that's how that particular goods is famous, which is known, which is famous with the region, name of that particular region. For example, Mysore silk, Mysore silk saree is very popular. It is very soft and it has particular motifs, borders, colors, right? So Mysore silk is very famous, popular. It is available only from KSIC today, right? And Dharwad Peda, which is very popular and which is originated from Dharwad, right? There may be many Peda shops like Mishra Peda and so many things, but they are not this Dharwad Peda. So the sign must identify a product as originating in a given place. So that is called as geographical indication. So Kinhala tiles is a geographical indication. So the tiles which are made in Kinhala by the artisans who are living in that particular area can only claim it as Kinhala tiles. There cannot be something like Glasgow Kinhala tiles. So later on, these Kinhala tiles, the producers, they formed the group and they were registered under these geographical indications, okay, under the IPR regime. And now some kind of training is given to these toy makers. So they were able to meet the customer requirement and they are improving their business, and even now today it is available on online market also. So some of these products are very popular. You must be aware of Darjeeling tea. So the tea which is originated only from the Darjeeling region in that specific area can be considered as Darjeeling tea. So some 300 odd number of tea gardens are registered under this. So only they can sell their product under the name of Darjeeling tea. So here you can see the logo which very much specifies that particular tea is originated from Darjeeling region. Then California almonds, right? So it is very popular. Then what is this? Champagne from France. Again, it is from France, this champagne. So it's quite popular. Then Cafe Colombia, the coffee from Colombia, which is very popular again. So these specify its origin, from where it is origin. It may have some special aroma, it may have special taste, or even something which is visual, the appearance, like Mysore silk saree, Banaras saree, right? So which has an appearance, a texture, a sense of touch, smell, taste, visual appearance. So all these are very important when you think about, registering a, sorry, is this? Geographical indications. So can you see here on the left hand side, this is Navalagunda Darri, Jamkana from Navalagunda village, and these are Mysuru Mallige, Jasmine, and these are two different types of banana which are registered, Kamalapurada Kembale. And this is very popular, you all know that. What is this? Can you identify? Anyway, Peda is already there here. What is this yellow color banana? which is very popular with the name of the town? Hmm? Anyone can answer.
ಏಲಕ್ಕಿ ಬಾಳೆಹಣ್ಣ ಮ್ಯಾಮ್.
Nanjanagudu Rasabale.
ಜನಕ್ಕೆ ರಸಬಾಳೆ. ಓಕೆ.
So like that, there are many goods which are registered under geographical indications. So how GIs are protected? Because one person is not responsible for this. Maybe a whole village or group of villages where it is produced. So there is a sui generis system, that is a special regime for protection. So using collective or certification marks. So those who are involved in that particular business, so they all have a certification mark. So it is a collective mark, group mark, which is given, and each member who are involved in that, they are identified. Okay, so the methods focusing on business practices including administrative product approval schemes. I told you, for food there is a special different certification mark. For spices there is a separate mark which is required. For textiles it is different. So this particular registration, it helps in the promotion of the business, so that the genuine product will reach the customer. Because when you say that Mysore silk, everybody wants to buy Mysore silk, but it is very expensive, right? But because of that, in the business always there are fake goods which will come into the market, and there will be competition. So to protect the identity, originality, certifications marks are very much important. Nowadays you see everywhere organic, but there is a proper protocol to get it certified as organic, right? So like this, so certifications marks are important, and GI is one of the main important certification mark under IPR regime. So there is a Judicial and Legal Protection for Geographical Indications Act as per 1999, which make provisions for civil and criminal remedies against infringement. Somebody would try to sell the fake product, copied or imitated product, so they can be sued. So under section 66, 67, infringement or passing of the person who is trying to sell the fake products can be put under this particular act. So there will be penalty also under section 39 and section 40 for selling or selling a false GI product or promoting such items. Accordingly, the infringement attracts an imprisonment of up to minimum of 6 months, up to 3 years, and there is a penalty in terms of finances like monetary expenses. Then in this particular registration, geographical indications registration, there are some formalities which need to be followed. So the statutory fees just 5,000 rupees and submission of a GI application. How, on what basis you can say it as a GI? Because it should have a history. It should be very popular. And who are the producers and where all they are marketing right now? And what is the possibility of scaling up the market avenue? So all these information needs to be given, and technical aspects are loaded. For example, if it is a food, then you have to give the details about what are the raw materials, how the ingredients are mixed, whether it is cooked, baked, sieved in the form of, like powder you are going to serve or a liquid, whatever it is, you have to give the complete technical details. If it is textiles and textile related information, you have to give. So then it is the people who are applied for this, the group of people, they will be called for an examination. When examination, during that they find it suitable, it is applicable under GI, they will grant the GI. And it is valid for 10 years. Afterwards, renewal is required. And who are all the parties to this? The artisans, I told you, are the producers. They can be registered individually. They are called as authorized users. They can only make and sell the GI. So they will be registered under this. For any business, some particular protocol is required. As you follow some protocol to do experiment in the laboratory, here also in the manufacturing, some protocol is required. So because that in the business always you have to maintain the quality and the standards, otherwise very soon it will be rejected by the customers. Always customer is the king. So a few years back, this Alfonso mango, which is very aromatic, which is very tasty. The size is very, pulpy, and it is very popular from that west coast region of India, like Maharashtra, right? Goa. So this particular mango was registered under geographical indications, but there was some problem when they tried to sell it because of the quarantine regulations. So in the year, I think 2013, there was some problem because these villagers, the landholders, they grow in different orchards, right? It is not from one particular orchard, all these mangoes. Uh, because there must be some problem why maybe while plucking or storing or transporting, so it was rejected, but they had to standardize all those things and they did it, and in the next year they could continue their market, the export business continue. So always, whether it is a food stuff or whether it is something like textile or some craft like toys, so any of these things should meet the customer expectations, because when you say Banaras silk saree, it should be qualified under that particular silk saree tag, right? It should have, just by appearance, look or touch, it should qualify those things. So unless it qualifies, customer will easily reject it. That's how, the fake are you listening?
Yes, ma'am. Yes, ma'am.
Okay. So customer should give a proper feedback. He should be satisfied. Then only the goods can continue in the market. So whatever registration you take up, but customer satisfaction is very important. Because these GIs, geographical indications, they generally origin from a very rural background area. So most of these people, they are very artistic in their work. They are most of them are not literates. Though they are educated, they are not literates. So it is necessary for us to work with them, make them understand the importance of these geographical indications, the knowledge they possess, and make them come together to take up registration. So when we work with these remote areas in the villages, in the mountains, in the valleys, we have to use our own strategy to make them understand this IPR regime, the importance of this IPR regime, importance of their knowledge, importance of that particular goods, the requirement of these particular goods in the market. Because always they work with some mediators. They grow something, some mediator will come there to that particular area in the season. They will collect, they will go and sell it in major markets with their own price. So these people who are working in a very rural area, remote area, they don't know exact value of that particular goods, exact value of their intellectual ability to make those items. So we have to use a lot of various strategies to make them understand the importance of this particular business. So when we were working with Uttarakhand, where is Uttarakhand? Yamunotri, Gangotri, all those you must have heard. So in that area, Jim Corbett National Park area, when we were working there, this Uttarakhand Tejpath. What is Tejpath? Can you tell me? Anybody? ತೇಜ್ಪತ್ತ ಅಂದ್ರೆ ಗೊತ್ತಾ?
Yes, ma'am.
ಚಕ್ಕೆ ಅಂತ ಹೇಳ್ತಿರಲ್ಲ ಇಲ್ಲಿ, ಅದ್ರದ್ದು ಎಲೆ. In North India, they use these leaves, bay leaves. Generally they are called. So this tejpath is used. Palav ele ಅಂತ ಹೇಳ್ತಿರಲ್ಲ ಇಲ್ಲಿ, ಅದು. So this tejpath is very popular from Uttarakhand, and it is sold in Delhi market. So the importance of this geographical indication is, these geographical indications are registered in most of the country, many countries. And here there is a case I wish to bring it to your notice. You must have heard about this tequila, right? It is a kind of alcoholic beverage, tequila. So the tequila is very popular from South America. But in USA also, so this some group they have come up with again the alcoholic beverage, and they try to name it as tequila. Okay, they try to make it as a generic, some kind of generic name. Then the US Department Treasury has classified tequila as a distinctive product of Mexico and prohibited the labeling of bottles as tequila if the product was not manufactured in Mexico in compliance with the Mexican laws. Okay, so once this name is registered anywhere, it should be from that particular area only. So it cannot be something generic. You cannot use something like soap. What soap it is? If it is soap, right? It should be from a particular uh, origin. For example, Mysore sandal soap, right? So it should be produced in Mysore sandal soap factory only. It cannot be from somewhere else. You cannot call it, if it is from somewhere else, you cannot call it as a Mysore sandal soap. In the same way, this tequila has gained its protection, though it is registered in Mexico. So tequila cannot be generalized name when it is used for other alcoholic beverages which is produced in other parts of the world. So that's how the geographical indication registration is quite strong. So benefits of regional development. Last year how everybody suffered during the lockdown. The laborers who came for the urban area for some kind of work, labor job, they could not go back so easily. So there was a lot of problems associated with this. So if we can identify the knowledge, the skill they possess, these rural people, we can make some kind of livelihood for them so that they will continue their livelihood.
Ma'am, you are not audible, ma'am.
Have. So it is necessary to go for registration, identify their knowledge, protect their knowledge, so that the rural exodus will not happen. Okay, it brings value to the region of origin. It empowers the producer community with power of bargaining. When they know the value of the product, they can bargain with the customers, right? Otherwise, they will end up with the mediators, and mediators will gain more than the actual producers. So it prevents rural exodus. So why there is so much population in urban area? Because everybody will come in search of some job, some kind of livelihood to urban area. So if they can find some satisfactory livelihood in their own place of origin, this urbanization can be limited. And we know that there are so many problems associated with these major cities. So the rights of the registered proprietors are to authorize the exclusive use of GI. So only who are registered under that, they can make, manufacture and sell it. No other person, outsider, cannot manufacture and sell it in the same name. To obtain relief in respect of infringement by unauthorized users, to administer the GI as a legal guardian. So to promote some of these GI goods, this horticulture department has announced that they will provide financial support to the people, the farmers who are growing this mallige, huvina hadagali mallige, right? So this is also one of the registered goods, and Udupi mallige is also registered. So there are many government programs which support these GI registered goods to promote the activities. And here there is a map, you can see India map, and this is actually the earlier old map, GI map. And there are many various goods which are producers which are popular in this country. There are hundreds and thousands of goods which are popular, but everything is not registered so far. There is ample opportunity for registration, but it is happening little slowly because lot of paper. Naga chili. Again, it is a different kind of chili. So there are various agriculture and horticulture producers which which are which have a distinct taste, aroma, and shelf life. So this there is an ample opportunity for these agricultural goods to register under IP. So here you can see these are some of the websites which help if somebody is interested to do business, to import export business. So this agriculture processed food products, this is a processed food. Okay, Export Development Authority. If you go to the website, you can see which country requires what and what standards, in what standards they are accepting these agriculture produce. And India Trade Portal, this is another website if you can see. So what is the requirement from Bangladesh, Belgium, Brazil? Here you can see. And there are so many other events they have, and they say what standards they are expecting, what are the quarantine laws, regulation, what's the quantity of commodity, from which port they are doing the business. So all this information is available in this particular website. And in Karnataka, Bangalore, VTPC is also playing a prominent role in developing and promoting business activities. Then like that, there is MSME also. Then this is one example. You can see rose flowers. So this is Hosur Rose, which is recently registered, and already they are doing business, online marketing they are doing. And this is from Tripura, pineapple. Tripura pineapple is very popular, which is which has soft, sweet pulp. Generally here, when you eat pineapple fruit, you may feel some kind of, tinging on your tongue. But here it is very soft and very sweet. So after registration, by the horticulture department, they form the group and they are producing in large scale. They are maintaining all the standards, and already they are exporting to Dubai and Middle East. So I was involved in another registration, which is called as Idu Mishmi. So this is a tribal community from Arunachal Pradesh in Northeast, and their weaving is very attractive. The textile is very attractive. So I wish to bring your notice to the earlier GATT agreement, STEEP agreement. And during that time, there was another convention called International Convention on Biological Diversity. So there was a Rio de Janeiro summit which happened in 1993. So the mandate of this particular convention was conservation of biological diversity, sustainable use of biological resources, and equitable benefit sharing of income generated through biological resources. So these are the mandates. And there were 193 biodiversity board. They will look after the aspects related to biological diversity, conservation, sustainable utilization. Okay, so under this popular. So whenever the VIPs they visit this Arunachal Pradesh, they were honored with their attire, their coats, the ladies were given a wraparound. So this is very popular throughout Arunachal Pradesh. It is from a particular tribal community called Idu Mishmi tribes. Okay, so when I was looking into this particular aspect, because everybody generally they wear this dress every day, they wear this dress, this kind of dress, the local people. I was looking at them and thinking this is something special. Of course, weaving is quite popular in Northeast India, in Arunachal Pradesh, among other tribes also. But this is something which is different, very attractive with the colors and the motifs. Only you can see geometrical patterns. There are no birds, leaves, flowers, human icons in this weaving. Only geometrical, designs, patterns, diamonds, lines, okay, squares, maybe sometimes some small circle. So lines, so these are very prominent. So what it represent? When I was talking to those ladies, I understood when they started telling. See, when they look at the uh, ants, when the ants are disturbed, they move in these particular different directions. Akua. So that's how when you disturb the black ants, they move. This is how they move. They said. Then they say that when the bamboos are stalked together, it appears like a ambushu, they said. So these are the observations, isn't it? Then when somebody walks up the hilltop and observe the farmland, it appears like this, Malejo. That's what they said. This is how the farmland looks. And the feather of a bird, ambo, they said. So these are some of the observation. Whatever they have observed in the nature, they try to bring it into their weaving. And it became very complicated, very intricate geometrical patterns. Can you imagine this? This can also happen. Here in South India, we do rangoli, right? We make a scale with the dots, and then we try to connect with lines, and we bring out the rangoli. But for them, there is no rangoli. Whatever they have observed in nature, they try to bring it into their weaving. So don't think that your biology, biotechnology, textile, food, it is different. Everything is connected, right? So after working with them, and developed this application and registered. So they got, we made a society and they got this particular certificate, their, geographical indications for Idu Mishmi textiles. And to promote these kind of activities, they have opened a shop, the outlet at Government of India has opened an outlet at Goa airport, because footfall is very high in Goa. Many people, tourists visit. So whatever so far registered in India, geographical indications registered goods are available in this. And other airports also, they are trying to do that outlet. And during lockdown period, there was online showcasing of these India's rich geographical indications heritage. So it was very, popular. This program was very popular, and many goods were registered under this, and it was displayed, and it helped to develop the business even during the lockdown time. And there is a possibility for this tourism. So GI tourism. Can you think of GI tourism from Hampi to Udupi, Bangalore? There are so many goods like during the in that Hampi area. If you take the tourist, apart from seeing the historical monuments, they can think about, you can make them visit this Kinhala, right? Then you can bring them to Bangalore. They can enjoy the grapes, Bangalore grapes, and you can take them to Mysore. There are so many products like Nanjangud Raswale and other things. Nanjangud Mysore Viledele, all these are very popular. Then take them to Coorg region. There are many different types of coffee, orange, which are registered, which are very popular from that region. Then take them to Mangalore side, Udupi. Peppers are registered. Then Udupi sari, which is registered there. So they can enjoy this, and that kind of tourism, GI tourism, is very popular in European countries. So that is why you need to understand, of course, you are studying biotechnology, but basic understanding of biology about the plants and animals, which is very, very relevant, which is very important for you. When you think about the plant kingdom, it is a composition of many different kinds of plants, trees, small herbs, climbers, right? So there are a lot of varieties. Then classification, when you start looking into that, you can say there is the lowest classification is species, but even again species under species, there may be varieties, right? It may be due to color, size, right? Then height. So there are various aspects associated with varieties. So that's how, when you think about a variety, can you register it? If you can develop a new variety, for example, through your tissue culture, you can come up with a new variety, which may be a disease resistant, which may be producing more number of flowers, horticulture plants, which are very attractive, right? So if you think about any variety, which is a subcategory of a species, if, for example, in this picture, I'm trying to show you tomatoes, which are of different shapes, maybe taste also, right? And these are peppers. They're same species, but the size, the color is different, aroma is different. So this is how, when you come up with a new variety, it may be like color, aroma, taste, pungency, right? Then it may be a disease resistant variety, it may be insect resistant variety, or something which can grow in a saline water, the paddy which can grow in a saline water in the coastal region. If you have come up with a new variety, that can be registered. So this Plant Variety Protection Act is there, and under this, the new plant must be novel, which means that it must not have been previously marketed in the country where rights are applied for. The new plant must be a distinct from other available varieties. The plant must display homogeneity. When you breed it for several generations, it should continue F1, F2, F3. It should continue with the characters for which you are trying to claim as a new variety. Okay, the protection can be obtained for a new plant variety. However, it has been obtained through conventional breeding techniques or genetic engineering. What are the conventional breeding techniques? Like through the seed crossing, right? Then through the seeds, then by budding, crafting. So all these are the conventional practices of breeding. Then through tissue culture or genetic engineering, if you have come up with a new variety, you can register. So this is the website. If you want to learn about this protection of plant varieties and Farmers' Right Authority of India, they have a website. You can check this website, whichever new variety which is released, which will come up in this, and all the details you can see here. And this is a journal, Plant Variety Journal of India. So all the updates you can see here. And PGR, Plant Genetic Resource Portal. Okay, this is again National Bureau of Plant Genetic Resources. Here you can check. I have just taken the clipping. Crop plant name you can type if you know, then accession number. So just if you try with plant name, it will come, and further you can keep trying if you want to find more details, biological status, from where it is produced. So all this information you will get. Then, for example, Tinospora cardifolia. This is a medicinal plant. You may be aware of this plant. In Kannada, it is called as Amruta Baldi, right? So, if you want to know about the genetic sequence or where all it is produced, so all the information is available here. Already, a lot of work is done. So, here in the database, if you go to the database page in that particular website, these are the information you can see here. And there is an app also, IPPGR app. So in the same website, you can find link to that, you can download. So whichever plant, whether it is agriculture plant, horticulture plant, medicinal plant. So all the information is available, like up to gene sequencing. And apart from that, if anybody has applied for a new variety under that, so you can, or already it is granted, you can find the complete information in this particular app. So there was a lot of discussion which happened with the BT brinjal, right? BT cotton and BT brinjal developed by Monsanto in India. So this particular brinjal, generally it will be, you know, when you go to market and try to buy, you can see some holes on the brinjal. So you don't like to buy because already some kind of infection has happened and destruction has happened. You will find some worms in that, caterpillars. You don't like to buy that. So market value is reduced. So to avoid that, this particular Briti brinjal is developed. So this particular Briti brinjal is developed to combat against the caterpillar So crystal 1AC protein was introduced into the BT brinjal through genetic engineering technique. You may all know that the details of the technique. I'm not going to tell already. I think time is exceeding. So that's how this particular BT brinjal is developed, because it is a crop which you are using it regularly and it is a matter of consumption. Most of the people, they don't like to use this genetically modified engineered food stuff, right? So there was a lot of agitation which happened during the release of this particular is the naturally available brinjal. This is Mattugu from Udupi, which is geographical indications registered. So if you can see this, very so span time something like BT brinjal. So when you go for any research, think whether it is really needed. Some product you have to produce it to the society. Don't try to do it just to do some business. So think whether it is really relevant, applicable or not. Because of its taste, because of the ease of production, right? So you can store it for long period. Shelf life is long. So these are some of the aspects you need to consider when you take up any kind of research. Okay, techniques you need to learn. Yes, it is very relevant to understand the basics. You have to learn the techniques. But when you think about the research and commercialization of the goods, you have to do a thorough, observation, study, understanding, then think about scaling up and marketing it. Okay. Then here is a graph. This is a big business. So this seed business or the agriculture, when it is considered as a business, there is a huge market for this. So this Chenpatna toys, you must have visited and you must have bought so many articles from Chenpatna, right? So Chenpatna toys are made out of Halemara, Raitia, Tinctoria, which was available in large scale in that particular location in and around Chenpatna earlier. No much resource available in that particular area. So if you don't restore the natural resources, we cannot think about our survival, because we have to, survive. Our survival is dependent on plants and animals. Plants and animals can live without us, but we cannot live without them, right? It is our livelihood. We have to secure them to secure ourselves. So within a short time, I try to, give you some information about this natural resources and associated information on IPR, GAT, and PGR, plant variety protection. So if you are interested, you can have some more session so we can discuss in detail. Thank you very much.
Thank you very much for the amazing presentation, ma'am. The platform is now open for question and answer session. Kindly put your queries in the chat box.
Ma'am, can you read? I'm unable to.
Yes, ma'am. She is
There is
going
any
to.
question?
Yeah, please, whatever the questions you got, Pallavi, just ask that, no?
Sure, ma'am. Sure.
Can I close the presentation?
Yes, ma'am.
Yes,
Yes, ma'am. You can
so
stop
we
short,
have got
ma'am.
a question asking for the similarities between geographical indications and patents, ma'am. This is from one of our students. They are asking for similarities between geographical indications and patents.
Okay, the very basics of patent is something which should be non-obvious. Okay, which is non-obvious, which should not be natural on its own. But here, when you consider geographical indications for goods like a crop, particular variety of crop, which is a natural element, but there is some intervention by human. So he must have used some techniques like breeding techniques or storage techniques or something. He must have selectively used some particular varieties and bred it over the period and developed that particular variety. So it became very popular over the period. For example, I showed you that Matagula brinjal, right? So probably somebody, we don't know who, or a group of people, they have selected from the wild Solanaceae members, they must have selected and they have started breeding this particular variety. And they have found that this is very unique and which is very much required. So the agriculture practices have developed over the period for that particular crop. So like that, this is a kind of innovation, but many people are involved, not just one or two people are involved in this particular innovation. So this is a collective right. Geographical indication is a collective right, whereas a patent may be an individual right.
Yes, ma'am. Thank you. There is one more question. This comes from one of our faculty. What is the duration for protection of geographical indication?
So actually, once you registered, it's registered. Okay. Generally, it is for 10 years, but afterwards, you need to renew it. There is nothing called expiry, but renewal is required because always when you consider patent, use it or lose it. When you don't use it, you cannot climb over that. For example, any kind of patent or even something like a trademark, when it is registered, you have to use it. You cannot just register it and keep it. This quite happens in terms of, film industries. They register just the title and they will keep it for 2 years, 3 years, and other person cannot use it. It comes under copyright, whatever. But I'm telling you, any patent is something which you have to use it, execute it. You have to make it into a business model and execute it. Otherwise, somebody will come and use it. So this registration is given for 10 years geographical indications, and further it should be registered, renewed.
Yes, Pallavi, proceed.
Yes, ma'am.
Any other question? You can ask also, no problem.
Ask this question. Last one. You just ask it and finish off. She's screaming from there.
Thank you, ma'am. There is one more question. What are the similarities between geographical indications and patents?
I think just I answered that question. That's over.
Sorry, ma'am. Royalty will be given to patent. Likewise, GI also given royalty.
Yeah, it is a business practice. When you register something, you have to do the business. So it will promote. It can be in terms of sharing of the profit, right? Or generally royalty when you think it will come for the copyright. But here it is more of a business practice. They have to share the whatever profit they get among the producers, and also they have to reinvest again to promote it further.
Thank you. Thank you for the wonderful session, ma'am. Now moving to our fourth technical session, I request.
Thank you, ma'am, for your presence and gracing this occasion, and thank you for accepting our invitation, ma'am. On behalf of KLSNC Principal Management, we express sincere thanks to you, ma'am. Thank you so much for joining us, ma'am. Thank you so much.
Thank you.
Now over to Trupti.
Thank you, ma'am. Now moving on to our fourth technical session, I request Dr. Head Department of Biotechnology, welcome sir to fourth technical session, Mr. B. Vivekanand Sagar. Over to you, ma'am.
Thank you, Trupti. I would like to welcome young, energetic, enthusiastic, ever charming invited guest speaker, Mr. B. Vivek Anand Sagar, IP attorney and consultant KCST. On behalf of KLE Society's management, yes, Nijlingappa College principal, heads of various departments, esteemed colleagues, delegates, and also on my personal behalf, I welcome you, sir. Thank you for joining us. And thank you for your unconditional support in conducting this today's workshop on IPR and biotechnology, sir. Welcome to you, sir.
Thank you, ma'am. Now I request Mr. Rajiv R. Potdar, Faculty Department of Biotechnology, to introduce technical speaker, Mr. B. Vivekanand Sagar. Over to you, sir.
Thank you, ma'am. My privilege to introduce session 4, Mr. Vivekanand Sagar. He has completed his master's in law and business law from Biotechnology, Shimoga in the year 2012, postgraduate diploma in human resource management from Coimbatore University in 2012, MA in sociology, Coimbatore University 2014, and is currently pursuing his PhD on enforcement of copyright issues in film and recording industry in CMR University. Sir has secured first rank in Masters in Law and independently practicing as advocate in Bangalore in the field of IPR and civil litigation. Sir is guest faculty in Ramaya College of Law, Bangalore. He is an international consultant in Cumming International Center for Arbitration and Mediation, a consultant in Karnataka State Council of Science and Technology, IASC Bangalore, honorary designated as Research Associate for Center for Intellectual Property Rights, Research and Advocacy, Ministry of Industry and Commerce, Government of India on IPR, National Law School of India, University, Bangalore. Mr. Vivekanand Sagar has published research papers and articles, various books and journals. He has been invited as a research person from various institutions and organizations. He has delivered guest lectures on subjects like intellectual property rights by Ministry of Micro, Small and Medium Enterprises. So I thank you, sir, for accepting the invitation.
Thank you very much for inviting for this particular 2 days program organized by KLE College. So, as you have already been having a, what do you say, lot of understanding on the patent subject matter, patent filing, or the PGR, or how traditional knowledge have an implications on intellectual property rights. Now, apart how we have under intellectual property rights as a bigger umbrella, we have copyright at one place. We have, as you have yesterday, we have gone through the patents in an international scenario, how it's working on the biotechnological aspects. Then coming to Indian situation with respect to patent filing, how does it happen? How patents are done on biotechnological related inventions. Today we spoke about additional knowledge and its implications on intellectual property rights. And here is another set of IP called as copyrights. So today we are going to, in this particular session, we will discuss about the copyright and its implications on the biotechnology related works, research work. Okay. And when you say biotechnology, it is more fully that it is involved with lot of research and development. Any such research and development and such intellectual output are entitled for certain intellectual property protection. What are those? For example, if in this biotechnology department, one person comes out with a biodegradable mask. Okay, because today that's one of the major problem which we are facing. So he comes out with a biodegradable mask, and the mask has such kind of a feature with various biotechnological intervention. He has made such a mask that even if you throw it in, first it gives appropriate protection from the viruses. That's the first major objective. Then it is also little, what do you say, able to have its durability in the use, effectiveness, and once it is used, when you dispose it off, it should not cause harm to the environment. Hence, it should be degradable, biodegradable. So these are the things which you have done. Now tell me, my dear sir and madam, now you have come out with this kind of a mask, a biodegradable mask. I can see the chat box. Hence, I hope all the participants are able to put up their chat answers in the chat box. Hence, I would like to pose this particular question. And the question is, can you tell me what, if I have come out with this innovative biodegradable mask, what kind of an IP I'm going to file for? What kind of a protection I'm going to get? Can anyone put up some kind of chat answers in the chat box, please? Dr. Rizwan, sir. Mr. Dhanush. Yes. Okay, Dr. Savita madam says. And what about others? Rizwan sir, Miss Ranjita, 4th semester. Miss Sona, Miss Amruta, Akash, Ananya. Ananya, are you there? Miss Anjali? Hello, please. There is an attendance being taken. Kindly answer your attendance, please. Miss Anusha? Anusha absent?
Present, sir.
Madam, present is fine. What about the answer? Rizwan says no idea. Trupti says patent. Okay, what about others? Mr. Bhaskar Gowda? Dhanusha says no. Okay. Bhavya? Bindushri? Bhaskar Gowda is present. Good. Mr. Naveen? Rakshita? What about you people? Can you kindly answer, please? Miss Harshita? Mr. Jayant? Jayantilla? Miss Komala? ಮಿಸ್ಟರ್ ಜಿತೇಂದ್ರ, ಯಾರ್ಯಾರ ಹೆಸರು ಕರೆದವ್ರು ಏನು ಉತ್ತರ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವೆಲ್ಲ ಔಟ್. ಮಿಸ್ ಸ್ನೇಹಾ, ನಿತಿನ್ ಅವ್ರು ಇದ್ದೀರಾ? PS ಮಾನಸ, Barka Goyal says yes. Mr. Pujo, CPPT 70. Priyanka, Ram Prakash, no. Miss Ramya, ರಮ್ಯಾ ಇಲ್ಲ. ರಾಮ್ ಪ್ರಸಾದ್ ಇದ್ದಾರೆ, ರಮ್ಯಾ ಇದ್ದಾರೆ. ಓಕೆ, ಗುಡ್. ನಿಮ್ ಮೇಡಮ್ ಭಯ ಆಗ್ತಾ ಇದೆ ಅಲ್ಲಿ, ನೀವ್ ಯಾರು ಉತ್ತರ ಹೇಳ್ತಾ ಇರೋದ್ ನೋಡಿದ್ರೆ. ಮಿಸ್ ರಂಜಿತಾ, ಆರ್ ಯು ಪ್ರೆಸೆಂಟ್? ಇಲ್ಲ, ರಂಜಿತಾ ಆಬ್ಸೆಂಟ್. ಓಕೆ. ಮಿಸ್ ಸಂಜನಾ, ಅಟೆಂಡೆನ್ಸ್ ತಗೊಂಡು ಸುಮಾರು ಆಗಿರುತ್ತಲ್ವ, ಸ್ವಲ್ಪ ತಗೊಳ್ಳಿ. ಮಿಸ್ ಸಂಜನಾ, ಜನ ಇದ್ದಾರೆ. ಓಕೆ. ಸಪ್ತದೀಪ್, ಶ್ರುತಿ ಎಂ, ಶ್ವೇತಾ 4th semester. No answer, absent. Shweta, Spandana GR, Shruti M present. Okay. Sushma madam, 7th semester. Idu second semester. Spandana is present. Okay. Tejaswini. Okay. You are unable to unmute. No, fine. You are unable to unmute. At least say yes or no, at least in the chat box. Okay. Tejaswini present. Okay. Trupti, ಮುಂಚೆನೆ ಹೇಳಿದ್ರು ಅನ್ಸುತ್ತೆ. ಓಕೆ. ಹರ್ಷ, ವಿನಯ್ ಕುಮಾರ್ ಪ್ರೆಸೆಂಟ್. ಓಕೆ, ಗುಡ್. ಸುಮ್ಮನೆ ಇದನ್ನ ಚಾಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಎಸ್ ಆರ್ ನೋ ಹೇಳಿ ಸಾಕು. ವಿವೇಕಾನಂದ್ ಡಿ, ಅದ್ ಮೋಸ್ಟ್ಲಿ ನಾನಲ್ಲ ಅಲ್ವಾ? ಓಕೆ. ವಿವೇಕಾನಂದ್ ಡಿ, ಸಿ ನನ್ನ ನಂತರನೇ ಯಾರೋ ಇನ್ನೊಬ್ಬ ಪರ್ಸನ್ ಇದಾರಲ್ಲಿ. Okay, so Tejaswini present. Okay, let us see technically how many are present. Tejaswini is Spandana, Satyadeep, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 ಜನ, 14, ಒಂದು 14ರಿಂದ 15 ಜನ ಇದ್ದೀರಾ. What about others? ಇವಾಗೆಲ್ಲ ಬರ್ತಾ ಇದೆ. ಯಾರೋ ಫ್ರೆಂಡ್ಸ್ ಹೇಳಿರ್ತಾರೆ ಅಲ್ಲೊಂದು ಮೆಸೇಜ್ ಹಾಕೋ ಎಸ್ ಅಂತ ಎಲ್ಲ ಪಟ ಅಂತ ಬರುತ್ತೆ. ರೈಟ್? ಸಿ? ಓಕೆ. At least I have 15 people and that's more than enough for me. Okay. Yeah, more than enough. ಸಾಕು, ಇನ್ಯಾರು ಜಾಸ್ತಿ ಮೆಸೇಜ್ ಮಾಡಬೇಡಿ ಪ್ಲೀಸ್. ಅದನ್ನ ಓದ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳೋಕ್ಕಾಗಲ್ಲ. Yeah. So let us now, as I was telling, see, all that which I require is interested. Even 15 people are there, that's more than enough. Number doesn't matter, it is only the interest matters to us. Okay, let us as I was telling you that patents we came to know. We spoke about a particular invention which you have come out with, okay, which is a biodegradable mask. And this biodegradable mask, what kind of an IP which you are going to protect? ಅಂತ ನಾವು ಪ್ರಶ್ನೆ ಕೇಳಿದಾಗ ಮೆನಿ ಪೀಪಲ್ ವರ್ ಪರ್ಪ್ಲೆಕ್ಸ್ಡ್. ಸರ್, ಯಾವ ಪ್ರೊಟೆಕ್ಷನ್ ಸಿಗುತ್ತೆ? ನೋ ಐಡಿಯಾ ಅಂತ ಸುಮಾರು ಜನ ಹೇಳೋದು. ಮೆನಿ ಪೀಪಲ್ ಸೆಡ್ ದಟ್ ನೋ ಸರ್, ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ಎನಿ ಐಡಿಯಾ. ಬಟ್ ಮಿಸ್ ತೃಪ್ತಿ and Dr. Savita madam, both of them rightly pointed out that, sir, if I have come out with a new innovative mask, so your mask is an innovative mask because you saw what the earlier masks were. Andre, you made a prayer art search. What is a prayer art? That you had a cloth based mask, you had the plastic based mask, okay, or N95 mask. So these are all the various kinds of masks which you saw, which is not degradable. So when you made a study on all these things, so you came out with a better filtration process, better protection process, better biodegradable process. And this better is nothing but called as innovative. Invention is something, a wheel, a stone wheel which was brought is an invention. But today we have tubeless tires, today we have punctureless tires, today we have in various other kind of tires, and this tire is an improvement, and that is called as innovation. Invention is first time you do, and anything improvement over that particular thing is an innovation. So such innovation, if you have done, it is entitled for patent protection. Okay, because of what are the, okay, why do you, how or why do you file a patent for it? Can anyone, okay, this is my another question. Can anyone say, why do you file a patent? What was there in your product? What is that thing which you identified in your product? It's a inventive one, but to file a patent, what is the requirement? Can anyone say what is the requirement for a patent? Ms. Ranjita? Register? No, Rizwan sir. I'm asking what is the requirement for a patent? Ranjita, Rajeshwar, Anjanadri, Rupa, please. Dr. Rizwan say first file the patent. No. Yes, Dr. Savita madam rightly says it requires an inventive step. Okay, and Dr. Saeed says to protect the unique feature from being used freely by others. Very correct. And we have Mr. Nandita says protection for their innovation, novel idea, and useless innovation filed by will lose your idea. ಭಾಸ್ಕರ್ ಗೌಡ್ರೆ, ನಾನ್ ಕೇಳಿದ ಪ್ರಶ್ನೆ, ಇವಾಗ ಒಂದು ಹೊಸದಾಗಿರೋ ಮಾಸ್ಕ್ ಮಾಡಿದೀರಾ, ಅದು ಯೂಸ್ಲೆಸ್ ಯೂಸ್ಫುಲ್? ಇಟ್ಸ್ ಅ ಯೂಸ್ಫುಲ್. So if it is a useful innovation, you will lose your idea. I don't get your point, Mr. Bhaskar. Okay. Nevertheless, Dhanush ಹೇಳ್ತಾರೆ capable to be help society. No, Dhanush, capability to help society is not a requirement under a patent. As earlier said by Dr. Savita madam, that it requires inventive step. one characteristic ಹೇಳಿದ್ರೆ ಇನ್ನ ಎರಡು ಹೇಳಬೇಕು. ಯುನೀಕ್ ಫೀಚರ್ ಏನು, ಅದೇ ಇನ್ವೆಂಟಿವ್ ಸ್ಟೆಪ್ ಒಂದೇ, ಇಟ್ ಈಸ್ ಮೋರ್ ಆರ್ ಲೆಸ್ ಒನ್ ಆನ್ ದ ಸೇಮ್. ಬಟ್ ವಾಟ್ ಇಸ್ ದ ಅದರ್ ವರ್ಡ್ ವಿಚ್ ಯು ಕ್ಯಾನ್ ಯೂಸ್? ಡಾಕ್ಟರ್ ಸಯೀದಾ, ಡಾಕ್ಟರ್ ಪ್ರತಿಭಾ ಮೇಡಮ್ ಹೇಳ್ತಾರೆ ಸರ್ ನಾವೆಲ್ ಐಡಿಯಾ. ಎಸ್, ಸೊ ದ ಫಸ್ಟ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಫಾರ್ ಪೇಟೆಂಟ್ ಇಸ್ ಇಟ್ ಶುಡ್ ಬಿ ನಾವೆಲ್. Second, it should be inventive. It should be have an inventive step. Third, what is the third? What is the third requirement? It must be novel idea and useful to the society. See, useful to the society patent requirement illa sir. ನೀವು ಮಾಡುವಂತ ಇವಾಗ ನೀವು ಒಂದು ಪೆಸ್ಟಿಸೈಡ್ ಒಂದು ಏನೋ ಆಟಮ್ ಬಾಂಬ್ ಇನ್ವೆನ್ಷನ್ ಮಾಡ್ತೀರಾ, ಆಯ್ತಾ? ಸೊ ಅದು ಯೂಸ್ಫುಲ್ ಯೂಸ್ಲೆಸ್? ಅಟಾಮಿಕ್ ಎನರ್ಜಿಯಿಂದ ಎನರ್ಜಿ ತಗೊಳ್ತೀರಾ, ಒಂದು ಬ್ಲಾಸ್ಟ್ ಮಾಡಬಹುದು, ಇನ್ನೊಂದು ಎನರ್ಜಿನೂ ತಗೋಬಹುದು. ಯೂಸ್ಫುಲ್ ಯೂಸ್ಲೆಸ್? ಸೊ ದಟ್ಸ್ ನಾಟ್ ದ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಫಾರ್ ಅ ಪೇಟೆಂಟ್. So Bhaskar Gowda said, sir, it's not like that, sir. You should first file patent. Sir, to file a patent, what is the three requirement? Patent file ಮಾಡಕ್ಕೆ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಏನು ಅದನ್ನ ಹೇಳಿ ಫಸ್ಟ್, ಆಮೇಲೆ ಫೈಲ್ ಮಾಡೋಣ. ರಿಕ್ವೈರ್ಮೆಂಟ್, yes, Bhaskar Gowda now he rightly says industrial applicability. Correct. So To file a patent, first you should know whether your invention is novel, whether it is non-obvious or industrial or inventive step. Third, whether it is industrially applicable. Anusha correct ಹೇಳ್ತಾರೆ. Anusha madam, you are correct. That offers a technical solution to a problem. Of course, ಒಂದು technical solution to the problem ಕೊಟ್ಮೇಲೆ ತಾನೇ innovation ಆಗೋದು. Yes, now Bhaskar Gowda rightly says novelty, non-inventive step and industrial applicability. So these are the three major requirement for a patent. Now you have done this particular mask. Now you think that okay, ನನ್ನ ಪ್ರಾಡಕ್ಟ್ ನಾವೆಲ್ ಇದೆ, ಇನ್ವೆಂಟಿವ್ ಇದೆ, ಇಂಡಸ್ಟ್ರಿಯಲ್ ಅಪ್ಲಿಕಬಲ್ ಅಂದ್ರೆ ನಾವು ಮಲ್ಟಿಪಲ್ ನಂಬರ್ ಆಫ್ ಕಾಪೀಸ್ ಅಲ್ಲಿ ಅದನ್ನ ರಿಪ್ಲಿಕೇಟ್ ಮಾಡಕ್ ಆಗತ್ತಾ ನಿಮ್ ಪ್ರಾಡಕ್ಟ್ ನ ಅಂತ. ಸೊ ಇಫ್ ದಟ್ ಇಸ್ yes, then now you go and file a patent because all these three criteria is fulfilled. Okay, so this is how you go for a patent. So that is one area. But what about the subject matter which I am telling about today's topic, that is copyrights. Copyrights ಅಲ್ಲಿ where do you find the intervention of copyright in biotechnology? Yes, ಭಾಸ್ಕರ್ ಗೌಡ್ರೆ ಒಂಚೂರು ಹೇಳ್ತೀರಾ? ಅನುಷಾ ಮೇಡಮ್, ನಿಮಗೇನಾದ್ರೂ ಬಯೋಟೆಕ್ನಾಲಜಿಯಲ್ಲಿ ಎಲ್ಲಿ ಕಾಪಿರೈಟ್ ಬರುತ್ತೆ ಅಂತ ಅನ್ಸುತ್ತೆ? ಎಲ್ಲಿ ಕಾಪಿರೈಟ್ ರೆಲೆವೆನ್ಸ್ ಇದೆ? ಏನಾದ್ರೂ ಒಂಚೂರು ಹೇಳಕ್ಕಾಗತ್ತಾ? Just put one or two lines, one sentence is enough, or 2-3 words. Softwares, very good. Software ಗಳಲ್ಲಿ ಯಾವುದು ಏನು ನೀವು you have come out with a new microorganism, okay, and to know its behavior on a particular temperature, you feed it to the system and it will check how it is being reacted, and you feed that in the software and you will come to know what is that nature of it. Or you also do, now this coronavirus is there. Now to identify that this is a coronavirus, there is a particular imaging which you do and profiling you do and feed it to the system or a software which will identify what category of a virus is that. That software will give you the answer. So such software is entitled for copyright protection. That's absolutely right, Mr. Bhaskar Gowda. Bhaskar Gowdre, are you a teacher? Sorry, are you a teacher or a student? ಯಾಕಂದ್ರೆ ನಾವು ಭಾಸ್ಕರ್ ಗೌಡ್ರ ಅಂತ ಹೇಳಕ್ಕಾಗುತ್ತೋ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. Just put me in a message that are you a teacher or a student? Okay, Dr. Rizwan sir says database. Very good. So now the faculties comes out with or the student while doing research in his laboratory, aita, when he does a research in a laboratory, he study on a microorganism called as ಯಾವುದು ನಮ್ಮ ಆಯಿಲ್ ಸ್ಪಿಲ್ಸ್ ನ ತಿಂದಿದ್ ಯಾವುದು? ಚಕ್ರವರ್ತಿ ಅವರು ಪೇಟೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ ಯಾವುದು?
Pseudomonas.
Yeah, very good. So now this Pseudomonas, okay, not sir, I am a student. Okay, very good. Thank you, Bhaskar Gowda. ಹಂಗ ನಾನು ಮಾತಾಡ್ಬೋದು ಆರಾಮಾಗಿ. ಸೊ ಸುಡೋಮೋನಾಸ್ ಅನ್ನೋ ಒಂದು ಮೈಕ್ರೋ ಆರ್ಗಾನಿಸಮ್ ನ ಚಕ್ರವರ್ತಿ ಅನ್ನೋನು ಕಂಡಿಡ್ದ. ಅಂದ್ರೆ ಮ್ಯಾನ್ ಮೇಡ್ micro organisms na ಮಾಡ್ದ. He filed a patent for it. He got a patent. That's a different issue in United States. But coming to India, now to make this study, you would have made lot of research, lot of experiments, and this experiments and research you would have recorded in a particular data. This data are protected under literary works. This literary works comes under the ambit of copyrights. That is where it plays a major role. One more example I would like to give, where now various researchers, PhD scholars, are there any PhD scholars here? ಅಥವಾ ಎಲ್ಲ ನಮ್ಮ ಬ್ಯಾಚುಲರ್ ಡಿಗ್ರಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅನ್ನ? No problem. So whenever you publish, yes, there are okay. Saptadeep is a PhD scholar. Dhanusha, okay. So as you all rightly said, that you do a research and you collect and write papers. You write various research papers, get it published in various reputed journals and other journals. So when you do all these things, what happened? This, okay, Mahesh PhD, okay sir. So when you do this kind of research, this research results, research methodology, research process are all entitled for protection under the copyright subject matter. Is protected under the copyright subject matter. That is where, and it is not only about protection of it, but also that when you take someone's content, use someone's content, material or research work in your research, then appropriate references, endnotes, or you should not do any plagiarism, and this comes under the copyright subject matter. Okay, so this was a brief introduction about what is a topic which we are discussing today. It's about the copyright and what all it protects: your research database, your software, your research work, your literary work, or your photographs or graphs. When you make a study on the temperature of in what temperature does this virus sustain, or in what temperature does the capacity of the virus increase ಅನ್ನೋದೊಂದು ಗ್ರಾಫ್ ಮಾಡಿರ್ತೀರಾ ನೀವು, ಅಥವಾ ಯಾವಾಗ ಒಂದು ಪೀಕ್ ಆಗಿ ಹೋಗುತ್ತೆ ಮತ್ತೆ ಡೌನ್ ಹಿಂಗ್ ಬರುತ್ತೆ ಅಂತ ನೀವೆಲ್ಲ ನೋಡಿರ್ಬೋದು. ಇವಾಗ ಏನು ಮತ್ತೆ ಥರ್ಡ್ ವೇವ್ ಬರ್ತಾ ಇದೆ, ಅದು ಏನು ಮತ್ತೆ ಪೀಕ್ ಹೋಗುತ್ತೆ ಅಕ್ಟೋಬರ್ಗೆ ಅಂತೆಲ್ಲ ಪ್ರೆಡಿಕ್ಷನ್ಸ್ ಆರ್ ಆಲ್ ಕಮಿಂಗ್, ರೈಟ್? ಸೊ this prediction ಅಥವಾ the earlier study which you make about the nature and behavior of the particular virus, etc. and etc. are all entitled for copyright protection. Okay, so I think I have another 30 or 30 minutes time. So all this time which I have told is one, patents and copyrights and how it has an interface and connection. Second, I told what are the subject matters of copyright protectable subject matter. Third, we made one revision about the patent requirement. Patent protects only in the case of process or a product. ಯಾವ process ನೀವು ಒಂದು ಜೀನ್ ಅನ್ನ ಸಪರೇಟ್ ಮಾಡಕ್ಕೆ ಅಂತ ಮಾಡಿರೋ ಒಂದು process. ಓಕೆನಾ? ಹೌ ಡು ಯು ಸಪರೇಟ್ ಜೀನ್ಸ್ ಅನ್ನೋದಕ್ಕೆ ಒಂದು ಪ್ರಾಸೆಸ್ ಅಡಾಪ್ಟ್ ಮಾಡಿರ್ತೀರ ನೋಡಿ, ಆ ಪ್ರಾಸೆಸ್ಗೆ ನಾವು ಪೇಟೆಂಟ್ ಅನ್ನ ಕೊಡ್ತೀವಿ. ಆರ್ ಯು ಕಮ್ ಔಟ್ ವಿತ್ ಅ ಪ್ರಾಡಕ್ಟ್, ದ ಪ್ರಾಡಕ್ಟ್ ಸಚ್ ಆಸ್ ಅ ಬಯೋಡಿಗ್ರೇಡಬಲ್ ಮಾಸ್ಕ್ ಆರ್ ಅ ಪ್ರಾಡಕ್ಟ್ ವಿಚ್ ಏನು ನೀವು ಏನೋ ಒಂದು ಸ್ಟಂಟ್ ಹಾಕ್ತೀರಾ, ಅಥವಾ ಏನೋ ಒಂದು ಬಾಡಿ ಏನೋ ಒಂದು which degrades there inside the body and does not harm the people and solves a particular problem, and that is a product which you have come out with, and such products are entitled for patents. For example, Pseudomonas ge patent kottiddu product agi. Okay na? So these are the two major things which we need to be understanding. So on the process ge atho product ge patent ಕೊಡ್ತಾರೆ, ಆ process ಮತ್ತೆ product it should have novelty, non-obviousness, industrial applicability ಅನ್ನೋದೆಲ್ಲ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. So all those subject matter we understood, and I would like to thank ಇನ್ನು ಮುಗಿಸ್ತಾ ಇಲ್ಲ, I am not finishing the topic, but now itself I would like to thank Mr. actively participated ಯಾರು ಭಾಸ್ಕರ್ ಗೌಡ್ರು, ಡಾಕ್ಟರ್ ರಿಜ್ವಾನ್, ಆಮೇಲೆ ಅನುಷಾ, ಆಮೇಲೆ ನಂದಿತಾ, ಡಾಕ್ಟರ್ ಸವಿತಾ, ಮಾನಸ, ಧನುಷ್ ಅವರು, ಓಕೆನಾ, ಪ್ರತಿಭಾ ಮೇಡಮ್ ಅವರು ಮಾಡಿದ್ರು, ಆಮೇಲೆ ನಂದಿತಾ, ಡಾಕ್ಟರ್ ಸೈದಾ, ಆಯ್ತಾ? ಇಲ್ಲೆಲ್ಲ ಸ್ವಲ್ಪ ಬೇರೆಯಲ್ಲಿ ಮಿಸ್ಟರ್ ವಿವೇಕಾನಂದ್, ಯಾಕೆ ವಿವೇಕಾನಂದ ಪ್ರೆಸೆಂಟ್ ಇದಾರ ಇಲ್ವಾ? ಇವಾಗ ಇನ್ನೊಂದ್ಸತಿ ಅಟೆಂಡೆನ್ಸ್, ಸೆಕೆಂಡ್ ರೌಂಡ್ ಅಟೆಂಡೆನ್ಸ್. ವಿವೇಕಾನಂದರು ಯಾರು ಇದ್ದಾರೆ ಇವಾಗ ಹೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮನ್ನೆಲ್ಲ ಆಚೆ ಕಳಿಸ್ತೀವಿ. ಯಾರು ಔಟ್ ಆಫ್ ದ ಕ್ಲಾಸ್ ರೂಮ್. ಮಿಸ್ಟರ್ ವಿವೇಕಾನಂದ್ ಯಾರೋ ಮೋಸ್ಟ್ಲಿ ಅವರಷ್ಟಕ್ಕೆ ಅವರೇ ಆಚೆ ಹೊಟ್ಟೋಗ್ಬಿಟ್ರು, ಯಾಕಪ್ಪ ಇರ್ಬೇಕು ಸವಾಸ ಅಂತ. ವಿವೇಕಾನಂದ್ ಇಲ್ಲ ಮೇಡಮ್, ವಿವೇಕಾನಂದ್ ಇಲ್ಲ, ಅವ್ರನ್ನ ಆಚೆ ಕಳಿಸಿ, ಅಂದ್ರೆ ಅಟೆಂಡೆನ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ. ವಿನೀತಾ ಇಲ್ಲ. ಓಕೆ, ಮಿಸ್ಟರ್ ವಿನಯ್ ಕುಮಾರ್, ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾರ್ರೀ ನೀವು?
ವಿನಯ್ ಕುಮಾರ್.
ವಿನಯ್ ಎಲ್ರಿ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ ನೀವು?
ಸರ್ ಕೊಡ್ತಾ ಇದ್ದೆ ಸರ್.
ವಾಟ್ ಸೆಮಿಸ್ಟರ್?
6th semester.
6th semester. What is the response you have given earlier in the chat box? ಏನು ಉತ್ತರ ಕೊಟ್ಟಿದ್ರಿ?
ಸರ್ ಚಾಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ ಸರ್ ಅವಾಗಿಂದ.
ಮತ್ತೆ ಏನೋ ಉತ್ತರ ಕೊಟ್ಟಿದ್ರಿ ಅಂತಲ್ರಿ? ಓಕೆ,
ಕೇಳಿಸ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್.
Tell me the requirement for a patent. Say ಹಾಕಂಡ್ರಿ ಇವಾಗ. ಪೇಟೆಂಟ್ ಇಂದು ರಿಕ್ವೈರ್ಮೆಂಟ್ ಹೇಳಿ ಮಿಸ್ಟರ್ ವಿನಯ್ ಕುಮಾರ್.
ಸರ್ ಹೇಳ್ತೀನಿ.
ಹೇಳಿ. ಗೂಗಲ್ ಚೆಕ್ ಮಾಡಿ ಹೇಳಕ್ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗ್ತದೆ. ನೀವು ನೋಡ್ಕೊಂಡು ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ, ನನಗೆ ಅದೇ ಖುಷಿ. ಅಟ್ಲೀಸ್ಟ್ ಅಷ್ಟಾದ್ರೂ ಎಫರ್ಟ್ ಆಗ್ತಿರಲ್ಲ ಅಂತ.
ನೋವಲ್ಟಿ ಇನ್ವೆಂಟರ್ ಸ್ಟೆಪ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಅಪ್ಲಿಕೇಶನ್ ಸರ್.
ಇದನ್ನ ಎಲ್ಲಿ ನೋಡಿದ್ರೆ ಹೇಳಿ
ಸರ್. ಅವಾಗ ನೀವು ಕ್ವಶನ್ ಕೇಳ್ಬೇಕಾದ್ರೆ ನೋಡಿದ್ದೆ ಸರ್ ನಾನು.
ಚಾಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಇತ್ತು, ಹಾಗಾಗಿ ಸ್ಕ್ರಾಲ್ ಅಪ್ ಮಾಡ್ಕೊಂಡು ನೋಡಿದೀರಾ ಅಲ್ವಾ? ಗುಡ್ ರೀ, ಸೂಪರ್, ಐ ಅಪ್ರಿಶಿಯೇಟ್ ಯು. ಆಯ್ತಾ, ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದ್ ಎರಡು ಮೂರು ಜನ ನಂಗೆ ಸ್ವಲ್ಪ ಏನೋ ಕ್ವಾಟ್ಲೆ ಕೊಡೋಣ. ಮಿಸ್ಟರ್ ವರ್ಷ ಅವ್ರಿದಾರಾ? ವರ್ಷ ನೀವೇನು ರೆಸ್ಪಾಂಡ್ ಮಾಡಿಲ್ಲ. ತೃಪ್ತಿ ಮಾಡಿದ್ದಾರೆ. ವರ್ಷ, ಸ್ಪಂದನ ಮಾಡಿದ್ದಾರೆ. ಶ್ವೇತಾ, ಓಕೆ. ರಾಮ್ ಪ್ರಕಾಶ್, ನೀವು ಉತ್ತರ ಹೇಳಿಲ್ಲ. ಮಿಸ್ಟರ್ ರಾಮ್ ಪ್ರಕಾಶ್, CBBT 44, ಮೋಸ್ಟ್ಲಿ ರೋಲ್ ನಂಬರ್ ಇರ್ಬೇಕೇನೋ.
Dear students, you can respond, you can unmute yourself and you can talk. Otherwise, you can also drop a message in the chat box. Please respond. I need reciprocation. You already studied in your paper 8, Industrial Biotechnology, in Plant Biotechnology IPR. They have, sir, for 8 hours IPR.
ಓಕೆ. ಪರವಾಗಿಲ್ಲ. ಹಂಗ ಸ್ವಲ್ಪ ಇನ್ನು ಡಿಫಿಕಲ್ಟ್ ಕ್ವಶನ್ ಕೇಳ್ಬೋದು. ಹಂಗಾದ್ರೆ ಸಿಂಪಲ್ ಕ್ವಶನ್ ಆಯ್ತಿದು. ರಾಮ್ ಪ್ರಕಾಶ್.
Yes, sir.
Tell me, man, what is the validity of a patent? ನಿಮ್ ಮೇಡಮ್ ನಿಮ್ಗೆ ಇನ್ನೂ ಹಾಕ್ಸ್ಬಿಟ್ರು. ಆಗ್ಲಿ ಓದಿಯಾರ ಸರ್, ಎಲ್ಲ ಗೊತ್ತವ್ರಿಗೆ ಹೇಳ್ತಾರೆ ತಗೊಳ್ಳಿ ಅಂತ. ವಾಟ್ ಇಸ್ ದ ವ್ಯಾಲಿಡಿಟಿ ಆಫ್ ಅ ಪೇಟೆಂಟ್? ರಾಮ್ ಪ್ರಕಾಶ್. ಪೂಜಾ, ನಂದಿತಾ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದರೆ, ಹಾಗಾಗಿ ಯಾವ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಯಾರು ಉತ್ತರ ಹೇಳ್ತಾ ಇವಾಗ?
ಸರ್ 2 years.
2 years ಯಾರಿಗ್ರಿ ಕೊಡೋದು 2 years ಪ್ರೊಟೆಕ್ಷನ್? ರಾಮ್ ಪ್ರಸಾದ್.
20 years, sir, generally.
ವೆರಿ ಗುಡ್ ಮೇಡಮ್. ಯಾರಿದೆ ಹೇಳಿದ್ದು? ಯಾರು ಹೇಳಿದ್ದು? ನಂದಿತಾ ಅವರಾ? ಓಕೆ, ಗುಡ್. ನೋ, ಯು ಆರ್ ಆಲ್ರೆಡಿ ರೆಸ್ಪಾಂಡಿಂಗ್, ಸೊ ವಿ ನೋ ದಟ್ ಯು ಆರ್ ಅನ್ ಆಕ್ಟಿವ್ ಪರ್ಸನ್. ವಿ ವಾಂಟೆಡ್ ಟು ಓನ್ಲಿ ಯಾರು ಸುಮ್ಮನೆ ಇದ್ರಲ್ಲ ಅವ್ರನ್ನ ಸ್ವಲ್ಪ ಎಬ್ಬರಿಸ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ. ಕೋಮಲಾ ಮೇಡಮ್, ಯು ಆರ್ ನಾಟ್ ರೆಸ್ಪಾಂಡಿಂಗ್. ಸೋನಾ ಅವ್ರು ಇವಾಗ ಉತ್ತರ ಹೇಳಿದ್ದಾರೆ. ಗುಡ್, ಓಕೆ, ಫೈನ್, ಆಯ್ತು. Now let us go. So these are all the the validity of a patent. ಇದೆಲ್ಲ ಕೆಲವು ಇಂಪಾರ್ಟೆಂಟ್ ಅನ್ನ ನೀವು ಯಾವತ್ತೂ ಮರಿಬಾರ್ದು. Because see, today you all finish your bachelor's, and when you go out, either as a scientist or researchers or as an entrepreneur, ಇವತ್ತು there is a lot of scope for this, ಸುಡೋಮೋನಾಸ್ ನ ಸುಮಾರು ಜನ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ಮಾಡಿ ಪ್ಯಾಕೆಟ್ ಮಾಡಿ ಮಾರ್ತಾ ಇದ್ದಾರೆ ಎಲ್ಲಾ ಕಡೆಗೆ. ಯಾಕೆ? ಟು ಸಾಲ್ವ್ ದ ಪ್ರಾಬ್ಲಮ್ ಆಫ್ ಆಯಿಲ್ ಸ್ಪಿಲೇಜ್ ಇನ್ ಅಗ್ರಿಕಲ್ಚರಲ್ ಲ್ಯಾಂಡ್ ಆರ್ ಆನ್ ವಾಟರ್. ಅದೇ ಒಂದು ದೊಡ್ಡ ಬಿಸ್ನೆಸ್ ರೀ ಇವತ್ತು. ಸೊ ದೇರ್ ಇಸ್ ಅ ಹ್ಯೂಜ್ ಬಿಸ್ನೆಸ್ ಆಪರ್ಚುನಿಟಿ. ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಹೇಳ್ತೀನಿ ಹ್ಯೂಜ್ ಬಿಸ್ನೆಸ್ ಆಪರ್ಚುನಿಟಿ ಅಂತ, ಯಾಕಂದ್ರೆ ಇವಾಗ ಕರೋನಾ ಬಂದು ಎಲ್ಲ ಬಾಕ್ಲಾಕೊಂಡು ಹೋದ್ರೆ ಏನಿದೆ ಬಿಸ್ನೆಸ್ ಆಪರ್ಚುನಿಟಿ ಅಲ್ವಾ? ಹಾಗಂತ ಹೇಳಿ ನಾವು ಸುಮ್ಮನೆ ಕೂತ್ಕೊಳಕ್ ಆಗಲ್ವಲ್ಲ ಫ್ರೆಂಡ್ಸ್. That ಇವಾಗ, do you have any questions regarding copyrights? Copyright ಬಗ್ಗೆ ನಿಮ್ಗೆ ಏನಾದ್ರು ಕ್ವಶನ್ ಇದೆಯಾ? Do you have any doubt? ಸರ್, ಇದು ಯಾವ ತರ ವರ್ಕ್ ಆಗುತ್ತೆ, ಅಥವಾ ವಾಟ್ ಇಸ್ ದಿಸ್ ಕಾಪಿರೈಟ್? Okay, can anyone tell what is a copyright? Yeah, that's a question. See, this question was, suppose you people should have posed me, but I am posing you the question. Yes, tell me. ವಾಟ್ ಇಸ್ ಅ ಕಾಪಿರೈಟ್? ಸರ್, ಅದು ನೀವು ಪಾಠ ಮಾಡ್ಬೇಕು. ನೀವ್ ಹೇಳಿದ್ಮೇಲೆ ನಾವು ಕೇಳಿದ್ರೆ ಪ್ರಶ್ನೆ ಸರಿ. ಇವಾಗ ನೀವು ಏನು ಹೇಳಿದ್ರೆ ಸುಮ್ಮನೆ ವಾಟ್ ಇಸ್ ಕಾಪಿರೈಟ್, ವಾಟ್ ಇಸ್ ಸುಡೋಮೋನಾಸ್ ಅಂತ ಏನು ಫಸ್ಟ್ ಸೆಮಿಸ್ಟರ್ ಕೇಳ್ಬಿಟ್ರೆ ಅಂತ ಅಲ್ವಾ? ಇಲ್ಲ, ನೀವೆಲ್ಲ ಗೊತ್ತಿದೆ, ಯಾಕಂದ್ರೆ ಮೇಡಮ್ ಹೇಳಿದ್ರಲ್ಲ, ನೀವೆಲ್ಲ ಓದಿದಿರ ಈಗಾಗ್ಲೇ ಅಂತ. ಹಾಗಾಗಿ ಐ ಅಸ್ಯೂಮ್ ದಟ್ ಯು ಆಲ್ ನೋ ಅಬೌಟ್ ದಿಸ್, ಹೆನ್ಸ್ ಯು ಹ್ಯಾವ್ ಟು ರೆಸ್ಪಾಂಡ್. ಎಸ್, ಕ್ವಿಕ್ಲಿ. ಸ್ಪಂದನ, ನಮ್ಮ ಎಲ್ಲಿ ಭಾಸ್ಕರ್ ಗೌಡ್ರು ಉತ್ತರ ಕೊಡ್ರಿ. ಇವ್ರು ನಮ್ಮ ರವಿ, ವಿನಯ್ ಕುಮಾರ್.
6th sem students can answer.
ಏನಮ್ಮ? ಏನ್ ಮೇಡಮ್?
6th sem students can answer, sir.
ಆಯ್ತು, ಓಕೆ. ನಾವು ಈಗ 6th ಸೆಮಿಸ್ಟರ್ಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಲಿಮಿಟ್ ಮಾಡೋಣ ಅಂತ ಮೇಡಮ್. ಯಾಕೆ ಅಯ್ಯೋ ಸರ್ ಅಂತ. ರೈಟ್ಸ್ ಗಿವನ್ ಟು ದ ಇನ್ವೆಂಟರ್. ಸಾರಿ, ಬೇಗ ಹೇಳಿ ಉತ್ತರ. ವಿನಯ್ ಕುಮಾರ್, ಭಾಸ್ಕರ್ ಗೌಡ್ರು, ಎಲ್ಲಿ ಉತ್ತರ ಬರ್ತಾ ಇಲ್ಲ
ಸರ್?
ವಾಟ್ ಇಸ್ ಅ ಕಾಪಿರೈಟ್ ರೀ?
ಸರ್, ಅದು ಕಲೆಕ್ಷನ್ ಆಫ್
ಕಲೆಕ್ಷನ್ ಆಫ್, ಕರೆಕ್ಟ್ ಹೇಳ್ರಿ ನೀವು. ಸಿ, ಇನ್ ಅವರ್ ಕ್ಲಾಸ್ ವಾಟ್ ಎವರ್ ಯು ಸೇ ಆನ್ಸರ್ ಆಲ್ ಆರ್ ರೈಟ್. ನೀವು ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಮಾತ್ರನೇ ರೈಟ್ ರಾಂಗು ಬರೋದು, ಬಟ್ ನಮ್ದ್ರಲ್ಲಿ ವಾಟ್ ಎವರ್ ಯು ಸೇ ಆಲ್ ಆರ್ ರೈಟ್.
ಸರ್, ಕಲೆಕ್ಷನ್ ಆಫ್ ಡಾಟಾ ಸರ್.
Collection of data. Okay, fine. That is copyright. Aithu ರೀ. Legal term used to describe the right that creator have over their literary and artistic work. Dr. Rizwan says. Aithu. Next one. Eli Bhaskar Gaudru. Bhaskar, can you respond please? Because I really appreciate your effort. That's why I want answer from Bhaskar. Nandita madam, ನೀವು ಹೇಳಿ. Anusha ಅವರೇ, what is a copyright? ನಾನ್ ಸುಮ್ನೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಹೇಳ್ಕೊಳ್ಳೋದಲ್ಲ, ಅರ್ಥನೇ ಇಲ್ಲ. ಐ ಡು ನಾಟ್ ಸಿಂಪ್ಲಿ ನನ್ನ ಕಡೆ. ಹೇಳಮ್ಮ ನಂದಿತಾ ಅವರು.
It gives the creator an original exclusive rights, sir.
ವೆರಿ ಗುಡ್, ವೆರಿ ಗುಡ್, ವೆರಿ ಗುಡ್. ಐ ರಿಯಲಿ ಅಪ್ರಿಶಿಯೇಟ್. ಕರೆಕ್ಟ್. ಆಮೇಲೆ ಇನ್ನೊಬ್ರು ಯಾರಾದ್ರೂ, ನಮ್ಮ ಭಾಸ್ಕರ್ ಗೌಡ್ರೆ ಯಾಕೆ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ವಲ್ಲ? ವಾಟ್ ಹ್ಯಾಪನ್? ಓಕೆ, ಹಿ ಹಸ್ ಗಿವನ್ ಟೈಪಿಂಗ್. ಓಕೆ, ರೈಟ್ ಗಿವನ್ ಫ್ರಮ್ ಒರಿಜಿನಲ್ ಇನ್ವೆಂಟರ್. ನೋ, ಇನ್ವೆಂಟರ್ ಬರೋದು ಪೇಟೆಂಟ್ ಅಲ್ಲಿ, ಕ್ರಿಯೇಟರ್ ಬರೋದು ಕಾಪಿರೈಟ್ ಅಲ್ಲಿ. ಓಕೆ, ದಟ್ಸ್ ಒನ್. ಭಾಸ್ಕರ್ ಹ್ಯಾಸ್ ಸ್ಟೇಟೆಡ್ ದಟ್ rights given from original inventor in terms of permission. No, Bhaskar, I'll give you the right answer. Okay, let me also take up two other response which has come. Saptadeep ಅವರು, right to make copies of creative products. Very good. For example, you have written an article, you have a right to make the copies of the article. You have written a book, you have a right to make the copies of the book. That's all. You have written a drawing of a or a drawing of a microorganism or drawing of a particular thing. That drawing, you have a right to make copies. Next, Dr. Savita ಅವರು ಹೇಳ್ತಾರೆ, protection against individual reproduction one's work without permission or citation. Very good. So what you do when you write your research work, you say what is the thing which was, for example, you are doing a research on extraction of oil from a neem seed. When you do a extraction of study on extraction of oil from a neem seed, what happens? You read what was earlier how people were extracting the oil. Okay, ಹೆಂಗ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರು, ಹೆಂಗ್ ಅದನ್ನ ಪ್ರೊಸೆಸ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ ಅದನ್ನ you do a research. When you do research in your literature review or in your research paper, you refer someone, you cite someone, okay, give a references, citation, or take permission from a author. Sir, ನಿಮ್ಮ ವರ್ಕ್ ನ ನಮ್ಮ ಒಂದು ಆರ್ಟಿಕಲ್ ಅಲ್ಲಿ ಬಳಸ್ತಾ ಇದ್ದೀನಿ, ಹಾಗಾಗಿ ನಿಮ್ಮನ್ನ ರೆಫರೆನ್ಸ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ನಿಮ್ಮ ಹತ್ರ ಪರ್ಮಿಷನ್ ತಗೊಳ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಅನ್ನೋದೇ ಕಾಪಿರೈಟ್. ಓಕೆ, Dr. Saida says without permission or citation. If you do without permission or citation, what will happen? ನೀವು citation ನಲ್ಲಿ ಕೊಡಬೇಕಾದ್ರೆ, if you are not taken the permission, if you have not appropriately cited, what will happen? ಏನಾಗುತ್ತೆ? ಎಲ್ಲಿ ನಮ್ಮ ಭಾಸ್ಕರ್ ಗೌಡ್ರು, what will happen if you have not taken the permission of an author? Saida says amount to plagiarism. This may amount to plagiarism. Plagiarism, of course, plagiarism is an ethical violation. Aita, but Manasa says that it is the legal ownership of a written record or script. Yes, copyright andre, it's a ownership on the article which you have written or if you have recorded. So what you do, there is a video you make a video of what, when you are doing a research in your laboratory, you make a video and explain ಈ ತರ ಬಿಹೇವ್ ಆಗ್ತಾ ಇದೆ, ಇಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಬರ್ತಾ ಇದೆ ಇದರ ರಿಸಲ್ಟ್, ಅಥವಾ ಇಷ್ಟು ಟೆಂಪರೇಚರ್ ಅಲ್ಲಿ ಇದು ವಿಥೆಲ್ಡ್ ಮಾಡ್ತಾ ಇದೆ, ಅಥವಾ ದಿಸ್ ಈಸ್ ಏಬಲ್ ಟು ಡಿಗ್ರೇಡ್ ದ ಆಯಿಲ್ ಸ್ಪಿಲ್ಸ್ ಅಂತ ಹೇಳಿ ಬರ್ತಾ ಇದೆ. ಸೊ ದೀಸ್ ಆರ್ ಆಲ್ ದ recording which you have made, and that recording is entitled for copyright. Yes, Dr. Rizwan says that they can take legal action can be taken. Dhanush ಹೇಳ್ತಾರೆ, yes. If someone takes your copyright work without the permission, it amount to a they can take a legal action. Without permission, it is called piracy. Yes, it is also called as piracy. It is also called as copyright infringement. It is also ethical violation is called as plagiarism. So these are all the things. So what we understood from even though 10-15 minutes of discussion, what we understood, the second part is that first, what is a copyright? Copyright is a right to reproduce the work, of the creativity. Second, it is a kind of ownership given to you. And if someone wants to use your work, they have to take permission or provide a citation or provide references. And if you does not take references, it amount to a legal action, infringement, piracy. That's all. Copyright will say only 3 major things. It gives you a right of creativity of a work. Second, you have a permission to give it to anyone, like publisher, like a printer, or anyone who uses your work. Third is that if someone takes your work without your permission, amount to an infringement. Ashte. Artha aita? Okay. I hope you all have understood on this particular subject matter. Right? Anyone have any question? So far, we have discussed so much. So do you have any question? No, because my next, in the same slide, the content says, now, do you have any question? ಯಾರಿಗಾದ್ರೂ ಏನೋ ಕ್ವಶನ್ ಇದೆಯಾ? ಗೊತ್ತಲ್ಲ, ನೀವು ಕ್ವಶನ್ ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಕ್ವಶನ್ ಕೇಳ್ತೀನಿ ಅಂತ. ಬೇಗ ಒಂದು ಮೆಸೇಜ್ ಹೋಗ್ಬಿಡ್ತೀನಿ ನಾನು. ಅಲ್ಲ, yes. Do you have any question? ಯಾರಿಗಾದ್ರೂ ಏನಾದ್ರು ಡೌಟ್ ಇದೆಯಾ? ಓಕೆ, ಕ್ವಶನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಡೌಟ್ ಇದೆಯಾ? ಎಸ್. ವೇರ್ ಟು ಫೈಲ್ ಕಾಪಿರೈಟ್? ವೆರಿ ಗುಡ್ ಭಾಸ್ಕರ್ ಗೌಡ್ರು. ನಾನು ಅನ್ಕೊಂತಾ ಇದ್ದೆ ಭಾಸ್ಕರ್ ಗೌಡ್ರು ಅಥವಾ ನಮ್ಮ ಸೈದಾ ಮೇಡಮು ಅಥವಾ ರಿಜ್ವಾನು, ಧನುಶ್ರೀ, ಮಹೇಶು, ಸೋನಾ, ಇವರೆಲ್ಲ ಸ್ವಲ್ಪ ನಮ್ಮ ಆಕ್ಟಿವ್ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ಗಳು. ಇವರೆಲ್ಲ ನಿಜವಾಗ್ಲೂ ಉಪಯೋಗಿಸ್ಕೊಂತಾರೆ. ರಾಮ್ ಪ್ರಸಾದ್, ನಮ್ ವಿನಯ್ ಕುಮಾರ್ ಹೇಳ್ರಿ. ವಿನಯ್ ಕುಮಾರ್, ನಿಮ್ದೇನೋ ಒಂದು ಕ್ವಶನ್, ಡೌಟ್ ಹೇಳ್ರಿ. ವಿನಯ್ ಕುಮಾರ್, kindly pose one doubt, one question, ಒಂದು ಕ್ವಶನ್ ಹೇಳ್ರಿ. ನಿಮ್ಗೆ ಏನಾದ್ರು ಡೌಟ್ ಇದೆಯಾ ಅಂತ ಕಾಪಿರೈಟ್ ಮೇಲೆ?
Sir, difference between copyright and patent. What is the difference between copyright and patent, sir? A
lovely man, a lovely ಕಣ. ಇವಾಗ ನಾನು ಉತ್ತರ ಹೇಳ್ತೀನಿ, ಅದಕ್ಕೂ ಮುಂಚೆ ನೀನು ಫಸ್ಟ್ ಉತ್ತರ ಹೇಳು, ನಿಂಗೆ ಗೊತ್ತಿದ್ರೆ. ಇಲ್ಲ ಇದ್ರೆ ನಮ್ಮ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ಗಳು, ನಮ್ಮ ಭಾಸ್ಕರ್ ಗೌಡ್ರು ಇದಾರೆ, ರಿಜ್ವಾನ್ ಇದಾರೆ, ಅವರೆಲ್ಲ ಹೇಳ್ತಾರೆ. ನಿಮ್ಗೆ ಏನಾದ್ರು ಗೊತ್ತಾ ವಾಟ್ ಇಸ್ ದ ಮೇಜರ್ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಪೇಟೆಂಟ್ ಅಂಡ್ ಕಾಪಿರೈಟ್? ಬಿಕಾಸ್ ಆಲ್ರೆಡಿ ಐ ಹ್ಯಾವ್ ಎಕ್ಸ್ಪ್ಲೇನ್ಡ್ ಅಲ್ವಾ, ಅದಕ್ಕೋಸ್ಕರ.
ಸರ್, ನನಗೆ ಗೊತ್ತಿದ್ದಂಗೆ ಪೇಟೆಂಟ್ ಅಂದ್ರೆ ಅದು ಓನರ್ ಇಂದ ನಮಗೆ ಬರೋದು.
ಏನಪ್ಪಾ? ಅಲ್ಲ, ಪೇಟೆಂಟ್ಗೂ ಕಾಪಿರೈಟ್ಗೂ ಏನ್ ಡಿಫರೆನ್ಸ್? ಫಸ್ಟ್ ಒನ್ ಡಿಫರೆನ್ಸ್ ಹೇಳಿ ಸರ್.
ಪೇಟೆಂಟ್ ಮೀನ್ಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡು ತಗೊಳೋದು ಸರ್. ಇದು ಕಾಪಿರೈಟ್ ಮೀನ್ಸ್
ಆಯ್ತು. ಕಾಪಿರೈಟ್ ಅಂದ್ರೆ
ಆಟೋಮೆಟಿಕ್ ಮೆಷಿನ್ ತರ ಆಗೋದು.
ವಂಡರ್ಫುಲ್ ಗುರು, ವಂಡರ್ಫುಲ್, ಸೂಪರ್, ಗುಡ್, ವೆರಿ ಗುಡ್, ವೆರಿ ಗುಡ್. ಐ ರಿಯಲಿ ಅಪ್ರಿಶಿಯೇಟ್ ಮ್ಯಾನ್. ಓಕೆನಾ? ನಮ್ಮ ಇವರು ರಿಜ್ವಾನ್ ಅವರೇ, ನೀವೊಂದು ಡಿಫರೆನ್ಸ್ ಹೇಳಿ. ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಅ ಪೇಟೆಂಟ್ ಅಂಡ್ ಅ ಕಾಪಿರೈಟ್. ಅಥವಾ ನಮ್ಮ ಭಾಸ್ಕರ್ ಗೌಡ್ರೆ ನೀವ್ ಹೇಳ್ರಿ, ನಿಮ್ಗೆ ಗೊತ್ತಲ್ಲ. ಆಮೇಲೆ ಕ್ವಶನ್ಗಳೆಲ್ಲ ಹಾಕಿದಿರಾ, ಅದಕ್ಕೆಲ್ಲ ಉತ್ತರ ಹೇಳ್ತೀನಿ. ಭಾಸ್ಕರ್ ಗೌಡ್ರೆ, what is the difference between a patent and a copyright? ವಿನಯ್ ಕುಮಾರ್ ಏನ್ ಹೇಳಿದ್ರು? said ಪೇಟೆಂಟ್ ಕೊಡೋದು ಒಂದು ಇನೋವೇಷನ್ಗೆ, ಕಾಪಿರೈಟ್ ಪೇಟೆಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು, ತಗೋಬೇಕು ಅಂತಂದ್ರೆ ಕಾಪಿರೈಟ್ ಆಟೋಮ್ಯಾಟಿಕ್ ಆಗಿ ಸಿಗುತ್ತೆ. ದಟ್ ಇಸ್ ದ ಫಸ್ಟ್ ಮೇಜರ್ ಡಿಫರೆನ್ಸ್. ರಾಮ್ ಪ್ರಕಾಶ್ ಹೇಳ್ತಾರೆ ಕಾಪಿರೈಟ್ ಈಸ್ ಸರ್ವ್ಸ್ ಆಥರ್, ಪೇಟೆಂಟ್ ಸರ್ವ್ಸ್ ಇನ್ವೆಂಟರ್. ವೆರಿ ಗುಡ್. ಪೇಟೆಂಟ್ ಕೊಡೋದು ಯಾರಿಗೆ? ಇನ್ವೆಂಟರ್ಗೆ. ಕಾಪಿರೈಟ್ ಕೊಡೋದು ಯಾರಿಗೆ? ಆಥರ್ಗೆ. ವೆರಿ ಗುಡ್. ಭಾಸ್ಕರ್, ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಪೇಟೆಂಟ್ ಫಾರ್ ಇನೋವೇಷನ್, ಐಡಿಯಾ ಅಂಡ್ ಟೆಕ್ನಾಲಜಿ, ಅಂಡ್ ಕಾಪಿರೈಟ್ is for ಕಾಪಿರೈಟ್ ಯಾವ್ದಕ್ಕೆ ಕೊಡ್ತಾರೆ? Is for work of author or original work. ಹೌದು ನಂದಿತಾ ಮೇಡಮ್, ಕರೆಕ್ಟ್. ಓಕೆನಾ? ವೆರಿ ಗುಡ್. ರಿಜ್ವಾನ್ ಅವ್ರು ಇನ್ನೊಂದು ಉತ್ತರ ಕೊಡ್ತಾರೆ. ಪೇಟೆಂಟ್ ಫಾರ್ ನಾವೆಲ್ ಐಡಿಯಾ, ಬಟ್ ಕಾಪಿರೈಟ್ ಇಸ್ ಫಾರ್ ಆಥರ್ ಅಲ್ಲ, ಕಾಪಿರೈಟ್ ಫಾರ್ ಕ್ರಿಯೇಟಿವ್ ಐಡಿಯಾ. ಪೇಟೆಂಟ್ ಕೊಡೋದು ನಾವೆಲ್ ಐಡಿಯಾಗೆ, ಕಾಪಿರೈಟ್ ಕೊಡೋದು ಕ್ರಿಯೇಟಿವ್ ಐಡಿಯಾಗೆ. Then copyright gives you legal protection, patent protects your work. ಧನುಷ್, ಏನ್ರಿ ಅದು? ಏನೇನೋ ಬರೀತಿರಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ರಿ. ಅದು ಎರಡಕ್ಕೂ ಲೀಗಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇದೆ. ಅಂದ್ರೆ ಕಾಪಿರೈಟ್ ಗೆ ಲೀಗಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕಾಪಿರೈಟ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಬರುತ್ತೆ, 1957. ಪೇಟೆಂಟ್ ಕೊಡೋದು ಪ್ರೊಟೆಕ್ಷನ್ ಇಸ್ ಫಾರ್ ಅಂಡರ್ ದ ಇಂಡಿಯನ್ ಪೇಟೆಂಟ್ ಆಕ್ಟ್ 1970. ಆತರ ಹೇಳಕ್ ಹೊರಟಿದ್ರಾ? ಹಾಗಾಗಿ ನೀವು ರೈಟ್ ಆಯ್ತಾ. ಈ ತರ ನಾವು ತಪ್ಪಿರೋ ಆನ್ಸರ್ನು ರೈಟ್ ಮಾಡ್ತೀವಿ ಆಯ್ತಾ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಸೋನಾ. ಲೈಫ್ ಟೈಮ್ ಆಫ್ ಅನ್ ಆಥರ್, ಲೈಫ್ ಟೈಮ್ ಫಾರ್ ಕಾಪಿರೈಟ್ ಈಸ್ ಮೋರ್ ದ್ಯಾನ್ ಪೇಟೆಂಟ್. ವೆರಿ ಗುಡ್. ಏನ್ ಮೇಜರ್ ಇನ್ನೊಂದು ಸೋನಾ ಮೇಡಮ್ ಹೇಳ ಪ್ರಕಾರ, ಪೇಟೆಂಟ್ ಪ್ರೊವೈಡ್ಸ್ 20 years of protection, copyright protects, copyright period of protection is lifetime of an author plus 60 years. Okay na, that's the correct answer. ರಂಜಿತಾ, ವೆರಿ ಗುಡ್. ರಂಜಿತಾ ಇವಾಗ ಸ್ವಲ್ಪ ಆಕ್ಟಿವ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಪೇಟೆಂಟ್ ಸರ್ವ್ಸ್ ಟೈಮ್ ಲೈನ್ ಫ್ರಮ್ 15 to 20 ಅಲ್ಲ, ಇಲ್ಲ 20 years ಅಷ್ಟೇ. ಇಂಡಿಯಾದಲ್ಲಿ 20 years. ಓಕೆ, ಪೇಟೆಂಟ್ ಕಾಪಿರೈಟ್ ಇಸ್ ಫಾರ್ ಲೈಫ್ ಟೈಮ್ ಆಫ್ ಅನ್ ಆಥರ್ ಪ್ಲಸ್ 60 years. ನೆಕ್ಸ್ಟ್ ನಂದಿತಾ ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ, ಕಾಪಿರೈಟ್ ಫಾರ್ ಫೋಟೋಗ್ರಫಿ, ಪೇಟೆಂಟ್ ಇಸ್ ಫಾರ್ ಟೆಕ್ನಾಲಜಿ. ಕರೆಕ್ಟ್, ಮೋರ್ ಆರ್ ಲೆಸ್ ಕರೆಕ್ಟ್. ವೆರಿ ಗುಡ್. ನಮ್ಮ ಯಾರು ಇನ್ನೊಬ್ರು ಫೇವರೇಟ್ ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ಲಿಲ್ವಲ್ಲ? ನಮ್ಮ ಫೇವರೇಟ್ ಯಾರು ಹೇಳಿ? Spurti for the first time is answering. Copyright is which protects original work. Yes. What is the requirement for a copyright? It should be original work. What is the requirement for patent? It should be novel, non-obvious, industrial applicability. Copyright ge novel, non-obviousness, industrial applicability bekagilla. Only requirement is your work should be original. Ashte. Then copyright, then patent is the right that gives the owner exclusive feature and processes of invention. Exclusive features and process of invention. ಸ್ಫೂರ್ತಿ ಒಂಚೂರು ಅಲ್ಲೊಂಚೂರು ಗ್ರಾಮರ್ ಸರಿಗ್ ಬರ್ತಾ ಇಲ್ಲ, ಸೆಂಟೆನ್ಸ್ ಮೀನಿಂಗ್ ಕೊಡ್ತಾ ಇಲ್ಲ, ಸ್ವಲ್ಪ ರೀಫ್ರೇಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಪರವಾಗಿಲ್ಲ. ಹಾಕ್ಬಿಟ್ಟು ಹಾಕಿ ಇನ್ನೊಂದ್ಸತಿ. ಭಾಸ್ಕರ್ ಗೌಡ ಹೇಳ್ತಾರೆ, ವೇರ್ ಟು ಫೈಲ್ and how much cost would be spent and validity or renewal of that copyright. May please explain. Appa ಹೇಳ್ತೀನಿ ಕಣೋ, ಎಲ್ಲೂ ಹೋಗಲ್ಲ. ಅದಿನ್ನು ನನ್ನ ಸ್ಲೈಡ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಲ್ವಲ್ಲ, ನಿಮ್ಗೆಲ್ಲ ಒಂದ್ಸತಿ ಬ್ರಷ್ ಅಪ್ ಮಾಡಿ ರೆಡಿ ಮಾಡ್ಸಕ್ಕೆ. ಅಂದ್ರೆ ಯು ಆರ್ ಸೋ ಈಗರ್ ಟು ಫೈಲ್ ಅ ಪೇಟೆಂಟ್, ನೋ ಅಬೌಟ್ ದ ಕಾಪಿರೈಟ್ ಇಂಪ್ಲಿಕೇಶನ್ ಅಂಡ್ ಫೈಲ್ and keep up that particular inspiration and your objective to file and protect your various intellectual property rights. And in the due course, I will tell, or I'll tell you now only, because see, now the cost of copyright is just 500 rupees for literary work. How do you file? You go to copyright.gov.in. There, it's a simple application. One letter, request letter to file or protect my IP. Second, it should have the copyright application SOP ಅಂದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ದಟ್ ಹೂ ಇಸ್ ಅ ಓನರ್, ಯಾರು, ನಿಮ್ಮ ಹೆಸರೇನು, ನಿಮ್ಮ ಅಡ್ರೆಸ್ ಏನು, ಕ್ರಿಯೇಟ್ ಮಾಡಿ, ಯಾವ ವರ್ಷ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರಿ ಅಂತ ಫಿಲ್ಅಪ್ ಮಾಡಿ, ನಿಮ್ಮ ವರ್ಕ್ ಆರ್ಟಿಕಲ್ ನ ಅಟ್ಯಾಚ್ ಮಾಡಿ, ಪ್ರಿಂಟ್ ಔಟ್ ತಗೊಂಡು 500 ರೂಪಾಯಿ DD ತಗೊಂಡು ನೀವು ಕಾಪಿರೈಟ್ ರಿಜಿಸ್ಟ್ರಿಗೆ ಪೋಸ್ಟ್ ಆದ್ರೂ ಮಾಡ್ಬೋದು, ಅಥವಾ ನೀವು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಬೇಕಾದ್ರೂ ಅಪ್ಲಿಕೇಶನ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ಬೋದು. ನೀವು ಹೆಂಗೆ ಒಂದು CET ಎಕ್ಸಾಮ್ಸ್ ಅಥವಾ ನಿಮ್ಮ ಬೇರೆ ಯಾವ್ದಾದ್ರು ಒಂದು ಜನರಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹೆಂಗೆ ನೀವು ಗೂಗಲ್ ಫಾರ್ಮ್ ಓಪನ್ ಮಾಡಿದಾಗ ಏನೇನು ಕೊಡ್ತಿರೋ, ಅದೇ ತರನೇ ಕಾಪಿರೈಟ್ ಅಪ್ಲಿಕೇಶನ್ ಫಿಲ್ಅಪ್ ಕೊಟ್ರೆ ಯು ವಿಲ್ ಗೆಟ್ ಇಟ್ ಡನ್. ದಿಸ್ ಇಸ್ ಫಾರ್ ಕಾಪಿರೈಟ್. ಬಟ್ ಫಾರ್ ಪೇಟೆಂಟ್ ಈಸ್ ಪ್ರೊಟೆಕ್ಟಿಂಗ್ ಅ ಪ್ರಾಡಕ್ಟ್ ಫಾರ್ ಅ ಮಾಸ್ಕ್. ಅದೇ ಹೆಂಗ್ ನಾನ್ ಮಾಡಿದೆ, ಹೆಂಗೆ ಒಂದು ಮೈಕ್ರೋ ಆರ್ಗಾನಿಸಮ್ಸ್ ಬಿಹೇವ್ ಮಾಡ್ತಾ ಇದೆ ಅಂತ ಬರೆಯೋದಕ್ಕೆ ಅಷ್ಟೇ ಕಾಪಿರೈಟ್ ಒಂದೇ. But if you go for patent, that you have created a new microorganism, or you have come out with a new invention of a mask, or you have come out with a new invention of extraction of oil. So for this, you get patent because there is huge amount of revenue generation. Hence, patent fees is 4,500 patent application fees, but the agent and other examination fees on 4,500 ಕಟ್ಟಬೇಕು ಮತ್ತೆ ಬೇರೆ ಬೇರೆ ಇದಕ್ಕೂ ಎಲ್ಲದಕ್ಕೂ ಫೀಸ್ ಕಟ್ತಾ ಹೋಗಬೇಕು. Then simply you cannot simply file a patent application. You should take an assistance of a patent agent. ಅವರಿಂದ ಮಾಡಿಸಿದಾಗ ಚೆನ್ನಾಗಿ ಕ್ಲಿಯರ್ ಆಗಿ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ತಾರೆ, ಅವ್ರು ಏನ್ ಹೇಳ್ಬೇಕು ಅದನ್ನ ಹೇಳ್ತಾರೆ, ಅವಾಗ ನಿಮ್ಗೆ ಪೇಟೆಂಟ್ ಸಿಗುತ್ತೆ, ಅದನ್ನ ನೀವು ಕಮರ್ಷಿಯಲೈಸ್ ಮಾಡ್ಬೋದು. ಓಕೆನಾ? ಸೊ ದಿಸ್ ಈಸ್ ವಾಟ್ ಅಂಡ್ how where to file copyright.gov.in ಹೇಳಿದೆ. How much cost to be spent is 500 rupees for copyright, 4,500 for patent. But sometimes approximately on patent ನಾನು ಫೈಲ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಒಂದು 35,000 ಆಗುತ್ತೆ. ಯಾರಾದ್ರೂ ಸ್ವಲ್ಪ ದೊಡ್ಡ ದೊಡ್ಡ ಲಾ ಫರ್ಮ್ಸ್ ಗಳ ಜೊತೆ ಮಾಡಿಸಿದ್ರೆ ಒಂದು 50,000 ಆಗುತ್ತೆ. ನಮ್ KCST ಯಲ್ಲೂ ನಾವು ನಿಮ್ಗೆ ಕಾಪಿರೈಟ್ ಫೈಲ್ ಮಾಡ್ಕೊಡ್ತೀವಿ, ಪೇಟೆಂಟ್ ಫೈಲ್ ಮಾಡ್ಕೊಡ್ತೀವಿ, ಯಾವುದೇ ರೀತಿ ಫೀಸ್ ಚಾರ್ಜ್ ಮಾಡಲ್ಲ. ಬಟ್ ಗವರ್ಮೆಂಟ್ ಫೀಸ್ ನೀವೇ ಬೇರ್ ಮಾಡ್ಬೇಕು. ಓಕೆನಾ? ನಾವು ಏನಿವಾಗ ನಿಮ್ಮ IPSL ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ತಾ ಇದೀವಲ್ಲ ನಿಮ್ KLEಯಲ್ಲಿ, ಇದನ್ನ ನಿಮ್ಗೆಲ್ಲರಿಗೂ ಹೇಳೋದಕ್ಕೆ ಹೆಂಗ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು, ಹೆಂಗೆ ನೀವು ಒಂದು ಇವಾಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ನೀವೆಲ್ಲ ಒನ್ಸ್ ಯು ಫಿನಿಶ್ ಯುವರ್ ಕೋರ್ಸ್ ಅಂಡ್ ಇಫ್ ಯು ಈ ನಿಮ್ಮ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಏನೋ ಒಂದು ಹೊಸದಾಗಿರೋ ಒಂದು ಮೈಕ್ರೋ ಆರ್ಗಾನಿಸಮ್ಸ್ ನೀವು ಕಂಡಿಡಿದ್ರೆ, ಅಥವಾ ಏನೋ ಒಂದು ಪ್ರಾಡಕ್ಟ್ ನ ತಂದಿದ್ರೆ, ಅಥವಾ ಡಿಗ್ರೇಡಬಲ್ ಪ್ಲಾಸ್ಟಿಕ್ ಒಂಥರದ್ದು ಏನೋ ತಂದಿದ್ರೆ, so anything which we have done like this can be used as a product in the market ಅಂತ ಬಂದಾಗ ನಮ್ಮ IPSL KLE and KCST IPSL ಮೂಲಕ ನಮಗ್ ಬರುತ್ತೆ, ನಾವು ಅದನ್ನ ಪೇಟೆಂಟ್ ನ ಫೈಲ್ ಮಾಡಿ ಕೊಡ್ತೀವಿ. ಬಿಕಾಸ್ ಯು ಆರ್ ಅ ಸ್ಟೂಡೆಂಟ್ and the professional fees ಏನು ಹೊರಗಡೆ ಚಾರ್ಜ್ ಮಾಡ್ತಾರೆ ಅದನ್ನ ನಾವು ಚಾರ್ಜ್ ಮಾಡಲ್ಲ, but we will take it up and file. But the cost has to be taken care. Sometimes institution will take care, sometimes student will have to take care. So that depends on the invention. ನೀವೇನಾದ್ರೂ ಅಷ್ಟು ಸ್ಟ್ರಾಂಗ್ ಇನ್ವೆನ್ಷನ್ ತಗೊಂಡ್ಬಂದಿದ್ದು ಮಾಡಿದ್ರೆ ಅವಾಗ we can ಅದನ್ನ ಪ್ರೊಸೆಸ್ ಮಾಡಬಹುದು. ಓಕೆನಾ? So that's what validity or renewal of a copyright. Copyright ಅಲ್ಲಿ renewal ಅಂತ ಬರಲ್ಲ. Patent to copyright ಅಲ್ಲಿ there is no concept of renewal. Renewal is only in case of GI, geographical indication, or the trademark. Trademark every 10 years you can keep on renewing. Aita? But copyright to lifetime of author plus 60 years ಆದ್ಮೇಲೆ lapse ಆಗುತ್ತೆ. Patent to 20 years ಆದ್ಮೇಲೆ lapse ಆಗುತ್ತೆ, means anyone can use the your invention. Aita? Next to patent is a right, registered right that gives the owner exclusive right to features. ಹೌದು, ಕರೆಕ್ಟ್. ಇಟ್ ಇಸ್ ಅನ್ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ರೈಟ್ ಗ್ರಾಂಟೆಡ್ ಟು ದ ಓನರ್. ಇಲ್ಲೂ ಅಷ್ಟೇ, ಕಾಪಿರೈಟ್ ಅಲ್ಲೂ ಅಷ್ಟೇ. ಕಾಪಿರೈಟ್ ಒಂಥರ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ರೈಟ್ ಏನೆ, ಅಥವಾ ಇವ್ರಿಗೆ ಬಂಡಲ್ ಆಫ್ ರೈಟ್ ಅಂತ ಕರೀತಾರೆ. ಕಾಪಿರೈಟ್ ಇಸ್ ಅ ಬಂಡಲ್ ಆಫ್ ರೈಟ್. ಆಯ್ತಾ? ಎಸ್, ಐ ಥಿಂಕ್ that's a really a very good discussion we made. I really appreciate all the active participants in this particular group, today's group. Is there any initiative by government for controlling piracy? Yeah. Lot of initiatives. See, ನಾವೇ ನಮ್ಮ ಎಷ್ಟೊಂದ್ಸಲ ಈ ಅಮಿತಾಬ್ ಬಚ್ಚನ್ ಇಂದೆಲ್ಲ ಕೆಲವರು ನೋಡಿರ್ಬೋದಲ್ವಾ, ಪೈರಸಿ ಮಾಡಬೇಡಿ, ಆನ್ಲೈನ್ ಮೂಲಕ ನೀವು ಪೈರಸಿ ಪಿಕ್ಚರ್ಗಳನ್ನೆಲ್ಲ ಇದನ್ನೆಲ್ಲ ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೋಬೇಡಿ ಅಂತೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ರು. ಮುಂಚೆಲ್ಲ ನಿಮಗೆ ಈಸಿಯಾಗಿ ಯು ಆರ್ ಏಬಲ್ ಟು ಡೌನ್ಲೋಡ್ ದೋಸ್ ಮೂವೀಸ್, ಬಟ್ now no, because those are all piracy which were happening. The government has taken a lot of initiative, promotion, awareness among the people, and various technological measures for piracy. ಮುಂಚೆಲ್ಲ ನಿಮ್ಮ ಬುಕ್ಗಳನ್ನೆಲ್ಲ ನೀವು ಈಸಿಯಾಗಿ ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ಬೋದಾಯ್ತು. ಫೇಸ್ಬುಕ್ ಗಳಲ್ಲಿ ಈಸಿಯಾಗಿ ನಿಮಗೆ ಮೂವಿಗಳು ಸಿಕ್ಬಿಡ್ತಾ ಇತ್ತು ಪೈರೇಟೆಡ್, ಅಥವಾ ನಿಮ್ಮ ತಮಿಳ್ ರಾಕರ್ಸ್ ಅಂತ ಆಗ್ಲಿ, ಅಥವಾ ಪೈರೇಟ್ ಬೇ ಅಂತ ಆಗ್ಲಿ. ಸೊ ದೀಸ್ ಆರ್ ಆಲ್ ದ ವೇರಿಯಸ್ ವೆಬ್ಸೈಟ್ಸ್ ವಿಚ್ ವರ್ ದೇರ್. ಸೊ ಇವತ್ತು ಬೆಳಗ್ಗೆ ರಿಲೀಸ್ ಆಗಿದ್ದ ಮೂವಿ ಸಂಜೆ ಅಷ್ಟೊತ್ತಿಗಾಗಲೇ ಪೈರೇಟ್ ಬೇ ಅಲ್ಲಿ ಬಂದ್ಬಿಡೋದು. ಸೊ ಅದನ್ನೆಲ್ಲ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದಾರೆ. ವೇರಿಯಸ್ ಇನಿಷಿಯೇಟಿವ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಟೇಕನ್ ಬೈ ಗವರ್ಮೆಂಟ್. ಸೊ ನಾ ದಿಸ್ ಇಸ್ ಫಾರ್ ಯು. ಓಕೆ, ಸೊ ಮೇಡಮ್ ಇನ್ನು ಎಷ್ಟು ನಿಮಿಷ ಟೈಮ್ ಇದೆ ನನಗೆ?
Sir, another 10 more minutes.
So close anta.
If students have again they have any questions, we'll another 10 minutes. So 10 minutes for you and 10 minutes for delegates.
Okay, ಆ ತರನಾ? ಸರಿ. ಸೊ ಫಸ್ಟ್ 10 minutes let me utilize. ಆಯ್ತಾ? Yes. What is there in my slide? ಬೇಗ ಏನೇನಿದೆ ನಮ್ಮ ಸ್ಲೈಡ್ ಅಲ್ಲಿ? ಬೇಗ ಉತ್ತರ ಕೊಡಿ. ನಮ್ ವಿನಯ್ ಕುಮಾರ್ ಅವರು. ವಿನಯ್ ಕುಮಾರ್, ನೀವು ಬರೀ ಮೈಕ್ ಆನ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ ಕಣ್ರಿ. ಚಾಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಆನ್ಸರ್ ಹೇಳಿ. ನಂದಿತಾ, ನೀವು ಆನ್ಸರ್ ಮಾಡಮ್ಮ. ಎಲ್ಲಿ ನಮ್ಮ ಬೇರೆಯವ್ರಿಗೂ ಒಂದಷ್ಟು ಜನ ಯಾರು ಮಾಡೋದೇ ಇಲ್ವಲ್ಲ ರಿಪ್ಲೈ. ರಾಮ್ ಪ್ರಕಾಶ್, What's there in my slide? And you should not repeat the answer which is already told by others. That's the primary point. It's a painting. Then lotus. Then ಬೇಗ ಬೇಗ ಹೇಳ್ರಿ ನೀವು ಸುಮಾರು ಸ್ಲೈಡ್ಸ್ ಇದೆ. Nature, sunrise, etc. Very good. Ilva? What do you find here? ಆಮೇಲೆ ಸ್ಲೈಡ್ ಆಗಲೇ ಹೋಯ್ತು, ಇನ್ನಿವಾಗ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೀವು ಹಳೆ ಸ್ಲೈಡ್ ಬಗ್ಗೆ. ಓಕೆ, dancing fish, etc. Okay, what do you find? Okay, so all these things which you saw, alva, so this is not just a mere painting. This is not mere a happy fish dancing, etc. It's not mere a painting. Rather, it is a creative expression of an author. So what is protected under copyright is the creative expression of an author is protected under the copyright. ಇದೆಲ್ಲಾನು ಒಂದು ಕಾಪಿರೈಟ್ ಪ್ರೊಟೆಕ್ಟೆಡ್ ವರ್ಕ್ಸ್ ಅಂತ ನಾವು ಕರಿತೀವಿ. ಸೊ ರಿಸರ್ವೈರ್ ಡಾಗ್ಸ್ ಅಂತ ಒಂದು ಮೂವಿ ಬಂದಿತ್ತು 1992 ಅಲ್ಲಿ, ಬಾಲಿವುಡ್ ಮೂವಿ. ಏನಿತ್ತು ಇದ್ರ ಮೂವಿಯಲ್ಲಿ ಅಂದ್ರೆ ಈ ಒಂದು 4-5 ಗ್ಯಾಂಗ್ಸ್ಟರ್ಸ್ ಗೋ ಅಂಡ್ ರಾಬ್ ಅ ಬ್ಯಾಂಕ್ ಅಂಡ್ ಹೌ ಡು ದೇ ಎಸ್ಕೇಪ್ ಫ್ರಮ್ ದ ಬ್ಯಾಂಕ್ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಒಂದು ಮೂವಿ ಮಾಡಿದ್ರು. ಈ ಮೂವಿನ ನಮ್ಮ ಬಾಲಿವುಡ್ ಒಂದು ಹಾಲಿವುಡ್, ನಮ್ಮ ಬಾಲಿವುಡ್ ಇಂಡಿಯಾದಲ್ಲಿ ಒಂದು ಕಾಂಟೆ ಅಂತ ಒಂದು ಮೂವಿ ತೆಗೆದ್ರು. ಏನಿತ್ತು ಈ ಕಾಂಟೆ ಮೂವಿಯಲ್ಲಿ? once again ಅಮಿತಾಬ್ ಬಚ್ಚನ್ ಇವರೆಲ್ಲ ನೋಡಿರ್ಬೋದಲ್ಲ ನೀವು. So these stars, once again they go this as a gangsters go and rob a bank, okay, and get escaped out of the bank without getting caught. Now the question is, did or was there a copyright infringement, or was there a copy from Reservoir Dog to Kante? Yes or no? ಬೇಗ yes or no questions ಇವಾಗ ಅಷ್ಟೇ. ಇನ್ನು ಮುಂದಕ್ಕೆಲ್ಲ ಸ್ವಲ್ಪ yes or no questions ಬರುತ್ತೆ, ಬೇಗ ಬೇಗ ಹೇಳಬೇಕು. Yes or no? Rizwan sir, Sona madam, Anusha, ಎಲ್ರಿ ಇವರು ಗೌಡ್ರು, ಭಾಸ್ಕರ್ ಗೌಡ್ರು, ಬಿಂದುಶ್ರೀ, quickly. Yes, very good, very good. Okay, now tell me, here in this slide, do you find anything which is copied? Another copy idea? Yes or no? Mahesh, Vinay Kumar all says yes. Anyone say no? Okay, I don't know. Okay, what about this? Hollywood flick, Inception and Badlapur. Bollywood film. Any copyright infringement? What about this? You know this Portugal music album of 1973 and Amir Khan speaking. A copy, yeah? What about this? The Ravan and the Batman. Anything which is copied? No. Bhaskar Gaudru once for the first time says, no sir, 100% copy. Not 100% copy. Now Bhaskar varies on the percentage. Sir, percentage ನೋಡೋಣ ಸರ್, ಸ್ವಲ್ಪ ಅವರು ನಿಂತಿರೋ ಪೋಸ್ಚರು ಅಥವಾ ಇಟ್ಕೊಂಡಿರೋ ಪೋಸ್ಚರು ಸ್ವಲ್ಪ ಸಿಮಿಲರ್ ಇದೆ ಸರ್ ಅಂತ. ಆಮೇಲೆ no sir, Sona says no posters copied sir, don't watch. ಅಪ್ಪ ನೀನೇನು ಯಾರಿದು HSVS ನೀವೇನು ವಾಚ್ ಮಾಡ್ಬೇಡ್ರಿ, ಇಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳ್ರಿ ಸಾಹೇಬ್ರೆ, ಇದು ನಿಮ್ಗೆ ಕಾಪಿ ಅಂತ ಅನ್ಸುತ್ತಾ ಇಲ್ವಾ ಅಷ್ಟೇ. ಸ್ಫೂರ್ತಿ, ಎಸ್ ಸರ್. Dr. Rizwan did not watch. Sir, you agreed sir, by looking at this slide, do you find anything which is copied? That's all my question is. Yes, ashte. Oh, thank you very much. Next, clear copy with minor changes. Okay, you know the explanation ಕೊಡ್ತಾರೆ ಮಹೇಶ್. Clear copy ante with minor changes ante. ಏನು ಮಾಡ್ತಾರೆ? Sir, I am writing an article, okay, where madam has written one article, I am written one article. Madam has also written on extraction of oil, I am also written on extraction of oil. What I have done, ಅವರು ಆರ್ಟಿಕಲ್ ಎಲ್ಲ ಬರೆದ್ರು, ನಾನು ಎಲ್ಲ ಆರ್ಟಿಕಲ್ ಬರ್ದೆ, ಆದ್ರೆ ಅವರೇ ಕಥೆನ ನಾನೇ ಸ್ವಲ್ಪ ಹಿಂದೆ ಮುಂದೆ ತಿರುಗಿ ಹಾಕ್ಬಿಟ್ಟು ಬರ್ದೆ. ಅದು ಮೈನರ್ ಚೇಂಜಸ್ ಮಾಡಿದೀನಿ ಸರ್, ಹಾಗಾಗಿ ಕಾಪಿರೈಟ್ ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್ ಇಲ್ಲ. ನೋ ಸರ್, ಪೋಸ್ಟರ್ ಕಾಪಿರೈಟ್ ಓನ್ಲಿ ಪೋಸ್ಟರ್ ಆರ್ ಕಾಪಿಡ್. ಓಕೆ, ವಾಟ್ ಅಬೌಟ್ ದಿಸ್? ಮೌಸಮ್ ಅಂಡ್ ದ ಟೈಟಾನಿಕ್. posters are copied. ಅದೇ ರೀ ಕಾಪಿ ಪೋಸ್ಟರ್ಸ್ ಬಗ್ಗೆ ನಿಮ್ಮನ್ನು ಕೇಳ್ತಾ ಇರೋದು ರಕ್ಷಿತಾ. ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಅಬೌಟ್ ದಟ್ ಓನ್ಲಿ. What about this? His and the king author. Aitra as in the graduate. Sona says yes. Anusha says yes. Okay. Rowdy Rathod and the replacement killer. Okay. So all this time, I'll just skip the slide. ಸ್ವಲ್ಪ ಯಾಕಂದ್ರೆ ಮೇಡಮ್ 10 ನಿಮಿಷ ಟೈಮ್ ಕೊಟ್ಟಿರೋದು ಅಂದ್ರೆ ಉಳಿಕೆ 10 ನಿಮಿಷ ಅಂತ. So now the basics of copyright which we talk is copyright protects creativity of an author. Copyright is granted for a work. What is protected in copyright is the expression and not the idea. ಏನದು expression and not the idea? Idea of ಬ್ಯಾಟ್ಮ್ಯಾನ್ ಅಲ್ಲಿ ಹಿಂಗೆ ಒಬ್ಬ ಇದನ್ನ ಎತ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರ್ತಾರಲ್ಲ, that is an idea. So you took that idea but you expressed in a different, you expressed in another form. So the expression is not copied, hence there is no copyright infringement ಅಂತ ಹೇಳ್ತಾರೆ. But it depends upon case to case basis. Okay, ಇದು ನಮಗೆ ಸಾರಿ ಕೇಸ್ ಎಲ್ಲ ಹೇಳೋದಕ್ಕೆ ನಮಗೆ ಈ ಸತಿ this is just an introduction. Sorry, battery not run down ಆಗ್ತಾ ಇದೆ. Yeah. So these are all the various copyright, how we said. So copyright is product except now for research work, there is one exception under the copyright. That is, it gives you, for the sake of research, you need not take a written permission of an author, but if you merely cite him, then it is not a amount to an infringement. If you are using for education purpose, for example, ನಮ್ಮ ಟೀಚರ್ಗಳೆಲ್ಲ ನಿಮಗೆ ಒಂದು ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಮೆಟೀರಿಯಲ್ ಅಂತ ಹೇಳಿ ಅಥವಾ ನಿಮಗೆ ಇಮೇಲ್ಗಳಲ್ಲಿ ಒಂದಷ್ಟು ಕಾಪಿರೈಟ್ ಆರ್ಟಿಕಲ್ಸ್ಗಳನ್ನ ನಿಮ್ಗೆಲ್ಲ ಶೇರ್ ಮಾಡ್ತಾರೆ. So now your madam is making copies of the said article to all 60 students. So will it become an infringement? No. They say because it is for limited circulation, it is for the educational purpose, hence it is copyright. It's not a copyright infringement. Okay, na? So I think I have used my 10 minutes and so these are the few. See, I did not want to simply dump information to you people. I just wanted to know that at least few points you are going to understand and apply it in your practical aspect. Okay, na? I have just told only one from the 5% ಹೇಳಿದ್ದೇನೆ ಅಷ್ಟೇ copyright ಮೇಲೆ, entire ಹೇಳಕ್ಕಾಗಿಲ್ಲ. So we will come back. This is only an initial sessions ನಾವು ಮಾಡಿರೋದು. So we will come back. We will take you people on an in-depth in the coming days. So I hope you all take better advantage. Next time the madam ಹೇಳ್ತೀನಿ ಆ ಪೇಟೆಂಟ್ ರಿವ್ಯೂ ಬಗ್ಗೆ, ಲಿಟ್ರೇಚರ್ ರಿವ್ಯೂ ಬಗ್ಗೆ, ಅಥವಾ ಪೇಟೆಂಟ್ ಲಿಟ್ರೇಚರ್ ರಿವ್ಯೂ ಬಗ್ಗೆ, ಪೇಟೆಂಟ್ ಡ್ರಾಫ್ಟಿಂಗ್ ಬಗ್ಗೆ, ಹೆಂಗ್ ಪೇಟೆಂಟ್ ಡ್ರಾಫ್ಟ್ ಮಾಡಬೇಕು, ಹೆಂಗ್ ಪೇಟೆಂಟ್ ಸರ್ಚ್ ಮಾಡಬೇಕು, ಅಥವಾ ಯಾವ್ದು ಹೆಂಗೆ ನಾವು ಇವೆಲ್ಲ ಸ್ಟೂಡೆಂಟ್ ಪ್ರಾಜೆಕ್ಟ್ಸ್ ನ ಚೂಸ್ ಮಾಡಕ್ ಮುಂಚೆ ಬರೀ ಲಿಟ್ರೇಚರ್ ರಿವ್ಯೂ ಅಷ್ಟೇ ಅಲ್ಲ, ಪೇಟೆಂಟ್ ಲಿಟ್ರೇಚರ್ ರಿವ್ಯೂ ಸಹ ಮಾಡಬೇಕು. ಓಕೆನಾ? ಸೊ ದಿಸ್ ಆರ್ ದ ಥಿಂಗ್ಸ್ ಸೇ ಅಂಡ್ ನೀವೆಲ್ಲ ಮಾಡಿ. So we at Karnataka State Council for Science and Technology are here to support you. And one quickly ನಾನು ಏನ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ನಮ್ಮ ಒಂದೇ ಇದೊಂದು ಸ್ಲೈಡ್ ತೋರಿಸ್ತೀನಿ ನೋಡಿ, ಉಪಯೋಗ ಆಗುತ್ತೆ. Yes, I hope this will be you all people kindly take the screenshot or save my email ID or mobile number. You may have cover assistance the numbers and email ID. We are there to support you. And ನಮ್ದು ಆಫೀಸು ಇಲ್ಲೇ ನಿಮ್ಮ ಕಾಲೇಜ್ ಹತ್ರನೇ ಇರೋದು. ಯಾವುದು ನಮ್ಮ ಇಂಡಿಯನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಸೈನ್ಸ್ ಅಲ್ಲಿ ಸರ್ಕಲ್ ಮಾರಮ್ಮ ಟೆಂಪಲ್ ಹಿಂಭಾಗದಲ್ಲೇ ಬರುತ್ತೆ. ಸೊ ಇಫ್ ಎನಿವನ್ ವಾಂಟ್ಸ್ ಎನಿ ಅಸಿಸ್ಟೆನ್ಸ್ ಆನ್ ಇಂಟೆಲೆಕ್ಚುಯಲ್ ಪ್ರಾಪರ್ಟಿ ರೈಟ್ಸ್, ಆನ್ ಪೇಟೆಂಟ್ಸ್, ಟ್ರೇಡ್ಮಾರ್ಕ್, ಕಾಪಿರೈಟ್ ಡಿಸೈನ್ಸ್, we are there to support and we will take it up. Okay, thank you very much madam. I think we have been successfully conducted all the 4 sessions and I am really very happy that okay, voice slow ಬರ್ತಾ ಇರಬೇಕು ಮೋಸ್ಟ್ಲಿ ಇಂಟರ್ನೆಟ್.
Your voice is breaking.
Okay, yes, ಅದೇ ನೆಟ್ವರ್ಕ್ ಇಶ್ಯೂ ಇದೆ. So thank you very much. Madam Pratibha Madam for providing me an opportunity. I would like to thank the principal, the KLE society, the organizer, ಮತ್ತೆ all my dear students who have or my friends who have actively participated. And thank you very much. Over to you, madam.
Thank you, sir. Over to you, Trupti. Sir, with your permission, any queries can be taken?
Yeah, yeah,
Last four
Tony.
delegates, if you have any kind of queries or if you have any kind of doubts, you can discuss with sir. Or if you have any kind of doubts, you can discuss with sir. There is a question from Sona, sir. Sir, if we contents are same but the format is different, is this copyright infringement?
One second, I am not.
Yes, sir. You
One
are
second. I'm not able to see the question. Can you repeat, madam?
Yes, sir. This is from Sona. Sir, if contents are same but the format is different, is this copyright infringement?
Very good. Look like substantial copy. Did you know you have changed, but substantial portion of someone? Yes, copy. Okay, or when you ನೋಡಿ ಅದನ್ನ ರೀ ಇದು ಯಾಕೋ ನಮ್ಮ ಶೋಲೆ ಮೂವಿಯಲ್ಲಿ ಇದ್ದಂಗ ಅನ್ಸುತ್ತಲ್ವಾ ಅಂತ ಯು ಗೆಟ್ ದ ಲುಕ್ ಲೈಕ್
Hello. Hello.
Yes, sir. You are audible, sir. Now.
Sorry, there was an internet issue. So as I said that, is it the content? Is it look-alike, or whether it is? What you said? Have you taken a substantial portion? If yes, then it amounts to an infringement. If no, then it does not amount to an infringement. Atara, it is depends upon case to case basis. Okay, na? Yes. Next. Any other questions, please? ಮೇಡಮ್ ಏನೋ ಕ್ವಶನ್ಸ್ ಚಾಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ನನಗೆ ಓದಿ ಹೇಳಿ ಮೇಡಮ್.
Yes, sir. So, yeah. So this is from Dhanush. Sir, what's the news with patent where that's going on with government regarding vaccine?
Very good. Wait. Yes, that's really a very good question. One ನಿಮಿಷ. Yeah, sorry. That's really a very good question. ನಮ್ಮ ಧನುಷ್ ಅದು ಆಕ್ಚುಲಿ ನಮ್ಮ ಭಾಸ್ಕರ್ ಗೌಡ್ರು ಕೇಳ್ತಾರೆ ಅನ್ಕೊಂಡಿದ್ದೆ ಈ ಕ್ವಶನ್. No problem. As you rightly pointed out, the vaccines which have come out today have patent protection over it. Once it has a patent protection ಅಂದ್ರೆ ಏನು, ಯಾರು ಕಾಪಿ ಮಾಡಂಗಿಲ್ಲ. No one else can. It's an exclusive right. ಅವಲೇ ಸುಮಾರು ಜನ ಹೇಳಿದ್ರಲ್ಲ, it is an exclusive right granted to an inventor. So now it is his invention. But now what happens? Now people are dying if they are not getting. See, this becomes very crucial. Patent becomes very crucial in the case of medicines. In case of a technology for a car, aeroplane, it doesn't matter. But if a technology, if a medicine, if you have come out with a vaccination and that's a life and death issue, then it is very, very much required for the people. So in such circumstance, if someone have a patent over it, the government said, hey, come on, however you have taken a patent, that means monopoly is given to you. But the problem is, if you keep monopoly, what happens? You can price your product at whatever price you want. But the government said, ಓಕೆ ನಾವು ಪೇಟೆಂಟ್ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಆದ್ರೆ ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಜನಗಳಿಗೆ ಬೇಕಾಗಿದೆ, ಇಲ್ಲಾಂದ್ರೆ ಸತ್ತೋಗ್ಬಿಡ್ತಾರೆ ಜನಗಳು, ವ್ಯಾಕ್ಸಿನೇಷನ್ ಸಿಕ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ. ಹಾಗಾಗಿ ಯು ಹ್ಯಾವ್ ಟು ಲೀವ್ ದ ಪೇಟೆಂಟ್ ರೈಟ್ಸ್ ಆರ್ ವೇವ್ ಆಫ್. ನಮ್ಮ US ಅವರು ಅಥವಾ UN ಅಲ್ಲೆಲ್ಲ ಡಿಸ್ಕಷನ್ ಆಗ್ತಾ ಇದೆ ಏನಂತ, ಪೇಟೆಂಟ್ಸ್ ಯಾವುದು ವೆಂಟಿಲೇಟರ್ಸ್ ಗಳ ಮೇಲೆ, ವ್ಯಾಕ್ಸಿನೇಷನ್ ಮೇಲೆ, ಅಥವಾ ಬೇರೆ ಬೇರೆ ಎಕ್ವಿಪ್ಮೆಂಟ್ಸ್ ಗಳ ಮೇಲೆ, ಕೋವಿಡ್ ರಿಲೇಟೆಡ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಏನೇನ್ ಪೇಟೆಂಟ್ಸ್ ಇದೆಯಲ್ಲ ಅದೆಲ್ಲದನ್ನು ಯಾರು ಸಹ ಎನ್ಫೋರ್ಸ್ ಮಾಡಬಾರ್ದು. ಯಾಕಂದ್ರೆ ಇವಾಗ ಫಾರ್ಮುಲೇಷನ್ ಏನು ಅಂತ ಗೊತ್ತಿರುತ್ತೆ. ಸೊ ಹಾಗಂತೇಳಿ ನಾನು ಎಲ್ಲ ಮಾಡ್ಬೋದಲ್ಲ. ಯಾಕೆ ನಾವು ಭಾರತ್ ಬಯೋಟೆಕ್ ಅವರು ಅಥವಾ ಬೇರೆ US ಇಂದ ನಾವು ರೆಡ್ಡಿ ಆಗ್ಲಿ ಇನ್ನೊಬ್ರಾಗ್ಲಿ ಲೈಸೆನ್ಸ್ ತಗೊಳ್ಬೇಕು? ಬಿಕಾಸ್ ಪೇಟೆಂಟ್ ಆಗಿರುತ್ತೆ. ಯಾರಂದ್ರೆ ಅವರು ಈಸಿಯಾಗಿ ಉಪಯೋಗಿಸಕ್ ಆಗಲ್ಲ. ಅವರು ಅವರ ಆಥರ್ಸ್ ಹತ್ರ, ಇನ್ವೆಂಟರ್ ಹತ್ರ ಪರ್ಮಿಷನ್ ತಗೊಂಡೆ ಉಪಯೋಗಿಸಬೇಕು. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅವ್ರು ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್ ಸೂಟ್ ಆಗ್ತಾರೆ, ಹ್ಯೂಜ್ ಅಮೌಂಟ್ ಆಫ್ ಡ್ಯಾಮೇಜ್ ಆಗ್ತಾರೆ. ಯು ಮಸ್ಟ್ ಹ್ಯಾವ್ ಆಲ್ ರಿಮೆಂಬರ್ಡ್ ಅಬೌಟ್ ಆಪಲ್ ವರ್ಸಸ್ ಸ್ಯಾಮ್ಸಂಗ್ ಕೇಸ್. US ಅಲ್ಲಿ ಅವರು ಫೈಲ್ ಮಾಡೋದು ಏನಂತ, ನಮ್ ಡಿಸೈನ್ ಕದ್ದಿದ್ದಾರೆ ಸರ್ ಅಂತ. ಅದಕ್ಕೆ ಹ್ಯೂಜ್ ಅಮೌಂಟ್ ಆಫ್ ಡ್ಯಾಮೇಜಸ್ ನ ಕೋರ್ಟ್ ಅವಾರ್ಡ್ ಮಾಡ್ತು. ಇನ್ ದ ಸೇಮ್ ವೇ ಇಲ್ಲೂ ಮಾಡ್ತಾರೆ. ಹಾಗಾಗಿ ವಿ ಶುಡ್ ಬಿ ವೆರಿ ಕೇರ್ಫುಲ್. ಅಂಡ್ ನೌ ದ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟೇಕನ್ ಅ ವೆರಿ ಗುಡ್ ನೆಗೋಸಿಯೇಷನ್ ಆಗ್ತಾ ಇದೆ. ವ್ಯಾಕ್ಸಿನೇಷನ್ ಮೇಲೆ ಪೇಟೆಂಟ್ ನ ಎನ್ಫೋರ್ಸ್ ಮಾಡಬೇಡಿ ಅಂತ US ಲೆವೆಲ್ ಅಲ್ಲಿ, ಅಂದ್ರೆ ಯುನೈಟೆಡ್ ನೇಷನ್ ಲೆವೆಲ್ ಅಲ್ಲೆಲ್ಲ ಆಗ್ತಾ ಇದೆ. ಅಂದ್ರೆ ನೀವು ಅಂದ್ರೆ ಇದು ಸತ್ಯನೋ ಸುಳ್ಳೋ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ದ ಅಸಂಪ್ಷನ್ ಇಸ್ ದ ಚೈನಾ ಅಂಡ್ US ಜಾಯಿಂಟ್ಲಿ ಕೇಮ್ ಅಪ್ ವಿತ್ ದಿಸ್ ವೈರಸ್. ಅದನ್ನ ಮಾರ್ಕೆಟ್ ಗೆ ಎಲ್ಲಾ ಕಡೆ ಬಿಟ್ಬಿಟ್ರು, ಜನಗಳೆಲ್ಲ ಅದನ್ನ ಸಫರ್ ಮಾಡಿದ್ರು. ಇವಾಗ ಸಫರ್ ಮಾಡೋದಕ್ಕೆ ಮೆಡಿಸನ್ ಅವ್ರ ಹತ್ರನೇ ಇತ್ತು, ವೈರಸ್ ನ ಬಿಟ್ರು, ಮೆಡಿಸನ್ ನ ಬಿಟ್ರು, ಮೆಡಿಸನ್ ಗೆ ಪೇಟೆಂಟ್ ತಗೊಂಡ್ರು. ಯಾರು ಸಹ ಅದನ್ನ ಸುಮ್ನೆ ಕಾಪಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವಾಗ ವಾಪಸ್ ನಾನು ನಿಮ್ಮ ಹತ್ರಕ್ಕೆ ಬರ್ತೀನಿ ಏನು ಆ ಮೆಡಿಸನ್ ತಗೊಳೋದಕ್ಕೆ ಅಂತ ಹೇಳಿ, ದಿಸ್ ಆರ್ ದ ವೇರಿಯಸ್ ಸ್ಟ್ರಾಟಜೀಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಿಕಾಸ್ ದಟ್ ಇಸ್ ನಾಟ್ ಏನು ಪ್ರೂವ್ಡ್ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. ಬಟ್ ನೀವು ಇದೆಲ್ಲ ಸಿನಿಮಾದಲ್ಲಿ ನೋಡಿರ್ಬೋದು. ಯಾವ್ದೋ ಒಂದು ನಮ್ಮ ತಮಿಳ್ ಒಂದು ಯಾವ್ದೋ ಒಂದು ಮೂವಿಯಲ್ಲಿ ಚೈನಾದವ್ರು ಬಂದು ಏನೋ ಒಂದು ವೈರಸ್ ಬಿಟ್ಬಿಡ್ತಾರೆ, ಆಮೇಲೆ ಮತ್ತೆ ಅದಕ್ಕೊಂದು ಹ್ಯೂಜ್ ಮಾರ್ಕೆಟ್ ಸಿಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಒಂದು ಬ್ಲಾಕ್ ಮಾಡ್ತಾನೆ. ಸೊ ದೀಸ್ ಆರ್ ಆಲ್ ದ ವೇರಿಯಸ್ ಥಿಂಗ್ಸ್ ವಿಚ್ ಆರ್ ದೇರ್ ಇನ್ ದ ಸಿಚುವೇಶನ್, ಆರ್ ರಿಯಲಿಸ್ಟಿಕಲಿ ಆರ್ ಅನ್ರಿಯಲಿಸ್ಟಿಕಲಿ. ಸೊ ದಟ್ ವಿ ಕ್ಯಾನ್ ಕೋರಿಲೇಟ್ ಸಮ್ಟೈಮ್ಸ್. ಬಟ್ ಅಟ್ ಟೈಮ್ಸ್ ವಿ ಫಿಯರ್, ಆತರ ಇತ್ತು ಅಂದ್ರೆ ಪೇಟೆಂಟ್ ಏನ್ ಮಾಡೋದು ಸರ್, ನಮ್ಮ ಜೀವ ತಿನ್ಬಿಡುತ್ತಲ್ಲ ಅಂತ. So those are all the topics which are going on. Really, I appreciate Mr. Dhanush that he has applied his mind. See, namma whole discussion irade, you should apply your mind in the subject matter. If you have done, then I'm successful in conducting my session. Okay? Yes. Madam, innenadru idea question?
Thank you, sir. That was great. We have received a lot of appreciation for your this particular special technical session, and this will be the last question, sir, with your permission. There is a question from Ranjita. What are the limitations to copyright? Student, this will be the last question. Sir has shared already his email ID. Rest you can approach through sir email ID. Thank you. So over to you, sir.
Madam, ಏನದು limitation to copyright? ಹಂಗಂದ್ರೆ ಏನು? What is the limitation for copyright?
To copyright. This question is from Ranjita. Ranjita, you can unmute yourself and interact.
Yeah, better. Ranjita, what do you mean by limitation for copyright? ಲಿಮಿಟೇಷನ್ ಟು ಕಾಪಿರೈಟ್ ಅಂತಂದ್ರೆ, ಲಿಮಿಟೇಷನ್ ಟು ಕಾಪಿರೈಟ್ ಅಂತ ಯಾವ ತರ ಯು ಆರ್ ಆಸ್ಕಿಂಗ್? ಕ್ಯಾನ್ ಯು ಲಿಟಲ್ ಮೋರ್ ಎಕ್ಸ್ಪ್ಲೇನ್ ಆನ್ ದ ಕ್ವಶನ್? ಬಿಕಾಸ್ ನನಗೂ ಏನೇನೋ ಅರ್ಥ ಆಗಲ್ಲ. ಹೀಗೆ ಯಾ ರಂಜಿತಾ ಅವರೇ ಹೇಳಿ.
Ranjita, you can unmute yourself and you can talk. I have requested to unmute.
ಓಕೆ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ, ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ನಿಮ್ಗೆ ಏನಾದ್ರು ಗೊತ್ತಾಯ್ತಾ ಮೇಡಮ್? Do you know what is the limitation for copyright and what does she mean to say?
Sir, she has to here mention the which particular product she is talking about the copyright. Based on that, think about the limitations.
ಲಿಮಿಟೇಷನ್ಸ್ ಆ ತರ. ಅಚ್ಚಾ, ಓಕೆ. ದೆನ್ ಬೇರೆ ಯಾರಿಗಾದ್ರು ನಮ್ಮ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಯಾರಾದ್ರೂ ಉತ್ತರ ಹೇಳ್ಬೋದಾ? ವಾಟ್ ಇಸ್ ದ ಲಿಮಿಟೇಷನ್ ಫಾರ್ ಅ ಕಾಪಿರೈಟ್ ಅನ್ನೋ ಕ್ವಶನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅಥವಾ ಕ್ವಶನ್ ಬೇಕಾದ್ರೆ ರಿಫ್ರೆಶ್ ಮಾಡ್ಕೋಬಹುದು ಅಥವಾ ಆನ್ಸರ್ ಬೇಕಾದ್ರೆ ರಿಫ್ರೆಶ್ ಮಾಡ್ಕೋಬಹುದು. ಎಸ್, ಎನಿವನ್? ಮೇಡಮ್ ಏನೋ ರೆಸ್ಪಾನ್ಸ್ ಇದೆಯಾ?
No, sir. After that, no response. Dhanush has mentioned. Thank you, sir.
Okay, no problem. What I request is, so however, ನೀವು ಹೇಳಿದ ಕ್ವಶನ್ ನನಗೆ ಎಕ್ಸಾಕ್ಟ್ ಆಗಿ ಯಾವ ಪರ್ಪಸ್ ಗೆ ಹೇಳ್ತಾ ಇರೋ ಅಂತ ನನಗೆ
She would have mentioned over there particularly about which particular product she is talking.
Yes, no problem. What you can do, madam, if that question will still open, keep it open, you can directly write me an email. What is the question which you are asking for? I will respond to you. Okay?
Definitely, sir.
Yes.
All these inputs, whatever I got chat box now, I'll send to you, sir.
No problem, madam. Yes, thank you
sir.
very
That
much.
was really a great interaction with you, and thank you for spending your time with us, sir. Over to Srimati Trupti.
Yes.
Thank you, ma'am. Thank you, sir, for the interactive talk on copyrights protection. Now, with this, we now conclude today's technical session. We hope this IQAC initiated 2 days virtual workshop on intellectual property rights and biotechnology affected our young and energetic minds to take initiation and build their career in these paths. Last, but not the least, I would like to thank everyone. On behalf of Head and Faculty, Department of I would like to thank everyone for allocating their valuable time for 2 days virtual workshop on intellectual property rights and biotechnology. Thank you all. I request everyone to kindly fill feedback form. The link is provided in the chat box. Have a good day.
Thank you, Vivek, sir, for joining us. Thank you so much. And thank you for your support, sir, on behalf of KLE SNC.